I keep losing mine. Here, tell you how. Okay. Good morning, everyone. Thank you for joining the New York State Senate Standing Committee on Judiciary and the Committee on Children and Families today for our joint public hearing to conduct oversight of family court throughout New York State, including the resources, operations, and outcomes. I'm pleased to be joined by a number of colleagues, including the chair of the Children and Families Committee, Jabari Brisport, who you will hear from in a moment, as well as Senators Mayer, Lieu, Palumbo, Ramos, and others who I think will be joining us momentarily. Thank you to the witnesses who we'll also hear from shortly. And we are tremendously honored to be joined by New York State Chief Judge Rowan Wilson, who I'm very happy to say has made family court reform a priority as he promised during his confirmation hearings. Welcome, Chief Judge. Nearly a fifth of all New York State filings in 2022 were in family court. These courts decide some of the most serious issues in a child's life, adjudicating custody disputes, assessing if a child's safety or well-being are threatened, and deciding whether parents may even see their children. Too many litigants still appear unrepresented, experience unacceptable delays, and are subject to unfathomable and traumatic separations. Many of us will recall recent reporting by media, including NBC New York, which has highlighted some of the parents affected by the failures of our family courts. We saw profiles of a woman named Marcia Miles, a parent looking to adopt 4-year-old Cameron Porter of Queens, whose adoption was approved by the court in March of 2021, but was not officially finalized until the summer of 2022, an unacceptable over 15-month delay while her adopted daughter languished in foster care. Testimony from Lawyers for Children highlights more examples. One of their clients, referred to as L, was removed from his parents' care when he was just 6 months old due to unexplained fractures on his arm and leg. The abuse trial did not begin until 3 years later and was drawn out over 14 court dates that spanned a full 12 months. On many of those dates, the judge was able to devote only an hour to hearing testimony because of the competing demands on her calendar. Although the court ultimately found that L's father was not responsible for his injury, by the time the finding was made, L had been in foster care for over 4 years. Unfortunately, as many reports have demonstrated, this delay is not unusual for litigants in family court. To add insult to injury, too, many parents also face harassment or prejudicial treatment at the hands of family court judges or employees. When the Williams Commission issued its report on racial equality in our court system in 2022, focusing on family court, it cited repeated complaints about, quote, dehumanizing behavior by court personnel. No level of case backlogs justifies a judge shouting at litigants, referring to them as the, quote, the mom or the dad, or retaliating against parents for exercising their right to due process. The task before us is certainly daunting, but we owe it to the families of New York to fix our broken system of family justice. And certainly we have enough reports ranging from Secretary Johnson's report on equal justice, to the city bar's report on COVID in the family courts, to, of course, the report by the Franklin H. Williams Commission on Judicial, on the report on the New York City family courts. So we have a roadmap of what to do. We now need to exercise the political will to do it. So I'm going to hand it over to my colleague, Senator Brisport, for his opening comments.
Thank you, Mr. Chair. Well, good morning, everyone, and welcome to the Senate's joint hearing between the Judiciary Committee and the Children and Families Committee in our great state of New York. Again, I'm the chair of the Children and Families Committee, State Senator Jabari Brisport, and I want to extend a thank you to all my colleagues here who were previously mentioned. I would also like to extend thank you to the New York State Senate for hosting this hearing, especially Majority Leader Andrea Stewart-Cousins. And most of all, I would like to thank our witnesses for being here today to share your expertise on this important issue. I want to start by taking a moment to acknowledge the gravity of what we're here to discuss. There is perhaps no structure more central to the human experience, nor more vital to our health and well-being than the family. Thriving families help teach us love, empathy, duty, compassion, trust, kindness, grit, and courage. They are a support system for life's ordinary challenges, and they are a first line of defense against its unexpected hardships. Every child deserves a safe, loving family, and ensuring that their families can thrive must be the highest priority for New York State. Family court, at its best, can be a way to ensure every child gets that. At its worst, it can be a destructive force against New York's most vulnerable families. It is not a secret to anyone in this room that family court is, by and large, a court that impacts the poor and marginalized populations of the state. The class and race dimensions at play here are obvious to anyone who walks to family court. This is the court system where loving families are frequently called in for what are effectively symptoms of poverty and charged with neglect. When court appearances are required, parents already struggling to make ends meet must find ways to take off work, to find childcare, and manage the disruption to their lives and the lives of their children. Making the situation even worse for low-income families, New York State has failed to live up to its obligation to guarantee the right to legal counsel. Unlike most other courts throughout the state, those who come to family court are primarily unrepresented by legal counsel. And when legal counsel is provided, it's often underpaid and overworked. The most devastating outcomes from this system impact groups of people who don't have the money and power to publicize the problems they're facing. To separate a family is to rip apart something sacred, that which was meant to protect not only our physical well-being, but also our social and emotional well-being. To lose a parent, a child, a sibling is a deep and terrible thing. As we consider how best to keep families safe and well, we must keep that truth in the room with us. We must acknowledge that a big part of the problem here is the New York State budget, where New York State has utterly failed our families. Too many judges are overwhelmed and are effectively cast into the role of social workers. When the additional burden is placed on judges who don't have the time or resources to fill that role, terrible mistakes are made with terrible consequences. When families experiencing poverty are met with court summons instead of supports, it is the children who suffer most. That suffering is not inevitable, it is the predictable result of the state's choice to underfund social services. We must also acknowledge that the legal rights designed to protect families in these cases do not, in practice, protect all families equally. To change that, the legislature and the executive need to ensure that families know their legal rights from the first point of contact and that adequate legal counsel is ensured in the state budget. For cases of poverty, we need to be diverting families away from family court and CPS and instead towards the supports that they need. Tackling child poverty itself is the biggest factor that we need to address. More broadly, we need to collaborate with all stakeholders here, discuss how our family court cases are tried, what the standard of proof is for various types of cases, and how we might want to change it in order to keep our children safe. We also discussed today the tragic and difficult cases that our family court system addresses every day, surrounding child custody and domestic violence cases. Some of our legal standards might need to be updated to address issues of class bias that favors wealthier parents, and of gender biases, and of other biases that favor abusive and manipulative persons. There are many experts here who will help us talk through the issues of how best to protect vulnerable children, vulnerable parents, and families in crisis. We've structured this hearing so that we will hear from impacted parents first. They have some compelling stories, and they are experts who have been forced to navigate a difficult system. They are well equipped to tell us about the problems happening in our family court. We will also hear from court personnel, judges, and various parties that have been trying to raise the alarm on this issue for a long time. As we hear testimony, it's also important that we not confuse structural issues with personal issues. There are a lot of hardworking and devoted people who are doing their best within a difficult system. In particular, I'm grateful to the witnesses at the Office of Court Administration who are here today to work with us to try to fix the problems. We won't, however, be hearing from ACS or OCFS. They were both invited about a month ago, but both declined to show up and testify today. That's a shame because issues within ACS and OCFS are a big part of the problem here, and it will be much more challenging to reach solutions without their participation. Thank you.
Thank you, Senator Brisport. We'll now hear for opening remarks from Senator Palumbo, Ranking Member of the Judiciary Committee.
Thank you, Chairman. Just to be brief, we do have a very packed schedule today. We do want to hear from you folks, and it's just an honor to be here. This is such an important issue to see Chief Judge Wilson here taking time out of his extremely busy schedule, as we were discussing offline. He's drinking from a fire hose as Chief Judge of a very large state like New York, but it's great to see him here as well because this is such an important issue. And Chairman Hoylman-Siegel and Senator Brisport, you've outlined these issues. It's not an easy answer. Such a dynamic, and it comes down to volume. The safety of children, obviously, is one of the most critical issues you can have in life, and that's something that we all are focused on. It transcends, I think, all parties, races, any category you can think about. Safety of children should be priority number one. And so the volume is a big issue. And I think as a legislature, we need to think about really putting some money into the issues that we see in the family court because it's volume. With the implementation of Raise the Age, we now have even more cases going to family court. So these judges have their hands full. There are obviously anecdotal and outlying issues with some judges who misbehave and act inappropriately, but generally speaking, their hearts are in the right place. And we need to figure out a way to give them the vehicle to make this world a better place and to protect children. There's no special formula. In the best interest of a child is kind of a vanilla standard. So there's a lot of common sense involved in this as well. So I really look forward to hearing from our witnesses today. And Chairman, thank you for allowing me to make a few comments. And I appreciate all of you being here.
Thank you, Senator. We'll now proceed with the hearing. Some ground rules. Witnesses will have 5 minutes to speak unless otherwise noted by the chairs. I wanted to thank my colleague Sam Vasquez, who's our official timekeeper today, as well as a lot of other things, and my team and Senator Brisport's team for organizing today's hearing. Senators will have 3 minutes to ask questions with additional rounds of questioning at the discretion of the chairs. Witnesses should note that we will have staff at the dais who will be keeping track of time and keeping us on schedule. As you know, we have many witnesses providing testimony today, so we all urge our colleagues and our guests to be judicious with their time, which would be appropriate for this hearing. Let's begin with the first panel. Welcome. I will call your name, and then you will begin your testimony. And as Senator Brisport noted, our first panel is primarily made up of advocates and impacted parents, a voice that is often not heard, which is why we want to hear you first. So if you could state your name, but I will introduce you for each witness. Ms. Ingram?
Good morning, everyone. My name is Aaliyah Ingram. Thank you again for the opportunity to give my testimony today. Okay, so I am a parent who has been impacted by the child welfare system, or what I choose to call the family policing system. I'm also an advocate and a graduate of JMAC for Families HEAL Fellowship. Thank you for the opportunity again to testify today. If you believe that the so-called child welfare system is truly about children, you might imagine family court to be a good thing. However, if you listen to the voices in your community of the people you are serving, you will know that family court doesn't solve problems for our families, it only creates new ones. I was first exposed to the violence of family policing through mandated reporting. After my daughter missed too many days of school, her charter school called in a report to ACS. At the time, I was experiencing difficulties at work, and the commute to school became a challenge. I shared this with the school to help them understand my situation. The principal heard me out, but she said she could lose her license for failing to report the absences to ACS. Mandated reporting makes professionals afraid to slow down for long enough to consider what is actually in the best interest of the family. Instead of asking how she could support me in making sure my daughter could attend school, she reported me. When ACS showed up at my door, I wasn't afraid. No one in my life had experienced this system, so my understanding was that you had to be really putting your kids in danger for them to show up the way they did. But I was wrong. It has been years, since July of 2017 to be exact, that ACS separated my family and I. At the beginning, I thought the family court would be the place where my family would be protected. However, it didn't take long for me to realize that family court is not about family, it's about control. When I walk into family court, I am aware that I will not be treated as a human being. I am aware that this system was founded on the villainization of moms and dads, especially black moms and dads. There is a lot of talk about diversity efforts in the courts, but I will tell you that my judge was a black woman and it didn't change a thing. There is a lot of talk about racial bias training in the courts, but I will also tell you that these issues are far beyond what can be fixed in a 2-hour training. The issue is that our humanity is not recognized by the court system. If we are going to talk about diversity in the courts, it can't just be based on race. It has to be based on professional experience. We need public defenders as judges. We need people who have dedicated their careers to defending families to be on the bench. We need people who have proved their commitment to keeping families together to be working in the courts. At the end of the day, I hope that the focus of this hearing is how we can shrink the system altogether. There should not be so many families going through this terror. There's too many false alarms. There are too many families who simply need childcare and stable housing, but instead are sent to family court. It is a waste of our resources, and it is preventing us from solving the true root causes of system involvement. If we reduce the size of the system and send the money directly to families, I can promise you that our families will be safer. One of the most effective ways to reduce the size of the system is by eliminating the mandate to report. Not only will this protect families from the trauma of the family court system, but it will allow us to take the money saved by eliminating unnecessary reports to give service providers what they need to truly support families. Thank you. Thank you.
Justice. Thank you. Next, we'll hear from Heather Imperial. Okay. Next, we'll hear from Alexis Warnick.
Hi, thank you for the opportunity to testify today. My name is Alexis Warnick, and I'm a graduate of JMAC for Families Hair Program. I have been impacted by the family court system as a child in foster system and now as a parent of 2. People justify the way the family court system treats parents because they think they do it to protect kids, but they don't do that either. I know that because I was a foster kid myself, and the system didn't help me. I signed myself out. As a parent, I have now survived 3 years of the family court involvement due to CPS cases. Family court set up for you to fail. When I first went into the courtroom, my judge would cut me off every time I spoke. She would even cut my lawyers off. Yet CPS could say whatever they wanted. Family court should be about the family, but the family never gets a say, and families are ripped apart because of it. Family court is broken and Family court is a broken system. Many people will say that we need to hire more judges, give judges racial bias training, or hire more black judges to fix it. But we could hire all the black judges in the world. Wouldn't change the system if the structure is fundamentally broken and any new judge would just fit right in with the rest of them. I have 5 real recommendations to share for the family court to make everyone safer. Family recommendation that instead of spending more money on family court judges, we should just stop filing cases that don't need to be filed. So many cases, including mine, are not emergencies. When families do not have a place to stay, that is a family problem, not a court problem. You could find family a place to stay. Taking the family to court is a huge waste of everyone's time and money. And for families who have to go through the system, they need a legal defense team. My attorney was the only person who shared information and resources with me. My legal defense unit has helped me keep my sanity. It's not just my attorney, but my social workers, my parent advocates too. My parent advocates came with me to every meeting and has been with me through everything. So my second recommendation is for New York to fund family defense, and that must include holistic defense models with attorneys, social workers, and parent advocates. Another problem is that even if there are attorneys available, most families don't know they have the right to an attorney. My third recommendation is to make sure that families know they have a right to an attorney in the first place, which could be done through the Family Miranda Right Act. I know how important it is to speak to an attorney during the family court case, but I didn't know this when CPS first came to my door. No one told me that I had the right to an attorney. When CPS comes to your door, it feels like they're speaking another language. You could be a doctor or a professor and still would need an attorney to understand what is happening. Investigations are designed to confuse you. My fourth recommendation is to pass the focus of the family reunification, not separation and adoption. The court focuses a lot on adoption because they say permanency is important to children. But what about families being together? When people are adopted, they go through so much headaches as an adult. People turn 40 without a birth certificate. They don't have the right to their own stuff or their own history. My last recommendation is for New York to focus on the holding CPS accountable too. We need to be asking CPS, what is your success rate? How many children in the foster system graduated from high school? How many children in the foster care system get a job and a career? How many are going through just not emotional trauma? I guarantee you that if you ask these questions, you will shut the whole system down.
Thank you. Next, we'll hear from Ms. Jimenez.
Good morning. My name is Saimalena Jimenez Fagardi. I am a parent who has been impacted by the family policing system, or the so-called child welfare system, and the family courts. I am also a former foster parent and the daughter of a former ambassador at the United Nations. My mother was part of a committee dealing with child abuse in the USA and worldwide. Thank you for this opportunity to testify about the harms of the family court system. For over 2 years, my husband has weaponized the family policing system against me. For a decade, he physically, emotionally, and racially abused me. Within 24 hours of telling my husband I was finally going to leave him due to domestic violence, he made a false report against me. This started the case that led to my temporary loss of custody of my 2 children. Right from the start, the corruption in my case was severe. Immediately, an ex parte restraining order was issued against me based on false allegations and without any evidence. I was abruptly forced out of my home with no notice, no opportunity to be represented by counsel. My husband transferred all of the money out of our joint bank account, and I was not granted emergency spousal support or legal fees for 9 months. In that time frame, I had to pay over $136,000 out of pocket in legal fees, supervision fees, house bills, even though I was not living at home, and lodging and food for my children and I. I was a stay-at-home mom at the time with no money, yet if I did not pay that money, I was threatened with contempt of court and arrest. I maxed out credit cards, begged and borrowed just to survive. I had to pay supervisors in order to see my children, and they charge up to $200 an hour. During this time, I was also investigated by Child Protective Services due to my husband's false report. The investigation itself was invasive, but it did not yield any suspicion of me. Nonetheless, the judge ordered temporary custody of my children to my estranged husband without justification, nor a hearing, nor a trial of any kind. She just simply signed the document behind closed doors without even a court reporter. It didn't make sense until I discovered all three of the attorneys on my husband's legal team have social or professional ties to the judge presiding over my case. The first attorney worked for the same judge for 5 years right before going into private practice. The second attorney is a longtime friend of the judge, and they have even gone on vacation together. The third attorney, who is also a partner at the law firm, threw a political fundraiser for the judge in her home in the middle of our case, which they did not disclose. Now the corruption was clear. In addition, the professionals that are supposed to be neutral in my case are all affiliated with my husband's legal team. Eventually, that judge had to recuse herself, but the new judge is retaliating and just as bad. This judge yells and berates me in court, and his abuse is clearly racialized. He refuses to call me by my Latina last name, and my children and I are prohibited from speaking Spanish, even though it's our native language. Before my daughter's first communion, he denied application so I could simply take her to a Dominican hair salon where they know how to do ethnic hair. All while my estranged husband, who is white, continues to physically and racially abuse our children, and the judge neglects the evidence every single time. Without justification, the judge took away my court-ordered phone calls with my children. After my mother died, he refused to excuse me from a court conference, and I was not able to be present when my mother was buried. But my husband is allowed to miss court to give people rides to the airport. Then the judge began the custody trial while I was in the hospital and did not have a lawyer. When I presented evidence to the court that my children are in imminent danger in my husband's care, the judge issued an order prohibiting me from communicating with the court without his permission or approval. I've had over 2 years of unwarranted supervised visits, and my children's lives are still in danger today. Stories like mine are often used to justify the known harms of family court. However, as a parent of children who are truly being abused by their father, I am here to tell you today that the court doesn't help our cases either. CPS has investigated my estranged husband 5 times via mandated reporters, but he still has custody. Our children showing up with bloody legs, black eyes, and other physical injuries has become the norm. On numerous occasions, my son has said, "Dad is going to kill us, Mom. Help us, please." And my daughter is called the Black African Monkey. At the end of the visit, they cry, they cling to my legs, and they don't want to leave. All of this evidence has been provided to the judge, yet he does nothing. Despite my husband having spent over $500,000 of our marital assets on his legal team, I don't have a lawyer. The judge refused to issue me an 18B attorney, and my husband has blocked me from our marital assets, despite domestic relation law 237 stating that the moneyed spouse must pay for the legal fees of the non-moneyed spouse. Over the last 2 years, I've had no due process. I've never been allowed to present my side. The courts have relentlessly violated my civil, parental, human, and constitutional rights. Family court is a billion-dollar industry driven by money, not justice. More training and money into the system is not a solution. Those fixes are equivalent to putting a Band-Aid on a wound hemorrhaging blood. The family court system needs accountability. Judges should not have absolute immunity, and the litigants should be provided the right to a jury trial and due process protections. We need a meaningful mechanism to report judicial misconduct, which does not involve the committee with the judge's friends, as is the case where I live. We need real judicial oversight to make sure the law is followed in the courtroom. We need a neutral, independent court watch program so that the court watchers can hold judges accountable too. We also need to prevent families from being targeted by this system in the first place. One simple way we can do this is to pass the Anti-Harassment Reporting Act. Survivors of domestic violence are disproportionately targeted and harmed by anonymous reporting. CPS violent invasion of my family's rights and privacy have only made the harms we are experiencing worse. We're calling on you to do everything in your power to stop this system from destroying more families. I tell you with 1,000% certainty that my husband is going to kill our children, and I pray that someone here will help me save my children's lives. Thank you very much.
Thank you. Thank you.
Thank you. We'll now hear. Thank you for that moving testimony. We'll now hear from. Is Ms. Burton here?
I would yield to Ms. Imperiale.
Oh, Ms. Imperial is here. Okay.
Good morning.
Good morning. Might we switch you so you could testify? Thank you so much, Ms. Burton. 5 minutes, please.
Good morning.
And there's a microphone if you could speak into that.
Can you hear me?
Yes.
Okay. Is there a green light?
Pull it closer to you.
It's on.
There we go.
There
on.
we go.
All right. I got an echo now. Good morning. My name is Heather Imperial. I am a mom, and I'm going to read this to you, but first, I think it's important for us to take a moment of silence and really let it impact us that there are so many innocent children right now who don't know where their parents are, and their parents adore them, and they're terrified because they don't know where their kids are. And I've been through this for years, daily, and it's terrifying, but just in this moment right now, this is happening, and we can do something about it. So I'm begging you guys to please take action. Moment of silence. I'm going to take my deep breaths. Father God, please comfort the children out there who don't know where their parents are, God. Please keep them calm, and please let them know how very loved they are. And please, please let these courts in this country make things fair for families so that we can stay together and we don't have to worry. We don't have to be paranoid about every little thing we do in public and at home. And now I'm testifying, but I'm talking to God and I'm talking to all of you guys. This is critical work. This has to change. Just on the way here, I'm paranoid about my daughter's socks being inside out because I'm thinking this is how paranoid. Logically, in my mind, I understand no one's going to take your daughter for her socks being inside out. But the way they have dragged us through the ringer in court over sillier things than that, it's still ingrained in my brain to be paranoid. It's been diagnosed as PTSD. So thank you, ACS, for that. I'm still living with it. Thank God I got my child back. One of them, I have two other children who I have not seen in years, thanks to judges in this country having ultimate authority in my family. And that's not fair. It's not right. It's not fair to my children. It's not fair that I'm a good mom and I have to be paranoid about inside-out socks. Thank you for letting me get that off my chest. I'm going to read through this now. I am a parent, writer, advocate, and graduate of JMAC for Families Heal program, and I'm so grateful for their presence in my family's life. Family court has been involved in my daughter's life since the day she was born. Moments after I gave birth to her in the hospital, my doctor drug tested me without my consent. I didn't even know if my baby was a girl or boy before they drug tested me. Joy quickly turned to panic and terror when my doctor reported me to CPS. In my first few moments with my newborn daughter, I was supposed to be focused on skin-to-skin bonding. I was supposed to be living in the joy that is a newborn child. Instead, I felt panicked, and I had every right to feel that way, because soon they ripped my daughter away from me. I was supposed to be taken care of by my doctor, but instead I was targeted. I didn't just feel targeted, I was targeted, because test and report is exactly what it sounds like. We need to narrow the front door. They're funneling us into this system, and it's not just my family, it's so many, and it's not just my generation. It's going to be my daughter's generation if we don't stop it now. This trickles down, and the trauma that I am suffering is being passed down, unfortunately, to the next generation. And my daughter has been abused in the system, in the foster system. I pray to God that we can overcome that before she becomes a parent, if that's what she chooses to do. But this, and I know I keep going off script, but this is just such a loaded topic, and it's so important. And if we care about our society, just our species, the future belongs to the children. This is what we should be focused on: love and on family. How much time do I have left? Okay. I mean, I don't think I'm going to get through all this, but
If you could just summarize.
yeah. Just let us be parents. You know, that's all I want to be. I just want to focus on my daughter every day. I don't want to have to jump when I hear something drop to the floor, and it could be a knock on the door, no matter what time it is. February of this year, they pulled us out of bed at 3 o'clock in the morning because I had lost weight, so I must have been on drugs. They stripped her down in the middle of the night to check her for bruises and everything. And I could have said no, but I know that opens the door to even more, you know, it's,
Thank you.
I could go on and on. So thank you for listening for the 5 minutes.
We'll take copies of your written testimony.
Okay.
Thank you very
I got
much.
more where that came from.
Well, we really appreciate it.
All right. Thank you so much, guys.
Thank you. And next, I'd like to ask Ms. Angela Burton to share her testimony.
Thank you. Good morning. My name is Angela Olivia Burton, and I have a very simple message. I'll share a little bit about who I am and why I think I was invited here today, and thank you very much for the invitation. But the simple message that I have is, listen to these guys. Listen to the people who've been through this. They're survivors. They have not been helped. Their children have not been helped. Our communities have not been helped by family court, by CPS. The system is not broken. It is doing exactly what it is framed and structured to do, which is to tear apart families, to take children out of their homes, to place them with strangers, whether in family settings or congregate care facilities, and to spend billions of dollars to maintain state custody of children in a system that we all know, everybody here knows, subjects them to heightened risk of abuse, neglect, sex trafficking, outcomes that are horrific in their adulthood, generationally. At this point in time, 50 years after the federal law was passed that created this system, the Child Protective Services system, 50 years next year. At this point in time, 53% of Black children in America will have been subjected to a CPS investigation strip search in the middle of the night out of their beds. 53% of Black children in America, how much longer will it take before that's 100%? Not much longer, I don't believe, I fear. 100%. Slavery is what it is. I will tell you a little bit about my background as a way to show you why this system needs to be abolished. Really, I'm not the only one calling for that. And that includes family court as well. In 1974, this country created the Child Protective Services. We say that the child welfare system is about protecting children's safety, stability, permanency, health, and well-being. We know that ain't true. And the reason why it's not true is because the system is not designed to do that. The federal law that created this system is about reporting, investigation, prosecution of parents. That's what it's called, prosecution. This family court is not a civil court, it's a prosecutorial court. The services, the treatment that we claim to be providing to parents and to families is punishment, it's control, it's regulation, it's disruption, and it's destruction. Everyday lives. So, as I said before, my reason for being here is simple, is to really ask you all to follow the lead of the people who have been impacted, who are survivors. My over 30-year career in New York State has spanned academia. I've been a law professor, I've been a practitioner, I've worked in state government, and I've seen a lot. I haven't seen it all. They've seen it all. And it's worse than you can imagine. So I'm here today to stand with these families, to stand with these parents. As a person who has been in state government with the New York State Office of Indigent Legal Services, I was the New York State's first director of quality enhancement for parental representation. I worked in the court system as a law clerk on the New York State Court of Appeals for Judge Fritz Alexander. I worked with Judge Kaye when she established the Permanent Judicial Commission on Justice for Children and have been a member of that committee for all these years. I've worked in the Office of Court Administration, in the Office for Justice Initiatives. They're not going to change themselves. Don't listen to them. They're going to tell you, we need more judges, we need more resources, we need more technology, we need more. They're just dragging and hoarding resources from the community. Do not give them more. Give that to these communities. Give it to the families. We can do this. Yes, Senator Hallman, it's daunting, but it's doable. We can do it. We have to first listen to the people who've been impacted, who are survivors. You know where to find me. Thank you.
Thank you. Thank you very much. Okay, Ms. McMillan?
Good morning. Thank you for giving me the opportunity to testify. My name is Kayla McMillan, and I am a former inmate. Foster youth. It's hard to differentiate the foster youth system when the congregate care settings that I was placed in represented a system that directly replicated the mass incarceration system. I am here on behalf of JMAC for Families, which is led and was founded by my mother, Joyce McMillan. This hearing is about how to make the family court system better for families, but I'm not sure if that can be done when this system was built on the backs of destroying them. Today, I demand your attention. I will speak for those youth and families who have been silenced. We will be heard. I want to be clear. We are not here to reform this system. We are here to shrink and later abolish this system. Family court is detrimental to youth and families. I know this firsthand. Family court shut down my voice when I begged for my mom, my sister, my school, and the life I lost before foster care. My family defense lawyer advocated for me to be home, yet I was still shut out and locked away into a system that resembled prison. This is not a line of defense for families. It is what we must protect families from. Family court took everything away from me that I knew and loved. It shattered the bonds of my family and kept me from building valuable memories that I will never be able to share with my own children one day. I have no baby photos. I have no early memories. I sink into my chair when my peers discuss early childhood. The embarrassment I once faced and blamed myself for hurts me.
I know only one thing is responsible for that pain now: this broken system. I am here today educated, loved, and cared for. That is not because of family court. It is in spite of it. Thank you, Mom, for fighting for me. Family court never protected me. It was what I had to be protected from. It is why my family had to fight. Family court put me in a congregate setting. I was sentenced to 1 year in jail. The similarities make it difficult to differentiate. I am not a criminal. I didn't deserve to be there. This now has impacted how I live my life. It brought me trauma that I will spend the rest of my adult life coping with and getting my life on the right path in terms of child, adult, and peer development. Now 24 years old, I am fortunate to glimpse a bright future ahead. My journey here has been long, and unfortunately, I am far from the only young person failed by this so-called child welfare system of New York State. There is no fixing this broken system. It must be dismantled. We must stop ripping families apart and placing kids into a system where they are hurt and unloved. No child deserves to face the educational, mental, physical, and emotional abuse and neglect that is the daily experience of so many of these youth. It is time for a change. In New York, there are thousands of kids like me who are separated from their families and placed into the foster youth system. The overwhelming majority of them look like me, Black. Despite everything, I graduated high school on time. I'm able to read, write, and get a job, but it was not because of this system. It was because my mom and my family fought for me. Thank you, everyone, for listening to my testimony, and I hope that we all come together to abolish this system.
Thank you. And I want to thank all of our panelists on this panel for your testimony. We'll be talking a lot about the structure of the family court system, but I think it was very critical that we centered your voices and your expertise and listened to you first, because as we go through all the solutions that we're hearing today, it's important that we recognize that it won't just be a matter of having more judges and more resources, processing more efficiently the types of cases that go through system, but really looking at how many cases are even brought to family court in the first place. I definitely want to highlight the 53% statistic that Ms. Burton shared earlier. I have a couple of questions. These are to the full panel. First, just in terms of your awareness of your rights, when CPS first approached you regarding your case, did they let you know what your legal rights were?
No.
And when you became involved with the family court system, did you have legal representation?
Not initially.
Not initially.
I did.
Yeah, speaking to the mic.
I used the Legal Hudson Valley before on my last case that I had with them. I've been with them for 3 years now.
Okay.
And they have been helping me. The only ones that have been helping me. I've gotten no services out of CPS since I've started in 2021 with them. I've been involved with them for 3 years, no services, no transportation funds, nothing. I have literally got nothing. And the family court actually highlighted something in court that I wanted to share with you guys today. That I was a great mom and just needed services. And now I just went to court on October 17th, and they still have denied the return for my children to come home with completed services.
Thank you. Oh, yes.
Could I speak to that as well? So in 2018, Judge DeFiore created the Parental Legal Representation Commission and appointed me as special advisor to that commission. One of the findings of that commission was that between, I may be getting the years wrong, but there's a report that has the exact accurate information, but between the years of 2015 and 2019, 12% or approximately 12% of cases in which a child was removed at an initial appearance in family court where the parent was there, that parent did not have legal representation.
Thank you. And I actually had a follow-up question for you, Ms. Burton, because I know you were previously employed by the OCA, and I was hoping you could share with us the circumstances by which you left the OCA.
I was fired.
I also understand you were previously scheduled to testify in Washington, D.C. Could you tell us briefly a bit about what you would have testified about?
In July of this year, I was scheduled for two presentations, actually. One was a congressional briefing in Washington, D.C. before the Congressional Youth Caucus, and that would have been on July 19th. That hearing was regarding the issue of hidden foster care or shadow foster care, in which CPS agencies basically will, upon investigating the family without any court oversight, without any court filings, without any due process, without any legal representation for parents or, any rights discussed, will basically threaten and coerce a parent to transfer custody of their children to someone else, usually a family member, and put restrictions and constraints on the relationship between the parent and the child, how often they can see them, when they can see them, whether they can see them at all. And that's a widespread practice that is that's prevalent across New York State as well as across the country. I thought I'd turn that off.
It's okay.
Sorry.
Thank you. That's also that's
So
my time.
yeah, so that was the gravamen of the hearing on July 19th before Congress. The other event that I was scheduled to speak at was July 21st. As some of you may know, the New York State Advisory Committee to the United States Commission on Civil Rights has been holding a series of hearings on anti-Black racism in the New York State family policing system. I was invited to speak at that hearing on July 21st, and the remarks that I plan to speak to were similar to what I summarized today, which is regarding the structure of the federal laws that trickle down to the states that lead to the outcomes and experiences that you heard today.
Thank you so much.
Thank you. A couple of questions for Ms. Jimenez. Thank you again for your, if we could just swap out for a moment. Just wanted to follow up with your personal plea here. Are those the names of your children on your?
No, these are the 5 names of the exonerated 5 who in 1989, black children, their constitutional rights were violated. They were sent to jail.
Yeah.
And
Well, I want to talk about your children.
yeah, well, you asked me.
Yes. No. Thank you. No, thank you. And I did. So what is the current situation? You're literally telling us you are fearful for their lives. What recourse do you have at this juncture? What's the court telling you?
The court is my custody trial is moving forward. My husband is the moneyed spouse, and he has been able to, through our marital assets, be the moneyed spouse, and everything is going in his favor because he's the law firm that he has, like I told you, they're affiliated with the judge. Every single professional in our case is affiliated with that law firm. At this point right now, I'm telling you right now, you will see us on the news. He's going to kill our children, and he's probably going to kill me too. I have no recourse. The judge refuses to assign an 18B lawyer, and I have no recourse. I have 0 legal experience. I'm expected to go up against one of the biggest matrimonial law firms in the tri-state area. And despite him spending $500,000 of our money, marital assets, on his legal team, I haven't been afforded the same opportunity, even though Domestic Relation Law 237 says the moneyed spouse is supposed to pay for the legal fees of the non-moneyed spouse. I'm terrified. My children, like I said, they show up with bruises, black eyes, and the judge does absolutely nothing.
So when was the last time you reported this to the judge?
The judge sees the supervision reports. I'm the one that has supervised visits. However, in those reports, it states what the children are saying. It's stating the children show up with bruises. He sees all of it. It's constant. It's constant. And he does absolutely nothing. He's retaliating for me having the prior judge removed. And she had to recuse herself for her own misconduct.
Well, we certainly want to follow up with you after this hearing to make certain that you and your children are safe. If not through the judge that it's been assigned to you, through law enforcement and other ways that we in the Senate can be helpful. So thank you for your incredibly important
Thank you very much.
testimony.
Any help in saving my children's lives is greatly appreciated. Thank you so much.
And I wanted to, again, thank you so much, and thanks to all the panelists. I wanted to acknowledge we've been joined by Senator Bailey, Chair of the Senate Codes Committee, and Senator Rawlinson, thank you, as well as Senator Skoufis, Chair of the Committee on Investigations and Government Operations. We'll now turn to other senators who have questions. Senator Ramos for 3 minutes.
Muy buenos días. I'm Jessica Ramos. I represent a few neighborhoods in Queens. I happen to be a divorced mother of two who has been through family court myself, and it has been quite emotional to hear all of you testify this morning, so I hope you can bear with me. I actually used to work for the Social Service Employees Union, which represents workers for CPS and ACS in the city. So I wanted to hear a little bit about your experiences working, I shouldn't say working, your experiences with them. Alexis, you said something interesting before about child advocates. We, in this past budget, actually allocated funding for 7 new child advocacy centers. So I was wondering if you could help talk about your experience or how child advocates in general have helped you.
Throughout the 3 years that I've been working with legal, with legal aid, their parent advocate been there with me. Also a social worker. They have came to CPS meetings. They have seen exactly what I have seen, the confusion, the no reunification. I'm still at no reunification point. I've successfully completed all of my things that they asked me to do. I have went to court, back and forth to court. It's the same answer, denial. Parent advocacy also comes to court and they advocate and testify as well. And that's, from what I've experienced, that's the only help that I've been seeing, and my case is coming from the parent advocate, the social worker, the legal defense unit, the legal aid part. That CPS has helped me with nothing.
Okay, thank you. Ms. Burton, only because I have 50 seconds and my next question is for you and maybe you can fold it in. Yeah. So I actually chair the Labor Committee in the New York State Senate, and I wanted to ask about your experience as a whistleblower and wondering whether you were an at-will employee or whether they had warned you before testifying that there would be negative repercussions for you speaking out.
So first, I just wanted to go back to the question that you asked, Ms. Alexis. The child advocacy centers are a completely separate animal beast than the parent advocates that she's speaking of. So I just wanted to clarify that that model that she's speaking of, holistic legal representation, which would include a lawyer, social worker, and parent
It's very
advocate.
expensive. I mean,
It's
not only do you have to pay for
it's
your lawyer,
n-
you have to pay for your children's
Right.
lawyer, the AFC.
Right.
Then there's the parent coordinator.
Right.
It all
Right.
adds up, and it's all money that we're actually supposed to be spending on our own kids.
Right, and so the model that Ms. Alexis is talking about is a model that I have championed that is based on the New York City model of having legal representation team include social workers and peer advocates, parents who've been through the system before that can work directly with parents who are going through that system in the lawyer-client confidentiality framework. Those child advocacy centers that you were referencing, it's a different thing,
Yeah.
and that's a whole other conversation. But to my situation, I am not labeling myself as a whistleblower. I have always, throughout my over 30-year career in this field of family law, children's rights, family court representation, stood with parents and youth who are impacted by the system. The incidents or the impetus for my firing, and I cannot speak to the rationale because I was not given a rationale or reason for my firing. What I can tell you is what happened. And what happened was I informed my bosses at the Office for Justice Initiatives that I had been invited to speak on the 2 occasions that I described. I was told that I would be denied permission to speak on those 2 occasions as long as I was a court employee. Despite my making it clear that I would be speaking in my own personal capacity as a private citizen with First Amendment rights to speak on issues of public importance that I have expertise and experience in, I was told that if I did speak, I would be fired. I did not speak in actuality, but I was preemptively fired the week before those events were to occur.
Thank you, Ms. Burton. I know we're out of time. To close, I just want to say that, you know, it just seems like family court's philosophy sometimes is to keep families together that don't need to be together, too. I know that there are very different types of cases in family court case. That's been my experience. But I do appreciate the overall point of addressing child poverty as a root cause of this. I actually passed the Child Poverty Reduction Act in the Senate, and we're hoping that we are embarking on a path towards the light because it has been so difficult for so many families in New York for so long. Thank you. Thank you all.
Thank you. And next we'll have Senator Liu.
Thank you, Mr. Chairman. I want to thank the witnesses for spending their time with us this morning. I just have a couple of questions for you, Ms. Byrne. I find your testimony very enlightening, and thank you for your forthrightness. You know, just to play devil's advocate, though, does the family court do anything right?
Which devil are you advocating for?
Well, the big one. So, you know, we've heard a lot of problems, and we're going to hear from the court system in a little while. Obviously, there are innumerable complaints. My question is there anything that you think they do right? I can say it another way. You had likened the court system to a system of prosecution instead, and you know, does that mean are there any families that are actually saved by family courts, or have they always just simply destroyed families?
I have not likened the family court to a system of prosecution when it comes to child protective proceedings. The federal law and the state law terms it a prosecution, and that is what it operates as. Parents are accused of wrongdoing.
Is there a difference between CPS and the family court system, or
The
CPS/ACS?
The child welfare system is is a network of systems. CPS is the feeder system. Family court is the ultimate oversight system, allegedly, supposedly, of the CPS system, Child Protective Services. They have different functions, but they're very integrated. And the family court judge is the final arbiter of whatever happens with regard to a family once that CPS agency, whether it's Administration for Children's Services in New York City or Department of Social Services in Rochester or wherever it is around the state. That's how the system is structured.
So the
family
Child
court
Protective
judges-
Child Protective Services system is kind of like a prosecutor, because
It is the prosecutor.
clearly the government is not agreeing with what the parent is doing and believes that the child is at risk.
Mm-hmm.
And you're saying that the family court system is simply an extension of CPS?
Pretty much in many cases, what I have seen, heard, and studied, it is pretty much a rubber stamp from beginning to end, yes.
Thank you. Thank you, Mr. Chairman.
Thank you, Senator Liu. I wanted to acknowledge Senator Rhodes has joined us. Thank you, Senator. We'll now have 3 minutes for Senator Palumbo.
Thank you, Chairman. And thank you all for your testimony. And I'm going to make just a quick comment, and then I'm going to have a question for you so you can start thinking about it. I'll lead with it as to what the alternative system is, because we can't just put a line through the Family Court Act and say, that's great. And when I hear these heartbreaking stories, I've practiced in these circles for probably 15 years as a lawyer. And I think about, as Ms. Imperial even mentioned, that tearing a child from a mother at birth is an outrageous thing, and that's not the answer. But when you have a positive meconium test that there's a drug issue, that also needs to be addressed. So there needs to be a focus on resources, in my opinion, and that's why I really want to hear from you folks who have been there. We can't throw it out. I know we're talking about completely abolishing the system, but what is the better alternative? And I think about, for example, there are so many dynamics to it, as I said within my opening comments. There's clearly a race issue as well that I think we all acknowledge. When you look out in Suffolk County by me, the Valva case, Thomas Valva's father was a police officer. The girlfriend, or I believe fiance, was also a police officer. There were complaints, mandatory reports from the school. The kid was showing up with bruises, was hungry. The father murdered that boy, but he was white. He was not of color. He was a police officer, and for some reason, there was never a founded complaint, and it clearly should have been. So to hear your stories, it's just awful that the system has failed you folks in the way that it has, and we don't want that. So what can we do with your view of the world? What can we do to make it a better system? Because there needs to be a system. We can't not have a system, right? We need to have the ability to report and to do something, because there are circumstances where court intervention is needed, but taking 3 years to resolve a custody case is outrageous. So anyone who'd like to make a few comments, I'd love to hear them.
One of the things is to not file, and that's not emergencies, to file within emergencies, because then you confuse the system. And what is intimate risk? What is an emergency case? What are those things? When they file things like a baby being on the bed, or not having a home, or things that you can fix 1, 2, 3 by assisting a family, takes away from a case like the case you just explained, where somebody is getting murdered. You're taking more time out on things that's not emergency for children, where the services could just be provided right then and there through a referral, and everything would be fixed, versus taking it to court, having a judge decide on, and wasting everybody's time. Not only the AFC, your lawyer as the parent, because the lawyer is looking at this as this is a waste of their time because it's no intimate risk. An intimate risk is something that is right then and there that needs to be a removal. Half of the cases that's going into court are not intimate risk cases at all.
Thank you.
Thank you.
Thank you. Thank you, Senator Palumbo. Senator Mayer for 3 minutes.
Thank
you, Mr. Chair. First place, to all of you, thank you for having the courage and the tenacity to come and tell your story today. It's super important that we actually hear what happened. I have a question. Ms. Jimenez, because these judges are determined by county and by politics, what county is your case pending in?
My case is pending in Rockland County, and the judge that was before, she's had numerous investigations with the FBI, State Judicial Committee for all types of bribery and things having to do with political contributions and things of that nature, and also for her just awarding custody to the moneyed spouse. They're not following the letter of the law. It's about the moneyed spouse. And by doing that, they're not doing what's in the best interest of the children. They're doing what's in the best interest of the moneyed spouse. And that's impacting my children's safety.
I understand, and we do need to follow up. Secondly, a number of you talked about being abused by the judge, orally or intimidated, belittled. I just wondered if any of you can speak specifically about the conduct. Yes, I would like to hear you on the conduct of the judge towards you and what you had to say.
I will say that the judge that I had, or have rather, she's very, how should I say, like, very gentle and soft spoken. She wasn't outright disrespectful in a way in which, I was insulted or anything like that. I think it was more so the tone of just ACS having the overall direction. There being no time frames of an outcome, meaning, my daughter, thankfully, I do have the support of my in-laws who have stepped in as guardian. I gave consent to that kinship guardianship.
Right.
But their involvement was just, it was dragged. It was too long. And again, the judge was more so, listening to what ACS had to say, and there was no countering that.
Can I
if you
just
will.
ask you how long it took for you to get the child that you have back in your?
I don't.
Oh well, in
She's
the
with-
kinship guardianship, how long did it take from the ACS?
6 years. I just closed it out in September.
6 years for your in-laws to have custody of your child.
Yes, she's with them now.
Thank you.
I can also speak to that. There's some time left. I can give an example of a time that the judge in my family court case that is closed now yelled at me in open court for 43 minutes. She looked at the court timer and yelled about that too, because I refused to sign a HIPAA for the first few months of my case. I did not want to turn over that information of the meconium test. I never consented to that test. It was irrelevant then, and it is irrelevant now, and it was irrelevant all through the case.
Thank you.
And so she took away my right. What is a HIPAA? If the judge can say in open court, and she said this, if you don't sign this, Miss Imperial, and quite frankly, it's neglectful of you not to, I will get those records with or without your signature.
Yeah, understood.
Can I
Thank
just
you.
say something really quickly? The second judge that I have now, he is a blatant racist. The day after my mother died, my mom had died, it hadn't even been 18 hours. He refused to allow me to miss a court conference. It wasn't anything big. And when I did show up, he saw me crying and upset, obviously, and he mocked me. He felt that the appropriate time to laugh, scream, and say, "You've had what? How many? 15 lawyers? That's a world record." And I said, "Your Honor, I haven't had 15 lawyers, please." And he kept screaming and hollering, and he refuses to call me. My last name is Jimenez Fagardi. He refuses to use the last name Jimenez. He is a blatant racist and refused to even issue an 18B lawyer. So it's
Thank
been
you.
ongoing with him.
Thank you.
Thank you, Senator Mayer. Just a quick question: Are any of you unrepresented by a lawyer? You don't have a lawyer now.
I don't have a lawyer.
Anyone else without a lawyer here and testify? Are you using what other resources do you have available? So you're pro se in court. Do you use how do you represent yourself?
I don't. I'm not a lawyer. I have zero legal experience. I asked the judge to please award me an 18B lawyer. He said absolutely not. Legal Aid has a 2-year waiting list. I've reached out to Women's Center, all type of centers. They're like, nope. there's a long list, wait list, and once a custody trial has started, we won't get involved. So the custody
Thank you.
trial is still ongoing. I have no lawyer, and he's represented by a big law firm.
Thank you. Senator Bailey for 3 minutes.
Excuse me. Good morning, everybody. There we go. Good morning, everybody. I just want to thank you for your courage. I apologize. I'm walking a little bit late. But the gist of what I want to ask Annie and everybody, thank Dean Burton, good to see you. I just want to ask you, outside of the I guess, the personal aspects, which are, I guess, and I thank you for sharing your stories, what steps, can we take? Do you think there should be more judges? Should there be more court-appointed attorneys? Like, I know you mentioned that, like, what gaps can we fill as legislators is something that I wanted to, not having heard the testimony directly, what are some of the gaps that we can fill in?
So the thing is, many families are in this system due to neglect and not abuse. So I would say stop giving funding to additional judges and stop funding the system when we can just give those resources directly to families. If a child is removed because mom loves her but can't feed her, that doesn't mean that she needs to go to a foster parent, which will be paid how many dollars when all we had to do was give additional food assistance. So the real problem is that we need to stop placing children in this system and instead give meaningful resources to families.
Well taken. Anyone else?
And meaningful reasons of why the children are removed.
Yeah, definitely narrowing the front door in the first place is going to save everybody a lot of money and all of us a lot of heartache, and it's going to improve society as a whole because everybody's going to be in a better mood. Our kids are going to grow up happy and loved and safe.
And we won't have statistics.
Right,
They'll be different. They won't be so heartbreaking.
Mandated reporting is a big issue. Again, it's too wide of a spectrum, and being that folks, their professional and livelihood are in line with this mandated reporting, it's causing too much harm by sending families in. Again, my case was missed days of school, and then there was another instance where the shelter that I'm placed in reported my family for a dispute, and it was a very benevolent dispute. So again, as opposed to just policing families in vulnerable states, how about we just hold the community-based organizations and schools and such to have more of an evaluation where they can really follow a specific metric that holds them accountable to these findings, like, hey, okay, what's going on? Missed days of school? Okay, mom is having an issue here. Let's be of sound mind where this is what the original complaint was, not my smoking or anything, because that was another can of worms that opened up that really held me into the web of family court. It was completely focused on a positive drug test, as opposed to I was in distress at the time. I already have the family supports. It's already there. I'm just having difficulty. New family, all of the above.
And you shouldn't be punished.
And children know what they want. I was a child when I went through this system, and if you asked me where I wanted to be, I would have told you home. Yet I was placed in the system regardless.
Thank you very
Thank
much.
you very much.
Thank you, Senator Bailey. Seeing no further senators, I wanted to thank the panelists again, as my colleagues have noted, for your courage, forthrightness, and candor. Not too many witnesses get to testify before the highest court officer in New York State, so it's a privilege to have you here. Thank you very much.
Thank you very much. If I may, Senator
I'm sorry.
Coleman-Segal,
We have to go on to the next panel. I'm so sorry.
I had one question for you.
We don't have time, but you can ask me offline. Thank you so much.
Thank you.
Thank you.
Thank you all too.
Thank you. Much appreciated. Our next panel will be Judge Richard Rivera, who is a statewide coordinating judge for Family Courts Office of Court Administration, and Anne Marie Jolly, who is the New York City Family Court Administrative Judge, Office of Court Administration. Each of these officials will have 10 minutes to testify.
Judge Rivera, whenever you're ready.
Good morning, Senate Judiciary Committee Chairperson Hoylman Segal and Children and Families Chair Brisport. Many thanks for convening this hearing on the critically important topic of the family court. We appreciate the opportunity to address the accomplishments, challenges, and recommendations for the future of the court. I am Richard Rivera, the statewide coordinating judge for family court matters. I was elected to the Albany County Family Court bench in 2014 and have served as supervising judge of the family courts for the 3rd Judicial District since 2022. I was designated as an acting Supreme Court justice in 2019, and in that capacity primarily preside over the integrated domestic violence part in the 3rd Judicial District. I also, prior to my designation as statewide coordinating judge for family court matters, I was the co-chair of the Franklin H. Williams Commission. I am now emeritus, but I'm still a member of that commission. Prior to becoming a judge, I practiced. I served as a child support magistrate in Albany County Family Court. I served as an assistant alternate public defender representing families in family court. I served as an assistant county attorney prosecuting juvenile delinquents in family court. I was an attorney for the child, and I also represented private clients. I started my career in family court representing domestic violence survivors with the Albany Law School Family Violence Clinic, and my colleague and I will be sharing our testimony.
Good morning. I am Anne Marie Jolly. I am the proud administrative judge of the New York City Family Court. I'm privileged and honored to have been serving in this capacity for 2 years today. And prior to serving as the administrative judge, I served as a deputy administrative judge to New York City Family Court. And prior to my appointment to the bench in 2010.
Maybe just pull the microphone back closer to you.
Closer? Sure. So prior to my appointment to the bench in 2010, I served at various points to 2 administrative judges of the New York City Family Court. I have served as a staff attorney at the New York State Judicial Institute. I have served as a court attorney referee in family court in Queens County. I have been the deputy to the chief magistrate for the state of New York State Family Court. I have served as an attorney representing children. I've also served as a deputy attorney in charge at the Juvenile Rights Division Legal Aid Society. Together, Judge Rivera and I bring decades-long commitment to and experience in all sides of the family court, and we do appreciate the opportunity to share our perspectives with you today. Preliminarily, I'm going to take full advantage of the microphone, and I thank you. I want to, Judge Rivera and I, at this time want to acknowledge that the judges and the jurists of the New York Family Courts, they make decisions daily that are among the most profound and long-lasting imaginable, including whether to order children remaining in their homes, whether or not children should return to the care of their parents or guardians, whether parental rights should be permanently terminated, whether children and youth who are accused or adjudicated for delinquent acts should remain in the community or return home or remain home, whether or not they should be placed in detention or placement facilities. We make determinations as to who should be guardians or adoptive parents of children, who should be adjudicated, whether or not we should issue protective orders to ensure that the domestic violence that's alleged serves to protect those who are being harmed. We also make determinations as to the extent that parents and grandparents should have access to children. I think that answers a question that Judge Liu had raised to the previous panel. These responsibilities are taken extremely seriously, even though those judges and jurists rarely receive praise, deserve for the challenging work that they perform each and every day. The judges, the judicial hearing officers, the court attorney referees, support magistrates of the family court, as well as the non-judicial staff that support them. They work tirelessly to rise to the challenges posed by the enormous volume and the complexity of these serious and emotionally charged cases. We take the opportunity to express our gratitude for the professionalism and commitment of the judges, JHOs, referees, support magistrates, court attorneys, clerical staff, security staff, interpreter staff, and court reporter staff. All of them have enabled the court to provide the best services possible. We thank them and we thank you for convening this hearing to address how the three branches of government can collaborate to enhance the capacity of the family court to provide timely and effective justice to the children and families we serve. Chief Judge Rowan Wilson has made, as you've heard before, resourcing the family court and the quality of justice it delivers a major priority for his administration, for which we are most grateful. This is reflected in many ways, including the appointment of Judge Rivera as the new statewide coordinating judge for family court matters. While we cannot dispute or deny that challenges exist and remain, we are eager to work with the legislative and executive branches to meet those challenges. We can report positive developments and important accomplishments in the family court. We can talk about the equal justice efforts that have been made, technology in the family court, alternative dispute resolution and community dispute resolution centers, judicial training, as well as the family court being a laboratory for innovation. In response to the report issued by Jay Johnson, the unified court system has established wide-ranging equal justice efforts under the leadership of our Deputy Chief Administrative Judge, the Honorable Edwina Richardson. Among the steps undertaken that affect the family courts is the comprehensive implicit and explicit bias training required of all judges and non-judicial staff, which was completed in October 22. We've enhanced the technology in the family courts. I know that we're short on time, so I'm going to turn it over to Judge Rivera.
So one of the most effective means of reducing caseloads in the family court has been through alternate dispute resolution, or ADR. Pursuant to the initiative of the past few years, all districts have ADR plans, and many of them include family court, and we certainly want to have that extended. We also have community dispute resolution centers that provide mediation in cases where it's needed. I know in Albany County, where I preside, we have a Mediation Matters program that we often use to provide mediation services in issues where there is no domestic violence or intimate partner violence, and we include it in matters of child support as well. The mediators are trained to handle those cases. Those agreements always come back to the family court judge or the support magistrate for us to review, make sure that they're in line and correct. And that is a service that we feel should continue and be expanded to assist in the caseloads and in the cases that come to family court. And we often even let litigants know that before they even file a petition in family court, they can go to mediation and try to resolve the matters without coming to family court. We have, we have a lot of court innovations in family court that we have implemented, like the Strong Starts Court Initiative and the Parent Support Programs, and we certainly want to continue to use those programs and expand them and see, in my capacity as statewide coordinating judge, see if those can be expanded throughout the state and used in other parts where they don't currently exist. We do want to highlight some of the issues that we believe still are concerning and that lead to significant delays. Two of the root causes of the family court trials and hearings that extend over months and years is, in fact, a shortage of family court judges. And I know that our prior panel may have said that we don't need more family court judges, but the reality is we do have family courts throughout the state. We do have cases that come to family court, and we don't always have the judges that are needed to preside over those matters. We don't have often the luxury of using 1, 2, 3, 6 days in a row to try a case. So often we do have to give parts of a day or one day and then adjourn it for another week or even another month. And it's not that we want to do that as judges. It's because of the nature of the system and the lack of both judges and resources. And so we do need more judges. And I don't want to spend more time on that because I see that my time is really short. When we prepare
Actually, we'll give you
statements-
more time because I think we were going to give you 10 minutes each.
Oh, okay.
But in addition to that, we also need the services to go along with it. And a lot of what was discussed in our prior panel really was not about the family court, but about the services that are needed for families throughout the state. And sometimes our hands are tied. Mental health is one of those areas where family courts don't have the resources throughout the state to assist families and young people who need mental health services. You know, that's supervised parenting time, centers that supervise families where it's needed. And it's not just in matters of domestic violence, but also where there are issues with substance abuse disorders. And we need parents to have access to their children, but at the same time feel that it would be in the best interest of the child to have that be supervised, but don't always have the resources. And we often have to resort to family members or friends or neighbors or others who can assist the court with that. And that's not always the safest way or the best way to handle it.
And the reality is there aren't always family members or other supportive people in the lives of, let's say, the non-custodial parent who wants to establish a relationship and wants time with their child. So the localized supervised visitation programs help. For example, people who don't necessarily plan to parent and all of a sudden they're parenting and they haven't figured it out. How do we do this if we don't have the resources that we need? We can't create new family for them, but if we had meaningful locations where people could meet and exchange, and unfortunately sometimes the exchanges happen at a precinct, that's not ideal, right? Sometimes it happens at a fast food place, that's not ideal. So if there could be locations that are comfortable for the families where they could exchange, have time, and develop those relationships. I want to take just a minute to acknowledge that we were listening to the panel before, taking notes diligently as to what we can do differently. It causes much concern to hear what parents are going through. We appreciate the format of the program so that we could be here to hear the concerns that were raised. It's troubling that a parent doesn't have any photos, right, of their child as they're in the foster care system, that a child doesn't have any of their own photos, something that we take for granted. So as a judge, it's striking, and I heard that, and I heard much more than that, so I do appreciate the format and the opportunity to hear from those who are impacted. And right, we don't often have that opportunity. Usually it's in the court setting. So thank you very much for setting up the format in this way. We will continue to take notes throughout the day. I have my counsel here. I have my counsel in my office as well, taking full notes as to what it is that we can do differently. Again, we are not in denial that there are things that need to be put in place in the community. It would be wonderful. I agree with one of the parents who said if you could support us in the community, many of the cases would not end up in family court, would not end up under investigation by the Child Protective Services or ACS if there was full support in the community. But once it gets to us, it would be lovely, right, to support a family and have appropriate resources and locations where we could make appropriate referrals and they could move along and get out of the court system. The lack of resources increases delay. It just does. If we don't have locations where parents can go for visitation, if in some cases there's a need for mental health evaluations and there isn't a location, where do they go? If they need counseling, right, where do they go? They get put on a list and that builds in delay. If they don't have an attorney to represent them and they're on a waiting list, how do they manage, right? So it'd be wonderful in the ideal world if there were locations established in the communities where people could, if you have a legal matter in most other worlds, other situations, and you have a criminal matter, you have an opportunity to go speak to a lawyer and try to figure out what your legal options are, what all of your options are. That is not something that is afforded to parents once those investigations begin. It would be ideal. In the ideal world, they could consult and figure out what's the strategy? Wait, what am I supposed to do now? Rather than face someone who's come to their home at whatever hour, where I imagine all of us would feel the same thing. What is happening? It's disorienting. How do I rationally process what is going on right now? I need to call someone. How do I figure all this out? And how many lawyers are there? We have a failure of having sufficient lawyers in our court system to represent parents and children. The pay raise happened, thank goodness. But we lost a lot of attorneys from the panel by the time the pay raises happened. We don't have attorneys in the other agencies who are staying. So I know that the agencies that represent parents and children, they're facing some challenges. And that's anecdotally. I've not reviewed reports. That's just based upon regular meetings that I have with advocates and agency heads, that they're facing similar challenges that the whole nation is facing, really. These are the most important cases, and we should have advocates who represent parents, or at least can consult with them in a certain way, and they can consult with them before a case is filed, as they're being in the city, the Administration for Children's Services conducts child safety conferences before they file a petition. It would be ideal and wonderful if a parent could say, can I talk to a lawyer first? Can a lawyer be in the room with me right now? So that I know what's going on. People are frazzled and they are unnerved. I know in my life, when I'm going to see a specialist, I bring a friend along. I have a husband, but we're both focused on whatever that issue is. And a doctor might say something, and I walk out, and I'm like, he said I'm going to die. But my friend will say, that's not what he said, right? But you're emotional. You're emotional. And what's more emotional when you're talking about your children, right? So if you could bring someone into the conference with you, if you could have a lawyer who understands the lay of the land, wouldn't that be a wonderful contribution to a parent who would then feel as if they really did have an advocate in the room?
You know, that's usually not something that we can address before a case comes to us as judges. But once a case is before us, we do have a responsibility to inform litigants of their rights, including their right to an attorney. So as my colleague said, we were listening, and we don't like what we hear any more than anyone else does. We certainly don't like anyone having a negative experience when they come to family court. I can tell you, as a sitting family court judge, I became a judge because of my experience growing up in the Bronx as a young Puerto Rican male. So I take that to heart. I consider that every time people come before me. I don't always grant the presentment agency what they want because they're not always entitled to what they want. They don't always have the evidence to support their requests. I take that seriously. And so it is disheartening when you hear that people have had a terrible experience in family court. Nobody certainly wants that. You know, but the family court judges do a lot. We do a lot. And we face a lot. We hear a lot of different kinds of cases, both good and bad. We try our best with what we have. We have rural parts in our state where it's difficult for people to get transportation. Using, Teams has been wonderful. Having virtual appearances has been wonderful because it has allowed more access to litigants. Having community centers where litigants can go and use their computers to file petitions and to access the court system has been helpful. I know we're doing that in the 3rd Judicial District. It's been done in the 9th. And those are the kinds of things that we are doing within the family court system to help with some of the issues that we've heard about, that we've encountered, even that were reported by the Franklin Williams Commission in their report on the New York City family courts. And so we don't work in a vacuum. We need the help of all branches of government, the 3 branches, to work together to do what we cannot, to provide the funding and the resources that we can't certainly provide. And that's why we're glad that you've convened this hearing and have allowed us the opportunity to speak.
Well, thank you.
You're welcome.
Senator Brisport.
Yes, thank you so much. I can't overstate how grateful we are that you took the time to join us at the hearing today and both share your experience and your expertise. Both of you, Judge Jolly, thank you for having myself and my team come visit family court in September. Definitely don't doubt that judges such as yourself face incredibly complicated and difficult decisions and have a very tough job, and even admit that we haven't made your job any easier with some of the laws that we've passed or the lack of funding to make sure you have the resources to do your jobs effectively. I wanted to start by just talking about translation services and ways you think we might be able to improve it. I did witness a case when I visited where there was a mother who needed translation services and at one point was asked a double negative question, and I don't speak the language that it was translated into, but it seemed like she contradicted herself when answering the double negative question, and it just seemed like a translation error. And it didn't seem like she had a chance to have the question fully translated for her. So I was just curious if you could just share more about any problems you see the court facing when it comes to translation and what resources might be needed in order to make sure we have adequate, translation services.
Well, I think it's a statewide challenge in that
Yeah.
we don't have a sufficient number of staff interpreters. We rely heavily right now on per diem interpreters, and we also access and use the Language Line telephonic translation service. And our Office of Language Access is reaching out and trying to reestablish internships. I don't know where the shortage and why there is a shortage of such a critical need. It, again, causes delay, right? If someone doesn't understand what is going on and we can't understand them, we have to wait. We've been working, I have to say, since the pandemic. There have been some positive things that have come out of the pandemic, if I can say that, in that we are sharing resources statewide, right? Typically, before the pandemic, you rely on the resources in your court, but we've expanded. We reach out to the Office of Language Access, and people assist us in translating from various locations, so we use the technology that we have. We need more interpreters in our court system. There's no question. Was the person represented by counsel or not? Yes,
Yeah.
okay. I find when we have interpreters, we just have to go at a slower pace, which is necessary to make sure there's complete comprehension. So there's a need for more interpreters. The money needs to be, I don't know where that comes from. Reaching out, our Office of Language Access is reaching out to schools where people are learning the skill and the trade, trying to have internship programs where they come, observe, and see what this is like, and they can come up through that way, like in a mentorship type program. But there's a shortage. I feel like there's a shortage of a lot of necessary and critical resources throughout, not just New York.
Thank you, Judge Charlie.
You're welcome.
Thank you. And just wanted to say, Judge Rivera, I think your new role is indicative of the new day at OCA as it pertains to family court. So I appreciate that. That you've inherited a crisis. You're dealing with families in crisis, but the family court itself, as multiple reports have stated, is in crisis. And I just wanted to know if you accept the findings of the Williams Commission report.
Not all of the findings. I think there are some findings in which I would have appreciated some feedback. There are complaints contained within the report that people are yelled at and screamed. I would have appreciated knowing, tell me when, I can check the FTR, go back and read the transcript, and do our investigations, which we do. We have systems in place when people are dissatisfied when they're on the receiving end. I'm talking about New York City.
Yeah.
Right? So if there were, you know what?
So
I'm
you
going
don't
to take a
accept
step.
all-
I'm going to
okay,
take
go
a
on.
step back. Some of the findings, yes. There are some conditions within our courts, beyond our control, beyond OCA, where the conditions are unacceptable. There is no question. I don't want to say that I don't accept all of the findings. There are real issues that are raised in the report.
Everything from bias on the part of judges, disrespect toward litigants, physical plant problems.
I can agree to the physical conditions. I cannot agree that wholesale all of our jurists,
Yep.
right, are disrespectful. I cannot wholesale say that everyone is getting yelled at. We receive reports and letters from people who do
understand.
actually commend the way that they were treated. And I think there was a woman on the panel who said she wasn't yelled at and screamed at. So universally, I
No.
can't accept that,
I agree.
at least for the city, and I think for the state. There are systems in place, cases.
Is there bias training? Is it still in place? You mentioned that
It's mandatory.
and it's ongoing.
It's ongoing,
Okay.
and it's mandatory. If
And
people
what-
don't participate, we receive notification that they haven't submitted their certificate of completion.
Right. Is one of the report recommendations was for ongoing monitoring and feedback in the courtroom. Is that still happening, or has that happened, to your knowledge?
We have an open court. I told Senator Brisport when he came, and your staff when he came, you don't need our invitation, right? We don't need to walk you around. People are free to come to the open court that family court is. The ongoing monitoring is we have supervising judges who monitor and receive complaints. Because I can't say anyone's exempt from receiving complaints. Some are legitimate, and some are investigated, and they're people's perceptions, and that
But the report
necessarily.
said that judges generally do not receive any feedback about their courtroom demeanor or behavior until they're seeking reappointment. Do you accept that statement in the Williams report?
Well, I'm only talking about New York City.
Yes.
Our
is the report.
our supervising judges meet with various agency heads on a regular basis, and they have relationships with those agency heads. Those agency heads are not shy in identifying concerns or issues regarding their observations of how a judge is engaged, and they tell our supervising judges, and we follow up. So
One of
there
the
is ongoing-
recommendations was that a system be implemented whereby judges and non-judicial court personnel are regularly observed in the courtroom by their colleagues and supervisors or independent court watchers to observe the treatment of court users. Is that something you'd consider?
Yes.
Okay. Well, thank you. I'll turn it over to Senator Ramos for 3 minutes.
Thank you, Senator Hoylman Siegel. Good morning. I
morning.
have lots of questions, so I'm
Okay.
going to try and go as
We might do
quickly
a
as
second round,
possible.
just to be-
I'm great. Put me down. All right. So I'd like to ask what training are judges required to take on domestic violence issues and effects of DV, family dynamics, and custody agreements?
So the judges that are presiding over domestic violence parts are specifically trained. In 2017, in Albany County Family Court, they created a domestic violence part, and the administrative judge appointed me to preside over that. And I was sent to get trained on domestic violence, and it's ongoing, it's continuous. And because I do the IDV part in Supreme Court, I'm continuously trained on that.
Does the training include any acknowledgement of what's called DARVO, which is deny, attack, reverse victim, and offender?
There is training on that as well.
Okay.
Yes.
Question about the virtual hearings. I noticed there are no accommodations for deaf people and people with other disabilities in virtual hearings. Have you guys given any thought to helping those who might have disabilities?
Well, I can share one experience that I personally had in Albany. We did have to do virtual hearings, and this was during COVID. We had someone who needed a sign language interpreter, and so we made sure that the camera was visible, that they could see the person. I asked, if they were able to see and to know and to hear, or not to hear, but to understand what was being interpreted. So I took extra precautions, but we did make sure that they had someone virtually that they could see and could see them to help with that.
Thank you. I want to quickly ask you about child support. In New York, child support is based on the CSSA, and unbelievably, Florida, of all states, has a completely different model that actually follows the income shares model, that actually allows the trier of fact to order payment of child support, which varies from the guideline amount after considering relevant factors, including the needs of the children or the child, age, station in life, and other expenses. Have you given any thought to having a better child support model, which is desperately needed in New York? And I say that as someone who pays child support.
So, Senator Ramos, I can tell you this much, that magistrates now are allowed to consider issuing orders that are based on the needs of the child and not entirely on the income. They can deviate from what the CSSA requires based on some of that, including based on the shared parenting, because some households, they share physical custody of the child. And so there are some deviations. I'm not wholly familiar with the Florida method, so I can't speak to that. But I can say the magistrates now are allowed to consider the needs of the child and the expenses, especially when they don't have access to the incomes of both parties.
Thank you. I'll be back.
Thank you, Senator Ramos. Senator Skoufis for 3 minutes.
Thank you, Chair, and thanks to you both for your testimony as well as your expertise. My understanding is that there have been, since 2016, 24 child homicides that have taken place while a custody fight was ongoing in family court. Certainly you heard the last panel and the horrible lived experience that they all had. We've all heard lots of other stories, including from constituents. And so my first question is, do you believe that there needs to be greater accountability for judges that put children in dangerous environments? Let me acknowledge, of course, that some of those 24 homicides are not the result of anything the judges could have avoided, but many parents, many of those 24 parents, allege that they raised red flags, they raised warnings, whether they be DV related, child abuse related, that were summarily ignored. Do you think there needs to be greater accountability for those judges in those instances?
Sorry, if you could just explain to me what you mean by accountability.
I leave that open-ended to you. Do you think there is enough accountability currently? And if not, what do you see as being sufficient accountability?
So I understand where Judge Jolly was coming from when she asked that question, because the presumption is that the judge was actually responsible for the outcome. You know, as we mentioned before, we as judges, we're courts, right? We're courts. We hear facts, we hear arguments from attorneys. We rely on the information that we're given as judges in handling a myriad of cases and in making decisions that are not often very easy to make, and the most often aren't very easy to make. And so I can understand why Judge Jolly, and I agree with her, said, well, what do you mean by accountability? Because the court is not always responsible for the outcome.
In cases of what most people would deem as negligence, in those circumstances that I touched on, what accountability does exist for those judges?
So there's always the appellate review process. You know, lawyers, and they often do it, can file motions, they can state proceedings, they can ask for reversals. There's always that appellate process. We hold hearings.
How long does that process typically take?
It all depends. You know, they can request.
It's not days, certainly, right? And in the meantime, visitations are happening, and again, potentially children are being put into dangerous environments. It's a long process, no?
It all depends. You can request a stay, and a stay can be granted that same day. So it doesn't necessarily take a long time. It all depends on the request being made by attorneys.
Okay, I appreciate it. My time's up. Thank you.
Thank you, Senator Skoufis. Senator Bailey for 3 minutes.
Thank you, Mr. Chairman. Just to piggyback off of that question, is that a function, that delay, is that a function of an under-resourced court? When you're talking about sometimes there may be delays in being able to make a determination of whether it's accountability or in what center, is that a function of an under-resourced court?
It often depends.
Okay.
You know, for example, a removal hearing is considered an emergency, and if a child is being removed or sought to be removed from a parent's home, they have a right to a hearing. That is done that day. And I know in our court in Albany, we have duty judges who are on duty every single day who would hear those matters. And they don't always go to hearing, but there is that right.
You know, and in custody matters, we're dealing with two civilians, two individuals who are presenting evidence and information to the court. We are not investigators as judges, right? We receive the information that is presented to us. We receive information that is presented to us, and we make the best decision. There are a lot of things that the judges are processing in trying to make the appropriate decisions. And I think what should be acknowledged is that the judge can't predict future behavior. And I think by virtue of the question, we're being told, I think, that the judge should be responsible for the behavior.
No, that wasn't my question. I wasn't
Okay.
commenting on outcomes.
Okay.
I understand that it's based upon the totality of circumstances. I'm an attorney myself. I understand
Yeah.
the process. What I'm asking is that predicated upon an under-resourced court?
I say that it's lack of resources for the parties who have to appear before the court. Yes.
Okay, excellent.
In
So
that sense.
I only have a couple more minutes. Sorry, Judge
Yes.
Jolly, I just want to get to a couple things. Infrastructure. Bronx Family Court is literally falling apart. I was there with you
Yes.
recently. I would hope that we're doing something about Bronx Family Court in terms of expending the resources to it so that it is somewhere that is a reasonable place to have anything taking place. But there was a point that I wanted to make about law departments. In Civil Supreme, there's often a law department, like a pool of attorneys that that judges can go to. Does that currently exist in the family court?
In New York City, we have been approved for a quasi-law department. We're in the process of hiring additional lawyers to support us, to support the volume, right? The tremendous volume. Typically, it's been one judge, one court attorney.
Yeah,
We've
because
been
in
approved-
Supreme you have 2 law clerks and you have a law department, and so there's a lot more help there. So I'm just hoping that there's something that we can do to make sure that there's a necessary attention being paid to that. And I know I know our chief judge is paying attention to it because
Yeah.
one of his first public appearances was in fact sitting in family court. So I know the chief judge is paying attention.
Yes.
Last thing I want to say during my time is we spoke about 18B. I was happy to be the sponsor of that bill. I know you can't recruit per se, but what is being done to try to encourage? What is OCA being able to do to gently encourage? I would say the application of more attorneys back to the panel now that there is a more reasonable, more livable wage.
So I am chair of the statewide advisory committee for attorneys for children. And we meet and just had a meeting maybe a couple of weeks ago, and we've been putting our heads together, strategizing, trying to figure out how to expand, how to introduce people to family court, explain to them it's not what you think it is, because some of you haven't been to the family court. I think we have to convey to people, come see what's going on in the family court, because people have a perception about family court, don't understand the value and the importance of the work that they can do to support the parents. So we have to work differently with the law schools, right, and do clinics, internships, all of that. So that's what we're doing, and I think we'll be doing that with Judge Rivera in his capacity.
Absolutely. And every chance I get, whenever I speak to lawyers and law students, when I go to law schools, I encourage people to come to family court. Too many attorneys shy away from it, and especially bilingual attorneys, because if you can't get an interpreter, at the very least, if you have an attorney who can speak the language of the person that they're representing, that's tremendously helpful.
All right, I thank you both for your time. Thank you.
You're welcome.
Could I just say, the statistic in one of the reports showed that over 80% of litigants are unrepresented in family court. Has the 18B increase had any impact on that percentage that you know of?
Not yet.
And then the
Not
other-
yet. They're working. I'll say that those who are running the first and second department are actively reaching out, having meet and greets, and trying to encourage people to find out more about what they can do and contribute, how they can contribute. That I'm aware of.
Thank you.
But it
Thank you.
hasn't yet significantly changed.
Thank you, Senator Bailey. Senator Liu. I said Liu.
Thank you, Mr. Chairman. I'll preface my comments by saying that the nature of these kinds of hearings is that people who are totally happy with what's happening, they don't come to these hearings. So I understand this is not a symmetrical situation we're dealing with here. And I say that because, as on a number of occasions while the both of you were speaking, we see heads about to fall off because they're being shaken so violently right behind you,
Right.
presumably in disagreement.
Understood.
So, I guess my main question for you is, the Williams Commission did come up with a dozen recommendations. Senator Hoylman Siegel addressed addressed many of these.
Yeah.
And the sense I get from both of you as representatives of the Office of Court Administration is that you just need more money and resources.
No.
But there's not, these recommendations beyond the more money, resources, and the improvement of the physical infrastructure of the courts, you didn't seem to agree with the recommendation for observation and feedback.
I said
The
yes.
observation that
I say yes. I said yes.
I-
Okay.
it's okay. So would you agree that something needs to be done to address the dehumanizing culture that exists in family court?
So we have started our training as it relates to bias. It's not a one and done. The ongoing conversations have to continue. It's incorporated into every single conversation we have when we interview individuals who want to come work within our court. We have equal justice committees in each of our courts and districts. We recognize that there was this sense. I cannot deny it. I've been in the court system for more than 32 years in family court. I know what it was like. I know how it was like when I was an attorney and stopped at the door by an officer and said, sit down and wait outside for your lawyer. So I can't deny what has in the report. I'm not denying that. What I'm saying is that we are making changes, but it's not going to happen overnight, right? But there's an expectation that we have of every single person who works in our court that they are accountable, right? And we've had our previous Inspector General for Bias Matters, who is now our Inspector General in New York City. She came and met with all of our staff as well as advocates and agencies to talk about, if you see this going on, this is how you report it. We have put ourselves out there clearly and plainly. If there is a problem and you see it, raise it. If you're not getting a response from my supervising judges, and they are very responsive, then come to me. Everyone here is accountable. I recognize, and I agree. I shouldn't have wholesale said I disagree with the recommendations. There are many recommendations I agree with. There was a recommendation that there be signage in the courthouse that explains to the individuals, court users, what their responsibility, what the expectations are they should receive, how they should be treated, and what their obligations are. That's a wonderful recommendation. It is posted throughout our courthouses. It's online. There's digital signage that includes that. There is work that needs to be done. I cannot disregard it. But I, personally, I do take offense at this blanket statement that we create and foster a dehumanizing experience. It's not what we do. There are conditions where it's logical to say, this is not appropriate, right? This is not acceptable for people who come through our doors or people who work in our courts to experience. I don't deny that.
I mean, I thank you very much for that explanation, and I take it to heart what you're saying, but the Williams Commission did study this at length. Judge Rivera was part of that commission, actually, I think the chair or the co-chair at some point, and it says address and eliminate the dehumanizing culture that exists in family court.
And we are doing that, but it's not going to happen overnight. It's not going to happen overnight, right? People are people.
Just a very, very quick question, because I think you had mentioned that the proceedings are open, meaning open to the public?
The courthouse is open, yes.
Okay. I mean, I've been to family court hearings, and they've been closed. I've literally been to hearings where they've been closed.
I'm telling you.
And I was an elected official, so I was allowed to come in, but they were closed.
So I can tell you, Senator, that obviously it is an open courtroom, but the litigants within each and every case do have a right to privacy, and sometimes there's a request from the people who are involved in the case that we have to consider. But it is an open court, and certainly you can report it if anybody is excluded to the judge, if they're being excluded. And I've had...
Thank you very much. Thank you, Senator
Mr.
Lee.
Chairman.
Thank you. He always brings cheers wherever he goes. Senator Mayer for 3 minutes.
Cheers or jeers. So, first place, thank you, Judge Wilson, for hearing us during the proceedings in which you were confirmed that family court was one of the most important and underappreciated part of the system that needed significant overhaul. So, and I appreciate you appointing Judge Rivera, but specifically on a few things. On the opening of the courtroom, since you've become in charge of all the family courts, has there been a specific written directive to every family court judge that unless requested otherwise, the courtroom is open, and that's to go to the bailiff, to the court officers, and to everyone else? And if there isn't, that hasn't been done, I strongly suggest that be done. So,
Okay, if we could hold any applause, thank you very much.
yeah, has that? Do you know if that's been done or will be done?
Is it Rule 205? Rule 205.7 clearly states that 205.5, I apologize, that all of our courthouses are open. They are open to the public for filing cases. The public is welcome to observe in-person proceedings. I can tell you there are requests by individuals who are participating in cases who the links are sent so that their supporters and their friends, whoever they want, also
Respectfully, though,
participate.
there is a culture, as someone who practiced in family court, of each individual court, and the culture of family court is that the court is closed unless someone is pushy enough to insist under that rule. So I'm asking whether you can take some steps to ensure that court is open, litigants know, and all the other employees of the court system know that the door is open unless there is an affirmative decision otherwise.
That is certainly something, Senator, we can look into
Okay,
and do.
thank you, I
yes.
appreciate it. Secondly, do you know, and I know you're new to this, the average length of time between the filing of a custody petition and the determination or an actual hearing as opposed to a court's decision? What is the average length of time statewide between the filing of a custody petition and a hearing on the determination of custody, if there is one?
I don't know, Senator, the average, but that's something certainly we can look into and get back to you on.
I'd appreciate that. The delay in having an actual evidentiary hearing for many women is the most offensive part of the proceeding, and so I would encourage that. Thirdly, what time does family court end as a generally and as a statewide matter? Is it 4:30?
So, Senator, generally our courts are open until 5. I know that for emergency applications, I've been there till 6, 7.
No, I
during
understand you have,
emergencies.
yes, but the courts generally close at 4:30 or 5. Is that correct? Is that I believe that's correct.
I
Yeah,
think
I
that's
think
fair.
that's fair.
Yes. Lastly, is family court open on Sunday in any jurisdictions?
No.
Do you think that is a wise thing that would make a difference for people seeking emergency relief?
Well, the problem with that, Senator, is that obviously it's going to require the building being open, which requires court officers, which
Understood.
requires staff. So it is a matter of funding. Obviously, it's something that would have to be considered and taken into account. But for family offense matters, litigants can go to a criminal court to get an order of protection, a
Yes,
family court order of
understood.
protection.
If
So
the-
even if the family court is not open, there is recourse.
If the criminal court is open on Sunday, which is not the case in every place. So, okay, thank you, appreciate it.
Thank you, Senator Mayer, and thank you, Senator Mayer, for suggesting that there should be some benchmarks that we as legislators could see your progress that I'm confident you'll be making over the next months and years to fix this court. So that would be something I think we could discuss with you, including caseload and backlog. Which, by the way, do you have any sense of that at this point? Do you have any statistics in that regard?
There is a dashboard that is easily accessible, and it's transparent. If you go to the OCA website, and there's a to Z tab, press it, then go to data, and it publishes on a regular basis what the pending caseloads are.
Do you know
as
that
they're-
number for us?
3, hold on 1 second, I'm going to tell you. As of the 8th of this month, the filings were 381,956, and the dispositions were 380,000 with 346. 380,346. The number of cases that were disposed of, which reflects that we completed almost as many cases as were filed for the year as of October 8th.
Thank you.
You're welcome.
Next we have Senator Rollison.
Thank you, Mr. Chairman. I appreciate the opportunity, and I appreciate the first panel too. Got here a couple minutes late, but thank you for your input and testimony. As it relates to 18B, and we heard from a resident of Rockland County who said that she's been denied an attorney within the Rockland County family court system. So currently, as she said, she has no attorney, which obviously limits her ability and the court's ability to come to some resolution in that case. Is that possible? I mean, is it possible for someone to be in the system without a judge under those circumstances?
Well, I have to say, Senator, that because that's her experience, then technically the answer is yes, that's possible. But there are guidelines that the courts do use to determine who is eligible for an 18B attorney. And so, I mean, that's the best that I can say. So it is possible.
So, and that's the lead up to my next question, Judge, is does it make sense at this point, and I don't know the last time it was reviewed, to expand that list of eligibility? I know obviously 18B has been difficult to recruit, retain because of the pay, but also if you have individuals that are not qualifying, do you revisit that from time to time on who would qualify for 18B?
It should. You know, there's some leeway that judges might have because we do ask for information like what's your debt, And so your income may look like you earned a lot of money, but you might have a lot of debt that does not allow you to afford a private attorney, and that often happens. So there is some leeway, but yeah, obviously an expansion is always helpful. Just like also expanding it to cover other types of cases, because there is no right to counsel if you're filing for child support, no right to 18B attorneys, no right to a public defender. I shouldn't say no right to counsel. So if they can't afford one, the court can't assign someone on child support matters, with exceptions.
Okay, and just I'll end with this, on the visitation. I know in my time when I was a member of the Dutchess County Legislature, it was a hot topic. Funding was an issue, where they were going to meet and have the supervised visitation, and I think it was discussed that possibly family members could be involved, but I know that the judges need those observations to make determinations on custody, and they're tough, and I don't believe that there is essentially every county has visitation. Am I correct in that assumption?
You're correct.
That is correct.
So, and in the last couple of seconds that I have, what would be your recommendation to the state legislature to say that has to happen? Because that is certainly a cog in the system. If you can't have people seeing visitation between two individuals and they have to make that decision, I would just appreciate just a quick thought on that.
One of our thoughts and recommendations on that is providing funding so that there's at least one place in every county. At least one, and I say it that way because there are some rural areas where, the distance between where people live and the family court is substantial, and so you have to figure out where is the best location to have a supervising visitation center, so we may need more than one, but at the very least one, so that is available to the court.
Thank you both.
Just a quick question before we move on to Senator Palumbo. Has OCA estimated just how many additional court judges you think you would need to be fully staffed?
We do have in place, and in fact, Judge Jolly and I are both part of a team that was put on by Chief Judge Wilson to provide a tool, a mechanism for giving you answers to that, more specific answers, because it varies depending on where in the state you are. And that should be happening shortly.
Okay, thank you. Senator Palumbo?
Thank you, Senator. Good afternoon. With the implementation of Zoom and through COVID now, do you think that virtual appearances have actually helped to an extent to kind of clean up the backlog?
They have in many ways. We talked about language access, interpreters, and that has helped a lot.
Using the language line, and I've practiced.
Not language line, but using Zoom to have New York City, people who have languages that we don't have in upstate New York. We can get them from New York City or other places, and they can appear by Zoom. But also in some of our rural areas, having people appear for court appearances by Teams. We don't use Zoom, we use Teams in the court system. That's been helpful.
We've also noticed that in child support matters, where prior to the pandemic, there was a higher rate of either non-appearance or inappropriate orders being issued because there was a lack of participation by the non-custodial parent. There's been an increase in participation and fewer default orders being issued, which then results in fewer orders, maybe suspending licenses or requests for incarceration. So there's been a certain benefit. We first felt it anecdotally, and then the data reflects it.
Right, bringing them back without prejudice, bringing them back again, and all of those
And people have anxiety about coming into the courthouse, right? And so they feel a little safer as well participating by teens.
Yeah, that's a very good point. And I'm sorry, I'm kind of trying to move quick. I have one other topic I want to address. But I've seen that having practiced and still practicing to an extent. You have some magistrates, referees, and judges on Long Island who won't do virtual.
Oh.
They say, no, too bad. You have to do that. And as we said earlier about the dehumanizing aspects of family court, and you don't want to use those words, but even as a lawyer, sometimes you'd roll your eyes and say, all right, I have to clear my morning so I can be there Thursday because I could be called at 9:45 or 12:15. I have an entire day just sitting there because you do have a lot of pro se litigants and you have just all these burdens. And then when you finally get, okay, judge, we're ready for hearing, pick a trial date. How's October 25th? Counsel, you're not available. Oh, AFC, attorney for the child, you're not available. Okay, well, I only have December now.
Right.
So this goes back to my other point, and this is my last comment and then a quick response from you folks, is resources. When I say resources, It's about volume issues. If we could address them quickly, and really my question is there a way we could slice out again? Because we have support magistrates who hear support. Okay, great. Now we have custody and neglect, though, all piled in, having to do with closures of the court. If it's a neglect proceeding, or rather, if it's a juvenile proceeding, you have an underage person who's accused of a crime, that obviously is going to be a closed courtroom. But even with the custody versus neglect, some of those are more priority than others, versus a regular visitation, temporary order situation versus a danger to the child situation. So I think about, like in the Supreme Court, do you think maybe a trial assignment part would be the way to go? That if somebody's ready to go, instead of having to come back to that judge who's available for 4 days in the next 3 months, and you're going to have to scatter the trial, to say, we're going to tap you out, go down the hall, and whatever judge is available, you guys are starting Monday. Good luck.
And if we had more attorneys representing the parents, it would be something that we could do, right? Because it's not just a creation of more judge parts, right? And having the resources
and
to,
you need
to
good
go.
lawyers. And
We
Senator
need-
Bailey was a big advocate of that.
Right,
and I
we
was
need
on
the
board as
lawyers
well. I'm
because-
glad we've increased the rates. I'm sorry to cut you off.
No, we appreciate it. But if we were to pull those lawyers away from the work that they had to do for 4 straight days to finish, 1 or 2 trials, what would happen with their other cases? We have attorneys who are solo practitioners who are not working with other colleagues who can, like a firm, right? So who's going to cover those cases for them? It's a challenge.
And in some cases, sorry, Jen.
That's okay.
And in some instances, it's a matter of space, where to actually have a separate, because every courtroom is being used, we would need an additional courtroom for a trial part.
Speaking of, thank you.
Thank you.
Thank you, Senator Pomo. Speaking of pro se litigants, are you looking at the forms that you have on your website? Another recommendation of one of the multiple reports to better inform the self-represented litigant on how to do so? Because there was some suggestion that the forms are not very helpful at this point.
Yeah. So one of the charges, one of the things that are being undertaken at this time is changing the website, and that is one of the recommendations of the Williams Commission, and also, I'm not sure if the Jay Johnson report recommended it, that there has to be this overhaul of the website, and clearly that means the content as well, and the information we make available. So that's being undertaken now, and yes, there's been a lot of talk, and the next steps have to be changing the forms so they're more user-friendly, maybe fillable for the individuals who don't have the technology.
When do you think that overhaul of the website will be completed?
I don't know, but let me get the answer back to you.
But it's underway.
Yes.
Okay. 3 minutes for Senator Rhodes.
Thank you so much, Mr. Chairman. Senator Palumbo actually asked, touched on the same topic that I wanted to touch upon. But the statistic that the Chairman Hoyman Siegel indicated was that 80% roughly, and it seems as though that's the case, that 80% of the litigants in family court are unrepresented. Is that accurate?
Well, I want to say this. We do have, it may be accurate that it's 80%, but unrepresented meaning that they come in without an attorney. And I'm not sure if that number reflects those that haven't been assigned attorneys after they requested one. So in other words, we have a lot of litigants that come to family court without attorneys, mostly because they cannot afford one. But I know that we advise them of their right. We give them the applications for court-appointed attorneys when they want one. Not everyone wants an attorney. Some people actually say, I can represent myself.
Okay. It does underscore one of the Williams Commission's recommendations, which was the fact that there be uniformity with respect to many of the procedures that individual judges use. Specifically with respect to to access to virtual proceedings, I think was the actual recommendation. But even with respect to the evidentiary rules that are used, both in virtual proceedings and in court, if you have that large a number, and I've never practiced, I am an attorney, but I've never practiced in family court myself, it's confusing sometimes for attorneys to know all of the rules of procedure. When you have pro se litigants that are trying to navigate their way through a process, what steps does the court take to try and educate litigants as to the rules of procedure? I don't mean what proper decorum is or what proper dress for the courtroom is, but actually how do they avail themselves of the system? What are the rules under which the court operates, so that they can understand and effectively represent themselves if you have that large a number of unrepresented people?
So we have clerical staff who virtually, and I think in New York City, I can't speak for outside the city, we have clerical staff who answer the questions of individuals, and by law, we cannot. If somebody wants to come in and file a petition, we have to help them write that petition, or they submit the petition on their own, whether it's a facially sufficient petition or not, whether they're in the right court or not, because our clerical staff cannot turn anyone away. So sometimes the petition gets to a judge, a jurist, and there's this recognition like, you're in the wrong court, right? And so that's a challenge. There are various agencies that do provide some guidance and advice, and they volunteer and they help and answer questions. We have help centers in our courthouses. We have a volunteer attorney program that is run by one of our attorneys, Angela Britton, who really helped navigate and assist us during the pandemic and helped individuals avail themselves. So there are attorneys from law firms who are trained to assist individuals and answer their questions and help them navigate. I do think there needs to be more in the community, but we do also plan, once the website is revamped, that'll happen with every court, that we will do a better job in putting information on the website so that people who are able to access and use technology will have that. We have people who are answering the phones all the time. Their jobs kind of change as a result of the pandemic because people weren't coming to the courthouse. So we have people who are now just answering the phones and answering questions. So a lot of resources have been shifted in that sense.
Thank you for your answer. I see my time is up.
Thank you, Senator Rhodes. If the Sergeant at Arms could make sure that folks are seated, that would be appreciated, because it's a little distracting when individuals are standing. And there is an overflow room as well, in case somebody would like to sit. Next, we'll have a second round of questioning, if that is okay with our witnesses.
Yes.
Beginning with Senator Ramos.
Thank you. I wanted to follow up on our child support discussion. I wanted to get some clarity because you gave me the impression, Judge Rivera, that a judge has discretion over how much child support to set in a case. And I'm also not an attorney, but it's my understanding that the statute currently does not provide for a deviation. So I'm wondering what facts or evidence may be considered for a deviation from the CSSA formula.
As I mentioned before, one of those factors is the amount of time that the child spends with each parent. And in fact, a lot of people think that because you have joint custody that you don't have to pay child support.
Someone always has to pay.
Right. But the judge can consider the amount of time that the child spends in each household, compare the income, and make appropriate adjustments.
But by definition, the parent who spends less time with their child is the one who pays child support.
Often.
Most often.
Right. And I don't know that it's a perfect system, and
it's
trust
not.
me, the litigants, have a tough time understanding that, especially when they're unrepresented. And they often get frustrated because they don't always get what they think that they should.
I think
on
overall
the
it's
one
just that
hand.
the cost of living in New York is very high, and so if you're giving money to the other parent, especially when you see that the other parent doesn't spend that money on the child directly necessarily, and then that takes away money that you can be spending on your child when you have them, it stirs up a lot of feelings.
Yeah, it does. I used to hear it all the time.
Okay.
Still do as a judge.
My other question is actually about a bill I carry, which is called the Promoting Pretrial Stability Act. It's essentially to codify the Crawford decision from the First Department, which would require that a hearing be held in cases where families are separated as a result of a criminal court order of protection. Yet some judges in New York City are denying requests for Crawford hearings, saying that families should just go to family court. Does OCA intend to provide further guidance of the issue, and would you be supportive of codifying the Crawford decision?
So I'm sorry, explain to me one more time what the proposed legislation is?
Sure. So it's essentially to codify the Crawford decision. It was a First Department case
Yes.
that requires that a hearing be held at the request of the defense in cases where families are separated as a result of a criminal court order of protection.
The
What
impact
we're
on
seeing is that some judges in New York City, I don't know about the other cities, are denying requests for Crawford hearings, saying that folks should just go to family court.
And so I guess I can't speak for criminal court, right? You're talking, this is an issue. I was trying to understand what direction you're asking come from OCA as it relates to the family court. Because we do face that challenge where people
Well, would that be
come-
helpful? Would you support codifying that decision? Do you want
know,
to keep it in
but-
criminal court? Do you think it should just all be referred to family court?
Well, what are the attorneys doing on the cases who represent these individuals?
I guess I'm not sure.
Right, I don't, it's a difficult question for me to answer right now, so I need some more time to think about it.
Okay. I'll follow up.
Okay.
Thank you. And before we move on, I just want to say if you are recording, you're totally in your right to record. I do just want to flag that the session is being recorded by multiple cameras in the room and being streamed on the Senate website. And if you are recording, if you could just turn the light off on your phone, please. Thank you. I would like to pass it on to Senator Skoufis.
Thank you, Chair. I'd love to follow up on a question that was asked much earlier by one of my colleagues about domestic violence training of judges. And Judge Rivera, correct me if I'm wrong, I think I heard you when asked the question, refer to a DV part that is up in, I guess, Albany County Family Court. My first question would be, how common is that? How many family courts have a DV part to them?
I don't know how common that is, Senator. I can't say.
Is it fair to say that the majority do not have a DV part?
I don't know. You know, and that's certainly one of the things in my new role that I'm going to look into. I don't know, so I can't say whether it's fair to say or not.
Okay. I had never heard of there being a DV part to a family court, so my assumption is that it is not common, but I could be wrong in that assumption.
Well, I can tell you, Senator, that the reason why it was created in Albany is because Albany County did not have an IDV part in Supreme Court.
Yeah.
And to address the
Understood.
issue of domestic violence and intimate partner violence, our administrative judge created that part.
So for those family courts that do not have a DV part component to them, is domestic violence, and I'll also throw in child abuse, a mandated training for those judges?
So, Senator, our judges are receive training. In fact, the minute you are elected or
I understand they
appointed-
receive training, but is there a exclusive, a specific training related to domestic violence and child abuse that these judges that are not part of some DV component required to receive?
I want to just make sure I'm getting the correct citation, but judges are required to participate. Thank you, Jan. Rule 17.4 of the Rules of the Chief Administrative Judge, they are required to participate in that specific training. Yes.
For domestic violence?
Yes.
And child abuse?
It's domestic violence, but every single judge who addresses and handles abuse Article 10 cases, they receive training. I don't know, I don't think it's in the chief judge's rules, but in New York City, they have to participate in the training. You can't jump in and not know anything about this, so we have
And what about New York
training.
State? I
don't-
represent
Yeah, I'm not
the
sure.
Hudson
Judge
Valley, so
Rivera doesn't know
I'm
yet, is
certainly
what
more
he
interested.
indicated.
Yeah.
Yeah, but no, what Judge Jolly said is true. Every judge, especially if you're going to be sitting in a domestic violence part or in family court, goes through that training, Senator. Because those are the issues that we handle.
So when you say that training, I'm just
training on
sorry
domestic
to drill in
violence,
here.
it's
Yeah.
training on domestic violence, training on Article
But
10
is it part of?
matters.
And I'm a layperson here, so pardon me, but I think you'll get my point. When you say it's part of that training, I know that there is a general training that all of these judges must receive, and so when you say is it part of that training, is it a 100 slide PowerPoint deck, and this is one or two slides of that 100 slide PowerPoint deck, or is it a separate course, a separate training that they receive on domestic violence and child abuse?
So it's a full training. It's not a couple of PowerPoints. There's training offered through the Judicial Institute and the Family Violence Task Force. I think, Senator, we had sent you a list of the programs that the Family Violence Task Force has set forth every year, which specifically addresses the issues that relate to domestic violence, intimate partner violence. So that is continuous, it's a requirement, it's ongoing, and it's a day, right? So when people participate in the Family Violence Task Force training, the judicial seminars, Judicial Institute seminars are hours. And then locally, there's training that's provided in each of the courts, and the districts do that. And some of the programs are recorded for us in case we're not able to participate. There are lunch and learns. There's always ongoing training that we offer.
I appreciate that. I know my time's up. I'm just trying to reconcile here, because I know that there is legislation out there that would mandate specific training to DV, and OCA opposes it, and your arguments that you're sharing here have not come up, and so I'd love to discuss this further offline. Thank you.
Thank you. And next up is Senator Bailey.
Thank you. Again, don't mean to alley-oop. I'm just going to ask another question about that training. As attorneys, in order to recertify every couple of years, we have to do our CLEs. It's like in certain areas of import as things develop. Like, for example, e-discovery didn't exist in 2009 at the rate that it was when I entered law school. But in 2012, once I graduated, e-discovery was much more was happening much more. Are there CLE-like opportunities for judges in these very specific areas of training? Because domestic violence changes, stalking changes with the proliferation of social media. Are some of those updates, are those incorporated in some of the updated training?
Yes.
So to the other question about to your point again, I just want to affirm some of your points, Judge Jelly, about the fact that I do know a great deal of family court judges who do really care about this, and they've reached out to me about this hearing, and that they just want the resource so that they can do their job better. You mentioned something in relation to administrative judges having conversations with other agency heads, right? Is there another conversation? Is there a conversation that we can have about these root cause issues? Because the panel before you eloquently said that if that front door is wider, right, and if we just have a more open door, what conversations, like in New York, are the ALJs having with ACS, for example, and with other folks? What kind of conversations are happening so that we can try to, cut off some of this stuff before it even gets to the point where it has to be in your jurisdiction at all?
So, since we've begun more than conversations about equal justice and changing the experience and the perceptions of individuals that we have this dehumanizing court, we thought it best to begin the conversations internally, make sure that everyone fully understands. We are trying to figure out how do we now incorporate the voices of the individuals who are impacted, from whom we can learn. So that is a next step. I don't know, how we're going to actually get there, but I think probably we'll rely on maybe some of the lists of people who were witnesses, maybe the organizations that work with individuals who are impacted, because we recognize that in order to make the change that we need to hear their voices. So this is kind of a step in that right direction. But we definitely need to figure out how to do that. We cannot talk about open and pending cases, as we're talking to individuals. And we have to figure out how to do it properly, right? Because individuals are dealing with actual, real emotions and their life experiences. And I think we need someone to help facilitate that conversation. And we've asked Judge Richardson, I've asked Judge Richardson Mendelson, how can we do this? And I think it's something that has to be statewide. So, Judge Rivera.
I think trauma is real, much like the community school model incorporates outside factors in community-based organizations. If we can have a conversation about beginning a community school model, even if it's a pilot in certain areas, statewide, and not just the Bronx. I'm not speaking for the Bronx, but the entire state. We want to make sure that we pilot this, because community school models are real. Because sometimes that parent, that the reason why their kid can't read is because that parent can't read, and sometimes they're too proud to admit that, and they're just going to keep going on in that cycle. I know my time's up. I just want to say to everybody in here, in terms of like what's happened before, it didn't happen under the eyes of Judge Rowan Wilson. So I just want to make sure that we censor that and give this administration the opportunity to move forward and do so positive. Thank you.
Thank you, Senator Bailey. Senator Mayer for 3 minutes.
Thank you, and I just want to echo what Senator Bailey said. I mean, this is the leadership of a new chief judge, and I'm proud that we were part of a group that insisted that this issue be part of the conversation, and your appointment reflects that. Thank you both. I just wondered what your position is on forensic custody evaluations. I know that my colleague, Senator Harcum, has a bill for a moratorium on them pending a review of the state's Blue Ribbon Commission on Forensic Custody Evaluations, which found that there really is not a uniform standard and there are not uniform rules, and yet these individuals have so much discretion and sway over the court's opinion. So I wonder whether you have evaluated that and you have a position on that.
It hasn't been evaluated yet from the whole court perspective. I mean, I have my own personal feelings. I think one of the challenges is there are times when there's a need for an evaluation. I don't think that they should wholesale be ordered on cases. The challenge is finding someone who's qualified, finding an evaluator who's going to complete that in a timely fashion, which is a challenge. By the time you get one, when you need one, it's almost a year, right? Because of the wait list, and then it's old, then it's stale. Then what do you do? Then that builds in more delay and more delay. But I do think that there are times when there's a need for an evaluation, not wholesale, not wholesale.
I understand your position on that, but so I think it would be helpful legislatively as we evaluate these proposals that are going to amend the Family Court Act and other things, to make sure that we hear from you as a presiding judge, and you as someone who has power over this, to give us insights into when you think it's appropriate to limit or what standards would be appropriate. So, but I wonder, Judge, do you have an opinion about that?
So I think that's something, Senator, that we can look into further and certainly give you any position or opinion that we have on that issue. I know as a sitting family court judge, they're not, at least in Albany and upstate, forensics aren't always requested,
Right.
not that often. Most of the time what people want is a mental health evaluation, which is not exactly the same as you know.
No.
And I think, quite frankly, some of those are of better use. We as judges don't always have to order them, even when they're requested. We do have that discretion. But it's something that we would have to get back to you on as far as any recommendations on legislation.
Thank you. I mean, one of the concerns is that the moneyed spouse can request it, and then it delays the actual hearing or determination by the judge with respect to custody, and also poses a financial burden that is a real problem for the litigants. I mean, we are talking about litigants for whom this court is the entry level for the most important decisions of their lives. So I look forward to working with you more collaboratively on legislative efforts.
Thank you, Senator.
Thank you.
Thank you, Senator Mayer. Just again, thank you to the panel and to the Chief Judge who is returning to Albany. We can all relax now. The Chief Judge is no longer in the room. Loosen your tie. Not you, Senator Liu. But thank you again. This was very informative. Look forward to future conversations, and to my colleagues for the excellent questions.
Thank you.
The next panel, we will hear from a number of experts. We have Mary Lynn Nicholas Brewster, the Honorable Judge Brantley, Patricia Warth from the New York State Office of Indigent Legal Services, and Bertina Capuana, the Assistant Chief Deputy County Attorney, Westchester County Attorney's Office. First up will be Judge Brantley. And you will each have 5 minutes. Not at all. Yes. No, we understand. We would not want to create court delays in this hearing.
floor?
Yeah, and I think pull the microphone to it.
Thank you very
Yes.
much.
Welcome.
My remarks started with good morning, but good afternoon. My name is Aisha Brantley, and it is my pleasure to sit in Nassau County Family Court as a family court judge for the past 7 years. I went out on a ledge and left private practice early on and left my well-heeled white shoe law firm in as much as I spent more time with my pro bono clients, much to the firm's chagrin, and decided that my home was in family court in which I could affect families. And so I spent time with the Administration of Children's Services. I was a longstanding court attorney within the New York City family court system, and then finally made my way to Nassau County to break barriers. Unfortunately, only 7 years ago, I was the second jurist of color ever elected to Nassau County Family Court, the first black woman ever to serve in Nassau County Family Court. But I'm pleased to say that in the shattering of that ceiling, there's been a recognition of the need for diversity on the bench outside of the New York courts, and so we're seeing slow change, but it's coming. So with that, I come here in my capacity as president-elect of the New York State Family Court Judges Association. The New York State Family Court Judges Association's membership is comprised of approximately 200 judges, including elected and appointed family court judges, as well as county, civil, criminal, and court of claims judges designated to sit in family courts. It's a tremendous honor and equally humbling to be in a position of such impact in the lives of the litigants, families, and children that we serve. The notion of impact is not lost upon my colleagues and I as we daily don our robes and take the bench with the goal of providing safety, resolution, stability, dignity, and justice to the parties that come before us. In preparing my remarks for today's proceedings, I had the opportunity to review some of the written statements that were submitted for this body's consideration. The submissions contain varied perspectives, experiences, and critiques from individuals who are all clearly passionate about impacting positive change in our family courts. The common refrain remains that family court judges, practitioners, and employees are overworked, under-resourced, and devalued. Despite these trying circumstances, family court judges remain committed to our oath to faithfully discharge the duties of our office to the best of our ability, while silently shouldering the brunt of the derision and cynicism born from systemic deficiencies that are oftentimes beyond our control. The New York State Family Court Judges Association has identified a comprehensive list of changes that we'd like to see implemented in family courts in the coming years. However, similar to many of the recommendations made by participants in these proceedings, the power to implement those changes lies within the authority of the judiciary branch of our government under the leadership of Chief Judge Joan Wilson. Under the leadership of Chief Judge, I have to get that man's name right, Rowan D. Wilson, and his team of distinguished administrative judges. Accordingly, I will confine my statements herein to issues that the New York State Family Court Judges Association would specifically welcome the support of the legislature in curing. First, increased resources for family court partners and service providers. As family court judges, we are tasked with adjudicating matters that serve the best interests of subject children, promote the safety interests of the public, and safeguarding the rights of our litigants. We rely on governing statutes and controlling case law to render interim and final decisions. Oftentimes, our decisions are informed by information and interventions from third-party providers that engage with parties from the initiation of proceeding through disposition to aid litigants in obtaining favorable outcomes. Frequently utilized services that are essential to effectively resolving concerns brought before the court include mental health and forensic evaluations, individual and family counseling, parent training, substance abuse testing and treatment, supervised parenting, anger management, batterers intervention, sex offender assessment and treatment, respite care, gang intervention, parent coordination, and mediation. We also rely on state and county agencies such as the Office of Child and Family Services, county probation departments, and the Department of Social Services and Child Protective Services to conduct investigations, supervise and/or house our youth, and create and implement service plans and furnish reports to the court. Family court judges actually share the frustration of litigants when a matter's timely adjudication is impeded by a lack of available social service resources. Even worse is witnessing litigants abandon proceedings or concede their position because they're being crippled by the financial burden of obtaining necessary services or counsel. Family court litigants would be greatly served by the legislature's prioritization of rebuilding our social services networks and ensuring robust funding of state agencies to attract and retain qualified, competent, and committed individuals to provide services and aid the parties in resolving the issues that brought them before the court. Finally, it'd be great to see an intentional focus on judicial security. It's fair to say that on every matter that comes before family court, there's a party whose life is significantly impacted by the court's decision, and oftentimes there's at least one party, sometimes more, that leaves displeased and feeling personally aggrieved. Unfortunately, because of same, family court judges are at an increased risk of becoming targets of harassment, threats, and physical harm. Throughout my career, I have become immune to the critiques and insults that embittered litigants levy at me, often online. However, I must confess that my defenses have been shaken upon receiving notification of credible threats of physical harm. As judges, we are left to fend for ourselves when it comes to defending ourselves and our family from harm from disgruntled litigants. In recent years, we've seen increased penalties imposed for harming or threatening to harm agents of law enforcement, transit workers, and even airline employees. However, even in the wake of the deadly assassination attempt on New Jersey Judge Esther Salas and the recent assassination of Maryland Judge Andrew Wilkinson just 2 weeks ago, there have been no discernible measures taken to increase penalties for harming or threatening to harm a sitting judge. Further, judges are made vulnerable by the ease with which litigants can procure their personal information and biographical data. Publicly posting and/or sharing personal contact or address information of a judge without his or her express consent should be a strictly prohibitive act and codified according in the law. The court system would also benefit from receiving additional funding to assist judges in having their personal information removed from the internet and public records, as well as hiring additional court officers to provide protection for judges while in the courthouse as well as in the community if necessitated by a judicial threat. While my time before you today was necessarily confined, I enjoyed having the opportunity to address this body. The New York State Family Court Judges Association would welcome continuing a dialogue with your committees on how you can support the work that we have committed our lives to in family court. Further, if you've not had the occasion to do so, I wish to formally extend an invitation for you to come to visit me or any of our association board members in family court and witness us in action to gain a greater sense of what some of our challenges are, but also to bear witness to the satisfactions we experience that bring us back to continue this work day after day and year after year. Thank you.
Thank you, Judge. And just on the issue of personal information, so-called doxing, I am working with Assembly Judiciary Chair Levine on legislation to address that very point.
I'm very pleased to hear that. Thank you.
Next.
So next we also have Mary Lynn Nicholas Brewster.
Good afternoon. Can you hear me?
Good afternoon.
Good afternoon. I am Mary Lynn Nicholas Brewster, the Executive Director of the Franklin H. Williams Judicial Commission, and I just want to thank the senators for hosting this hearing and also for reviewing the commission's report and for taking action by holding this hearing to really address the issues in family court, because that was the goal of the Williams Commission, to ensure that we improve our family courts. Now, while our family court report was limited to New York City, the Williams Commission also intends on updating its report and expanding the report to cover all of New York State. And some of the issues that were raised in that report do impact the entire state. Just by way of background, the Franklin H. Williams Judicial Commission is a permanent independent entity of the New York State court system, and it's dedicated to promoting racial and ethnic fairness in the courts. The Williams Commission was established in 1991. It is chaired by the Honorable Troy K. Weber, Associate Justice of the Appellate Division, First Department. And as you heard earlier, Honorable Richard Rivera was our co-chair. He is now Chair Emeritus and has been appointed a statewide coordinating judge of the family courts. So the commission is composed of 28 diverse members from throughout the state. Again, our goal is to make the courts more responsive to the issues that are faced by persons and communities of color in the courts. For more than 30 years, the Williams Commission, in keeping with the legacy of its namesake, Ambassador Franklin H. Williams, has worked towards eradicating systemic racism and bias within the New York court system. And as part of its mission to enhance the delivery of justice within the courts, the Williams Commission in December of 2022 issued its report on the New York City family courts with many recommendations on how to address the challenges that impact the family court and its diverse litigants. I also want to acknowledge at this point, with gratitude, the assistance and the significant contributions to our report by the Honorable Shirley Troutman, who was our Chair Emeritus, and also an Associate Judge of the Court of Appeals, and also the Honorable Yannette M. Rosado, who is a Commissioner and also an Associate Justice of the Appellate Division, First Department. And you've all read our report. You're familiar with the recommendations. And one of the things that was discussed earlier was the dehumanizing culture. Our report followed the report of the Special Advisor on Equal Justice, Secretary Jay Johnson. And in his report, he recognized what Ambassador Williams found over 30 years ago, that the courts are overburdened, they're under-resourced, and that there is dehumanizing culture within the court system, specifically family court, housing, criminal, and civil courts, and that there's a second-class system of justice for people of color in those courts. And since the issuance of that report you heard earlier, the Honorable Edwina Richardson is tasked with ensuring the implementation of those recommendations. So earlier, one of the senators asked, what is being done correctly? So we have bills that were recently passed that have added family court judges. Last year, there was a bill that was signed by the governor where there were 4 New York City family court judges added. There was a recent bill that was passed in this legislative session that would add 13 additional judges in the family court across the state, 3 of which are in New York City. But between those bills, that's only 7 in New York City, and the Williams Commission urges and maintains that we need more judges in order to address the volume in the New York City family courts. A bill that was sponsored by Senator Brad Hoylman this past session would have increased the number of New York City family court judges to 72, and the Williams Commission supports that recommendation in that bill. Again, we advocate to address and eliminate the dehumanizing culture found in the family court. And yes, while we know it's not every single family court judge, and we know that many of our family court judges are hardworking, they care about their cases, but we have heard from our stakeholders that this is a culture within the family courts. So one of the things that's being done right is the anti-bias training that is done, and that has been incorporated. The Williams Commission created signage that would tell our court users what their expectations are within the courts, including, for example, a courteous and respectful treatment, free court interpreters upon request, and clear and understandable information. And our signage helps court users navigate the court system. There's been technology that has, technological advances that is now an access that the practitioners now have to NYSEF, the New York State electronic filing system, as well as the case management system. There has been recommendations for access. We heard about the increase to assigned counsel. That is a step in the right direction. And we know that our chief judge is committed to the family courts, and of the appointment of the Honorable Richard Rivera to his new role. So what are some of the areas for continued legislative action? Again, you've heard throughout the morning, alternative dispute resolution resources are greatly needed. Parents need child care, so we need to work on that and to ensure that we are continuing our financial investment in our children and our families. Mental health issues and drug alcohol addictions, again, those are part of family court cases, so community-based mental health services, again, we need more support and more funding for that. Supervised visitation programs, you heard, are critical to the family courts, and we would just urge the legislature to consider dedicating funding for these programs across New York State, and that would assist to decrease case lengths. Affordable housing is another important issue. The Williams Commission, again, continues to recommend additional resources, more family court judges, court attorney referees, support magistrates, court attorneys, court clerks, court interpreters are needed statewide, and that is an issue too. There's a severe shortage of court interpreters, so we urge more funding and more resources to be able to address that, because that's an access to justice issue. Again, additional funding for technological resources is needed, and again, lastly, the physical maintenance of these buildings is so important and continues to be concerning, and we would encourage the legislature to meet with DCAS, the New York City, Department of Citywide Administrative Services, regarding the maintenance of those courthouses. So in conclusion, if we truly care about New York families, we must invest in them and in our family courts. Thank you for the time this morning to speak with you.
Thank you so much. Next up, we have Ms. Patricia Worth.
Good afternoon, and I want to thank you for inviting me on, for ILS to speak to this hearing this morning on behalf of ILS, and to talk about our proposal for improving one part of family court functioning. Many of the early panelists spoke compellingly about the need for quality representation for counsel. But the attorneys who are currently assigned to represent parents in family court matters do not have the time and resources that they need to do a good job. Why? Because New York State has delegated to counties and to New York City the responsibility for funding public defense, including the representation of parents in family court matters. This started in the 1960s with enactment of County Law Article 18B, which gave counties the responsibility for building and funding criminal defense systems. And in the 1970s, Article 18B was expanded to include family court representation, or the representation of parents in family court matters. Twice, judicial commissions have held that this county-based system of public defense doesn't work. In 2006, the Cade Commission issued a report after deep examination into mandated criminal defense. The report bluntly concluded, New York's experience since 1965 has demonstrated that a system of minimal state funding with primary responsibility at the county level does not work. Similarly, in 2019, a commission convened by then Chief Judge Janet DiFiore examining mandated parent representation in family court also held that the systematic problems in our underfunded county-based system are well documented, as are the harmful effects of inadequate representation on families and the family court system. Now, the Cade Commission report led directly to a class action lawsuit against the state, the Harrell Herring litigation. That litigation focused only on mandated criminal defense. And as a result of a settlement of that litigation and its expansion statewide, the state now is committing every year $273.8 million to improved quality representation in criminal matters. And that is having a significant impact on reducing caseloads and increasing attorney use of the specialized services that are necessary for quality representation. But the representation of family court, of parents in family court matters, was not part of that litigation. It's been left behind. And the quality of representation of parents in family court matters, and I think people heard this earlier today, it's in crisis. And this crisis is having an unfair impact on Black and brown families. Because race is a defining feature of our child welfare system. It impacts decision-making at the point of first contact with the child welfare investigation, to decisions about foster care, and decisions about termination of parental rights. All too often, our child welfare system views families, particularly low-income families and families of color, punitively, casting blame on them for the circumstances that they're in, instead of trying to figure out what are their personal circumstances and what services can be used to help address people and keep families together. So I'm here with good news. There's a solution. And one that we know from experience works, and that is replicate the Harrell Herring settlement that's working so well in criminal representation, replicate it for family court representation. And so this past summer, ILS conducted a comprehensive survey of providers of mandated family court representation to determine what their caseloads are, what their staffing patterns are, and what their expenditures are. And the goal was to determine what is needed to come into compliance with caseload standards that ILS established in 2021 that currently are unfunded. And caseload standards are the core of the Harrell Herring settlement. So with caseload standards, attorneys have the time and resources that they need to provide quality representation. we determined that there's a total of $150 million necessary to do so of state funding. And we propose that the state commit to that funding, but phase it in over 3 years. And so we're requesting $50 million in the ILS-H localities budget this coming fiscal year, 24-25, for improved quality family court representation. The other good news is that money does not need to come from the general fund. There was a special fund created in 2003 for improved quality mandated representation under County Law 18B. That includes criminal defense and the representation of parents in family court matters. And so far, the fund has been used almost exclusively for improved quality criminal defense. It's time to use the funding as it was intended, both for criminal defense and improved quality parent representation. So I see my time is up, but I look forward to answering any questions you may have.
Thank you so much. Next, we have Ms. Bertina Capuano.
Hi, good afternoon. My name is Bertina Capuano. I am the Assistant Chief Deputy County Attorney in Westchester County. Oh, thank you. I've had the privilege of practicing in family court for over 27 years. I have worked as an ACS attorney. I have worked for the New York City Law Department doing juvenile delinquency cases. And more recently now, I am in Westchester County. And I want to thank your honorable committees for the time to appear and express my concerns about family court today. The report from the Special Advisor on Equal Justice in the New York State Courts and the Williams Commission report in 2022 are comprehensive reports focused on issues within our court system and the reforms which desperately need to be put into place. The reports go on to give recommendations on ways to eradicate the dehumanizing culture through a commitment of resources, training, and oversight. I commend all the recommendations, but would say that they do not go far enough. While the report encourages the New York State court system to start at the top, I would implore you to start with the law and to look at the inequities created therein. With New York's enactment of Raise the Age in 2018, we correctly codified the idea that juveniles should be treated differently than adults. As part of the law, Family Court Act Section 350.3 sub 4 was amended to include that a victim in a case involving juvenile delinquency shall not be made aware of the final disposition on the case. That practical effect of that one sentence has caused a consequence that has real-life effect of treating victims differently depending on what court system you're involved in. Imagine for a moment being the presentment agency on a juvenile delinquency case where the youth is accused of a serious offense such as rape. Cases like these happen in family court every single day. The victims come, they are interviewed by law enforcement, they are brought to child advocacy centers where they are re-interviewed, victims are treated, and then come to family court and are treated as almost nameless, faceless, second-class citizens of a second-class court. As part of my office's investigation of cases, we do due diligence. An assistant county attorney goes to great lengths to forge relationships with victims and sees victims through the initial investigation, preparation for trial, the agony of testifying, all the way to the disposition of a case. But then at the end, we can't tell them what happened. And that has to change. Additionally, I would implore these committees to look at settling the issue of court openness. We've talked about that several times here today, but it is fundamental that all judicial proceedings, both civil and criminal, are presumptively open to the public. The family court is generally open to the public. In addition to the persons who have cases before a court part, the judge or support magistrate presiding over the case has the authority to exclude the public from the courtroom, depending on the nature and privacy interests, of course. But I would tell you, having practiced for 27 years, this happens routinely. And I cannot, even I, who am in charge of a family court bureau, cannot sit in the back of a courtroom without putting my name on the record when I'm not even part of the case in front, because I'm there to observe my people do their jobs. It isn't open. As much as judges, it says there's signs in family courts that say the court parts are open to the public, they're not. And that needs to change, and the way that that changes is through legislation. The special advisor report also recommends additional family court judges. That's been discussed here many, many times. And I would say, having practiced in family court for 27 years, and I've been in 3 different courts, yeah, I generally agree with that. However, there has to be accountability built into this. Family court does publish statistics, but not by judge. And it should be done. Standards and goals is something we hear as family court practitioners all the time. You know, when a judge is looking at their standards and goals to make sure cases don't go beyond a certain point. But I have to tell you, they routinely do, and there are no consequences for it. Judges who are appointed to 10-year terms, elected to 10-year terms, there's no accountability in the system built in, and that has to happen. You can't just give more and more resources to a system with no accountability. Currently, supervising family court judges are carrying caseloads themselves that are very high, and outside of New York City, there's one supervising judge for the family court for the entire 9th Judicial District. Those judges need to be freed up to do court observation, to do accountability, to do good supervision of their judges. In order to hold the system accountable, you can't just keep throwing money at it. So I want to thank you again today for your time, and I appreciate your attention to this matter, which is something that affects children and families all over the state. So thank you again.
Thank you so much. So I'll take my first 3 minutes. I think my first question is for Miss Mary Lynn Nicholas Brewster, and it's about the Office of the Managing Inspector General for Bias Matters. So I know in the Jay Johnson report it says we are told that the IG for Bias Matters typically receives 10 or fewer complaints of racial bias meriting an investigation per year. But given that the Williams Commission and other reports found more widespread issues of bias, there seems to be a little bit of a disconnect. And the Johnson report argued that there was a general unawareness that the IG process even exists. So does the number of reported complaints suggest there might be an underreporting issue?
Well, if I can just speak to, since the Johnson report,
Yeah.
I know that the Inspector General's office, and in particular the Managing Inspector General for Bias Matters, has done a lot of outreach, not only, all throughout the state to ensure that people are made aware of the process. I know that there is signage that is available in each of the courthouses to make that process clearer. I know that there was an appointment of an ombudsperson so that there's a hotline so that individuals can report complaints. And I know that they've seen an increase in the number of complaints as well. So because now people know how to make those complaints, and they've seen an increase in the number of complaints that have been lodged.
Thank you.
Yes.
I also wanted to speak more to assigned counsel. And there is a sentence in the Williams Commission report that I'd like to read. It says, "The lack of timely access to counsel is an unconstitutional infringement on the rights of children and their parents. The Williams Commission urges swift action to address this dire situation and remediate the dramatic exodus of family court attorneys who cite unlivable compensation as a primary motivation for exiting the assigned counsel panels. The Williams Commission urges the governor and New York State legislature to support legislation that would raise compensation rates for assigned counsel panels and remedy an injustice in our family courts affecting the constitutional rights of children and families." The report also makes note of a lawsuit seeking to increase the compensation of the 18B attorney compensation. And just to be totally clear, funding the program in this coming year's budget isn't just something nice for us to do. It's also legally required by existing law, right?
Well, definitely. We know that in the 2023-2024 budget that the increase is up to 154. One of the things that I didn't have an opportunity to mention is that we at the Williams Commission would also urge that legislation require 18B attorneys receive a cost of living adjustment and that their base rates be increased at least once every 3 years. We all know that those rates were languishing for over 20 years. And again, that caused the exodus of these attorneys from the panel. And you've heard all day about, the need to try to encourage attorneys to join the panel. I know that the Williams Commission has done efforts, have done outreach. We've done programs with the AFC, all the 4 departments and those and try to do outreach to encourage more attorneys to join these panels. But they also need to know that this is not a one-time investment, that every 3 years, there'll be a cost of living or their salaries will be considered, or increases would be considered at least once every 3 years. We also heard about nonprofit attorneys and staff. Those are also critical to the family court's function, and so we would, obviously urge funding for civil legal services be increased, and that we need to properly fund these nonprofit agencies to attract strong candidates who will work on family court matters, and we need those family court attorneys to protect our families.
Can I speak to that as well? So under County Law 722E, the counties in New York City are currently required to pay for the cost of the increase, not the state. Now, the state did appropriate to the ILS budget $92 million for ILS to reimburse counties for 50% of their expenditures for the assigned counsel increase. And we've been doing that. We set up a really smooth system to do that, and counties have been taking advantage of that. But that funding needs to continue in next year's budget. If the counties continue to bear the burden of paying for the assigned counsel and the assigned counsel increase, they will seek to cut services in other places of mandated representation, including, for example, the requirement that many providers of mandated representation are not just assigned counsel attorneys, but also institutional providers, public defender offices, legal aid societies. And, they, as you mentioned, they desperately need a salary increase as well. But the counties, it's not forthcoming right now because they have to pay for the increase for the assigned counsel program. So we would urge the state, I would urge you to think about not only continuing the $92 million in this coming year's fiscal budget, but looking long-term at changing County Law 722E so that the state is responsible permanently for fully paying for the increase. And you are also absolutely right about the assigned counsel increase needing a mechanism for periodic increases, because attorneys right now are going to hesitate to rejoin the panels if they know that we're going to be in crisis again in another 5, 6, 7 years.
Thank you. Chairman?
Thank you, Mr. Chair. Couple of questions, and again, thank you for your work, everyone on this panel, and Ms. Nicholas Brewster. We've spoken before about the need for diversity on the bench, and I think it's probably as important as any court that the family court judges be diverse, because so many of their litigants are people of color. Do you know what the percentage of white judges is on the court at the moment? I think I read in your report it was something around 60%.
Right. I also know that the court system, there was recent legislation where this information is publicly available, and you heard from Judge Jolly that there is a dashboard where that information can be obtained. But in our report, we did note, I believe it was, and let me just quote from the report, that 77.6% of family court judges in New York State identify as white, and 61.5% of family court judges in New York City identify as white as of July 2022. And again, the statistics are, publicly available on the court's dashboard.
So you and I have spoken about how we get more judges of color on the bench. do you have thoughts that you'd like to share with us today?
You know, again, you know, upstate New York, the family court judges are elected. In New York City, they're appointed. I know that the Williams Commission has made, you know, efforts to, number one, bring information to. For example, we hosted a program this year on how to become a New York City family court judge, inviting, you know, the public and attorneys to join, because we want attorneys to be interested in becoming family court judges. We annually host how to become a judge throughout the state, again, to encourage diverse attorneys to learn about the process, learn about how to become elected in upstate New York. But really, we need to attract people to the family court. And I know when we spoke, sometimes, you know, individuals don't view family court as highly as, say, Supreme Court or other courts within the court system. And I think, you know, really placing an emphasis in family court, putting additional resources would assist in attracting attorneys to join our family courts.
Thank you. Ms. Worth, I wanted you to repeat what you did at our budget hearing last year about the looming specter of a lawsuit that would throw New York State's budget in chaos if we don't provide for family legal representation.
Sure. Well, we know from the Harrell Herring litigation that there was a class action lawsuit against the state because of the Kate Commission, which focused on the lack of resources and the lack of state fiscal investment in criminal defense, mandated criminal defense. All the essential ingredients and more are there for a lawsuit now for the parallel of the defense of parents and family court matters. We have a commission saying that the system's broken and that attorneys need better resources and that the state needs to make an investment. And then just this summer, the American Bar Association revised their 10 principles for a public defense delivery function and in a system. And in New York, the defense of parents and family court matters is part of the public defense delivery system. And they emphasized the point, two points. One, that states have the obligation to fully fund it, to adequately fund these systems. And two, attorneys must be in compliance with caseload standards. There's caseload standards in New York for family defense, for the representation of parents in family court matters. No provider is in compliance with these caseload standards. So all the essential ingredients are there for litigation against the state.
Thank you. And then one quick question for the judge about there was a
I thought you were
report.
going to ask me about being elected as a judge of color outside of New York City, because you know I
Oh,
have personal expertise in that.
then that
I'm joking.
that is
Go ahead.
you know, is a
My
very
apologies.
very alarming statistic about the lack of judges of color particularly outside of the city. But it's something, you know, I think we need to get more young law students of color, right?
Yes.
That's
Yes, we
where,
talked about
and we talked about how we can expedite that. So hopefully we'll have conversations further. But there was a ProPublica report in August of this year that highlighted a disturbing trend of family courts explicitly or implicitly endorsing something called the parental alienation theory, which is an argument that a parent will brainwash a child to turn them against the other parent in a custody dispute. I mean, it's regarded by most social scientists as junk science, and you know, doesn't have much grounding. But apparently, it's a national trend line in family courts. Have you had any experience or seen this raised as an argument?
So I'm not familiar with this ProPublica report, but generally, we're of the same understanding about the concerns about this notion of parental alienation syndrome. I can't speak for what other practitioners are doing throughout the nation or even in the state, but it's my understanding that our education of the past few years was that even when I'm ordering a forensic, I specifically tell the evaluator not to include a diagnosis of this, just provide me with what the status is and allow the court to come to a determination with respect to what the factors are. So, you know, again, my understanding generally amongst myself and my colleagues is that we don't endorse the notion of this parental alienation syndrome, and it was done for some time, but I believe it's outdated. I think we've stepped away from that.
Thank you very much. My time is up, and we'll turn to first Senator Skoufis.
Thanks very much, Chair, and thanks to each of you for your testimony. It's always struck me as odd that we have this bifurcated system of choosing family court judges, depending on whether you're in New York City or rest of state election appointment. I'm curious to each of you if you think one way of choosing judges or the other leads to more qualified judges ultimately sitting on the bench.
I think I'd like to address that since I have practiced both in New York City and in Westchester County. It really doesn't make that much of a difference. I feel like the cases are the same. They're treated the same whether you're sitting in Westchester or the Bronx or Manhattan, and it really hasn't made that much of a difference to me as a practitioner in family court every single day, and what I see has not really affected the outcome.
Do you all feel the same?
Depends on the day.
Yeah. I would just say, I mean, at least in New York City, just based on the statistics, there are more family court judges of color than outside of New York City. So, and New York City has an appointment process. So I think there is a distinction there. Is it more difficult for those attorneys of color outside of New York City to be elected, in certain areas of state New York? There is a lack of diversity, and the statistics bear that out.
Do any of you, obviously, if a judge is elected, they have to be a candidate, and typically, with few exceptions, they first have to be supported by the party to become the nominee of that party to get on the ballot and get to the general election. Do you find, or do you feel that outside of New York City, where these judges are elected, that they come more from the party apparatus? They're more political prior to becoming judges?
I wouldn't say so. I think there's the question of how the electoral process affects the ability to achieve diversity, and so that can somehow be politically related. But I think it's incredibly burdensome because we're not political animals. Definitely, once we are all behind those doors, there are absolutely no party lines. We don't see that in family court. I think even in terms of the disparities you see in judicial determinations, particularly in family court, are not about politics. They're about culture and cultural, information, maturity, and sensitivity. So I don't necessarily know that one person of one political party or the other is doing a better job at addressing the needs or concerens of the litigants in family court.
That wasn't my suggestion at all, that one party is doing a better job of addressing concerns. But it's really just I guess, a matter of interest as to whether before becoming judges, generally, not one party or the other, either party, are those judges before getting to the bench just more involved in politics in order to be the chosen candidate of that party?
That wasn't me.
Yeah,
Okay.
Senator, I think most of the time, a lot of the family court judges are practitioners who have moved up and who sought either a spot via election or through the appointment process. So these are people who've worked in family court, who have spent their professional careers in one place or another, whether it was legal aid or corp counsel, or they pretty much all have come from somewhere inside family court.
Okay, thank you.
Thank you. And next we have Senator Mayer.
Thank you very much, and thank you to all of you. A question for Ms. Worth on the $50 million a year proposal over 3 years, not out of the general fund. What's the funding source?
So in 2003, the state created a special fund under
Yes.
State Finance Law 98B, and it's the Indigent Legal Services Fund.
Oh, okay.
And so that fund is designed specifically to improve the quality of representation under County Law 18B, which
Right.
includes both criminal defense and the representation of parents in family court matters. So the money's there, and the
How
fund,
much money is there, do you know?
the last time I looked at the fund, it was close, a little over north of $800 million.
Okay.
So the fund, the mechanisms for the receipts for the fund have been increased over the years, and so the fund is robust, and there's enough funding there to support this.
Okay, thank you. And Ms. Capuana, thank you very much, and thank you for your frankness about the way the courts operate. You mentioned about supporting a concept of accountability for judges. In your mind, what does that look like?
Well, I think the normal person, if you're not a person who works in family court every day, doesn't know about the court dashboard, doesn't know that the judge they're appearing in front of has a case that is pending disposition for over 4.5 years. They don't know that because they don't know how to access that information. It's not readily available. I have been in family court for 27 years, haven't seen any statistics by judge published. Like, I think that's important for transparency purposes. And unfortunately, that's not what happens. And if I was a litigant in family court, would want to know who the judge was that that is going to decide my family's fate. And whether or not they're worried about 16 other cases on their docket today, or are they worried about my family because they're behind.
Thank you. And then the other question is about recusal of a judge. You as a county attorney, representing the county, not a particular litigant, if a judge's conduct is such that you think recusal is appropriate or you need to be in front of another judge, what process do you use?
So what we do have available to us is in Westchester County is not as clear as what I would say I had available to me in New York City. In Westchester County, if I have an issue with the way a judge is conducting themselves on the bench, I feel comfortable enough to go and discuss that with my opposing counsel to the judge themselves. There isn't like a monthly agency heads meeting like there is in just about every borough in New York City with an administrative judge. The administrative judge for Westchester sits in another county and got a full docket himself. So his ability to come and watch the judges in Westchester is very limited. So I think that there has to be better supervision and better oversight of the family court judges and accountability through transparency. I'm not really sure that that's what exists right now.
It sounds like it doesn't exist. Okay, thank you.
Senator Rollison, please.
Thank you, Mr. Chair. I have a question for Judge Brantley. And as the president-elect of the association, I know you have certainly a lot on your docket on both sides, your own court, representing the judges. If the association had the ability to put together for the legislature, we've heard a lot today so far. We'll hear a lot before the hearing concludes and as we move into the next legislative session and budget deliberations. More resources, more judges, hearing about the physical plant in many of the courtrooms throughout the state. And colleague Senator Bailey talking about Bronx. Where will we start as a group so we're not doing something that causes an extra burden that the system can't handle? Because we know that happens. Policymakers make policy and sometimes they don't fit into the current climate or the current system as much as they are needed. And I think that's important for us. And you don't have to, give me the long answer on that now, of course, but I think that would be something important from the association.
I want you to recognize it was actually very important for us to be here. You'll notice me sneaking out in a few minutes because I have a competing interest on my calendar, but we were actually pleased to receive this invitation because we want to be a part of the conversation. We don't want to respond to the legislation as it's being proposed, and so, as we say, we welcome you to communicate with us, liaise with us, and particularly as a statewide association. You're hearing a lot of information about what's happening in New York City here. I represent the judges across New York State, which represent vastly different communities and different interests. And so it's also important to ensure that while we're addressing or treating one issue somewhere, we're not then creating a deficit elsewhere. So I'd welcome additional conversation surrounding that.
And I look forward to that. Thank you, Judge.
Sounds good.
Thank you. So seeing no other senators, I just want to thank you all again for your time and your work. Thank you.
Thank you.
So our next panel will have representatives from bar associations, Richard Lewis from the New York State Bar Association, Michael Weinstein from the New York City Bar Association, and Renee Kathawala from the New York City Bar Association. Thank you so much.
Yes, please. Thank you. Thank you.
And just a reminder, 5 minutes each, and we can go in that same order, Richard Lewis, Michael Weinstein, and then Renee Kathawala.
Nice to meet you. Is this on?
Yes, indeed.
Well, as you indicated, my name is Richard Lewis. I'm president of the New York State Bar Association. I actually have with me Susan Lindenauer, who is the chair of the association's Committee on Families and the Law. And we really thank you for letting us speak on behalf of the association. The association has worked with members of our legislature before, and we like to have as much input as we can and to work collaboratively as much as we possibly can. And to that end, I want to make a quick plug before I go on. In listening to prior panels, one of the issues has been the makeup of our courts racially. And I commend to your attention our most recent task force report, Advancing Diversity, chaired by Jay Johnson, Brad Karp, and former Attorney General Loretta Lynch. And we talk about the makeup of the courts post the affirmative action decision in June. In any event, the family courts are a top priority because they are the court in which most Americans experience the justice system. Hundreds of thousands of individuals enter the courts every year seeking divorce, separation, matters relating to children, sometimes happy with adoption, most of the times not, dealing with juvenile delinquency, child support, custody, joint parenting, and so on. Given the weight of these matters on countless lives, it's paramount that our system, our family court system, has sufficient resources, training, and reforms necessary to ensure fair treatment for all. Our association has a long and deep commitment to addressing legal issues that impact families and children. And among the many association sections and committees that have been involved in this important work is the Committee on Families and the Law, which last April released a report that looked at family courts across the state and the child welfare system from the historical perspective, recognizing the myriad of challenges, including inherent structural racism that exist within these institutions and requires the concerted reform effort to combat. The full report is submitted to the committee with my written testimony, and we can provide electronic copies as well. This association report followed on the heels of an independent review commissioned by the Chief Judge in 2020, which issued a stark indictment of a court system that delivers second-class justice for New Yorkers of color. Unfortunately, this was particularly the case in our family courts, where the chronic lack of respect for individuals of color and unacceptable delays in abuse and neglect of proceedings far too often result in permanent damage to families and children. Now, I want to say parenthetically that these delays occur not only downstate but upstate where I am from. And these have to be confronted because they can rip a family apart. The Committee on Families and the Law's report found, for example, that at preliminary stages of child protective proceedings, judges are more likely to order black children into the foster system. Once in the system, these children often receive inferior services and experience longer stays than white children experience, lessening their chances of family reunification, which is obviously the goal we should be striving for. The New York State Bar Association's Committee on Family and Law report makes a series of recommendations aimed at improving the culture and efficiency of the family court system, including increasing the availability of essential preventative community-based services to preserve families, increase economic opportunity, and ameliorate poverty without the threat of unnecessary family separation through the child welfare system. And I would add to that Susan and I were just conversing about it, and dealing with children in our courts has to be more holistic. We need to involve social workers. We need to involve medical attention. We need to involve so many different things that impact these children and their parents. One of the other things we look at is appointing more judges. Family courts continue to experience extremely high volumes of cases and receive fewer resources to hear those cases. Delays in case processing can result in permanent damage to children, particularly when those delays impact reunification. Raising the pay for court-appointed attorneys in family court cases is absolutely essential. And I thank many of you here, including Senator Holloman, for carrying the ball when it came to increasing our assigned counsel rates recently. Quality legal representation is absolutely essential in combating disproportionate and disparate impact on the child welfare system on families of color. Effective assistance of counsel for parents and children help keep families together, reduce the duration of foster care stays, and ensure access to individualized, culturally appropriate, and supportive services and resources. Competitive compensation and reasonable caseloads that enable attorneys to meet their ethical obligations to clients are critical to ensuring effective representation. The association continues to advocate for an increase in state-assigned counsel fees to bring them in line with federal rates. This will increase participation in the program, addressing the shortage of representation, particularly for indigent defendants and minors, which is undermining access to justice in the state. And again, I'll say parenthetically, I know that you have a lot of people, my time is up, I guess, but I'm going to add this anyway. I know you have a lot of people who have testified here from downstate. I want to tell you about one upstate county, Shenango County, which has 2 people on the 19B list, an elderly practitioner and his daughter. It's critical for us to have attorneys in upstate New York and rural areas that can participate in these programs. And if I can just close by saying that this year's state budget increased assigned counsel rates, but we feel that that's only a first step, and we really need to move forward. The New York State Bar Association acknowledges the pervasive systematic racism in our state's child welfare and family court systems. We are ready to work with the legislators and the policymakers and the judges and the attorneys to enact reforms that will improve access to justice for individuals of color and all others. And thank you again for the invitation.
Mr. Michael Weinstein.
I think the same clock from Oppenheimer, isn't it? Good morning, Senator Brisboard and Hoyman Seal, and to all members of the Judiciary.
Actually, it's the same clock from Barbie.
See, I didn't see Barbie, so I don't get that.
Thank you to everyone on the Children and Families Committees. Thank you for giving the New York City Bar Association the opportunity to testify today. My name is Michael Weinstein. I currently serve the people of Northern Manhattan, my lifelong friends and neighbors, as part of the Neighborhood Defender Service of Harlem in their family defense practice. Our work primarily involves Article 10 proceedings, which are abuse and neglect. But we also do work on orders of protection, custody matters, and along with my present specialty, appeals and strategic litigation. I'm the co-chair of the City Bar's Family Court and Family Law Committee. I'm present here today because time and again, I've chosen to work with parents in family court over every other type of employment. Twice, I've left other employ after very brief periods of time to return to this work that I love. 10 years, perhaps 1,000 families represented, and hundreds of trials later, I now feel confident in my observations concerning the state of our great state's family courts. Beyond observing the various inefficiencies and room for improvement that the City Bar has reported, my colleagues at the City Bar Committee and I that I co-chair, who come from all walks of family court life, jurists to budding attorneys, have all corroborated my own fears. The New York family courts are broken, resulting in unnecessarily delayed access to justice for the hundreds of families to whom I've dedicated my life in service. I will now turn over to my colleague, Renee Kathwala, to introduce himself and to present his testimony on behalf of the City Bar, after which we are both happy to answer any questions you might
have. Good afternoon. My name is Renee Kathwala. I'm the pro bono counsel at a law firm called Orrick that has offices in New York City. I have been representing low-income clients in family court for more than 25 years. My focus has been in representing clients in child support, custody, visitation, and order of protection matters. I've handled more than 300 petitions in the New York State Family Court process. Based on my long-standing commitment to access to justice issues in the family court context, I have been appointed as co-chair of working groups of the City Bar focused on race equity in New York State courts, the family court's response to COVID-19, and others. I've been a member of the City Bar's Pro Bono and Legal Services Committee and currently sit on the Council of Judicial Administration. I have been involved in the drafting and release of City Bar reports, making significant recommendations about the family court and how the New York State Unified Court System could improve the system that you've heard is at a low point. This testimony, which focuses on the family court in New York City, includes a series of links in my written testimony to prior City Bar reports that are relevant to the proceedings here, the top of which also endorses the recent Williams Commission report on the New York City Family Court. The New York City Family Court is emblematic of long-standing inequities and systemic discrimination. Family courts in New York City are dehumanizing and have a demeaning cattle call culture. For example, litigants are summoned to appear at 9 a.m. and often wait hours to get a mere 15 minutes of court time. Cases are adjourned for weeks or months at a time, with the resolution of a case far in the distance. Court vacancies caused by judicial retirement or transfer of judges to the civil or other courts result in family court parts being vacant for up to a year, during which time litigant cases are not heard at all. Mr. Weinstein and I have countless clients who say they do not see any purpose in showing up in family court and enduring the disrespectful system that is the New York City Family Court. In the view of many who represent clients in family court, the management of the court system, the Office of Court Administration, or OCA, unacceptably tolerates a broken court that has not seen substantial improvements in decades. Professed progress simply is not evident to the many poor and working class litigants in family courts in New York City, most of whom are people of color. These litigants have no voice, and they are further silenced by a bureaucracy that does not see their plight as one worthy of a dignified process. The sad picture that emerges is, in effect, a second-class system of justice for people of color in the New York City Family Court. As found by Secretary Jay Johnson in his 2020 Equal Justice Report, this has been an enduring failure and feature of the New York City Family Court for decades. Yet, OCA has failed to meaningfully and systematically engage the diverse group of stakeholders who operate in the New York City Family Courts to ensure that they are able to provide significant and sustained input into potential reform of the system. Given the limitations of time, I focus our testimony today on one recommendation made by the City Bar and other stakeholders. Again, other recommendations appear in our reports that you have access to. As background, if you appear in virtually any state trial court or federal district court in the country, procedural rules exist that govern the conduct of those cases in those courts and ensure there's a credible and thoughtful process, particularly to handling litigants. One of the only courts that I'm aware of that has no procedural rules is the Family Court. This has a tremendous negative impact on litigants because procedure differs in most of the more than 100 family court parts of the New York City Family Court alone. As just one example, a litigant can show up 5 minutes after their case's scheduled court hearing in one part and have the petition be dismissed for failure to appear timely, and in another part, the same litigant in the same case shows up 2.5 hours with no consequence. Court leaders should enact uniform procedural and part rules for both in-person and remote proceedings in family court. Judicial discretion is not a sufficient justification for the absence of consistent, published part rules dictating discovery, trial procedure, and courtroom behavior. Clear rules will help ensure that all litigants and lawyers are treated fairly and equitably, regardless of which courtroom their case is assigned to. It is unclear to us and many advocates why these rules have not been implemented. This is just one example of common sense reforms that we have proposed and that require no additional court resources. But for whatever reason, this recommendation has been met with resistance. Hopefully, hearings like this will cause a shift in court leadership thinking so that reforms to truly better the system can be implemented. We close with one final thought and recommendation, which in our view should not be all that controversial because it's really just about communication. It has proven difficult to come up with a meaningful and sustained way of talking about stakeholder recommendations with OCA and court leaders or assessing the progress of promised change. To that end, one of our recommendations is for the court system to provide clear, public-facing information regarding implementation efforts, monitoring, and how stakeholders can regularly provide input as part of the process. Thank you for your attention. We're happy to answer any questions.
Thank you. I have my first couple of questions are to the full panel, but they're really rooted in a report from the New York State Bar Association from April 2022. The first quote I just want to pull is, the report said only a quarter of child protective cases involve intentional harmful acts by parents, and then most cases involve parents who cannot meet their child's basic needs due to poverty. So could you tell us a little bit more about the types of cases that come through family court?
Sure. Yeah, actually, would it be all right if I had our chair of that section?
Sure. Yes.
She's the author of the report.
The cases.
Mike.
Come on right over here.
Just into the mic so we can get it in the recording and into the record. And also just, and thank you.
I'm Susan Lindenauer. I am chair of the Committee on Families in the Law at the State Bar, and also author or co-author of the report that you are describing. What we were stating was that child protective cases include neglect and abuse, and it is only 25% of those cases that involve abuse. Abuse means that there has been really a danger to the child. Neglect can mean failure to provide a home for those families that are homeless and then are charged with neglect on top of the fact that they are homeless. Failure to have adequate food, failure to provide adequate education, and that, in fact, has involved children who are, in fact, in shelters and who have not been given assigned schools because they've been moved from one place to another. All of these things really are not largely the family's fault. They're the fault of our social structure. And that's what we were referring to.
Thank you so much. And I had another question. This again is for the full panel, but it's also from the same report. It stated, by the time they reach the age of 18 years old, an astonishing 53% of black children in the United States will have been subjected to at least one CPS investigation, which we heard that statistic earlier, compared with 28% of white children. So I was just curious if people on the panel had any contact with CPS or ACS employees where they tried to explain why that tremendous gap.
Well, the gap that we were describing there is a nationwide gap.
Uh-huh.
The gap in New York may vary somewhat by geographic location. The gap has narrowed somewhat in recent years, but it is still enormous.
Yes, please.
I know we're short, Senator Brisport, but in 10 years of doing this work, no explanation is offered by the CPS. Rather, what you get are excuses that don't compare. You'll have a white family that comes through. Very rarely, I'd say, I've had maybe 10 clients over the course of my career who are white identifying. And of those where a petition is never filed against them, there's always some reason that if I argued in court on behalf of a black and brown family would not be accepted, but is put forth as a reason not to investigate further of a white identifying family.
Thank you.
Right, and I would just add that there's a public interest organization, Family Justice Law Center, that's working on systemic cases like Michael does, and they're certainly looking at the race equity features of CPS and how those matters are handled just from a discriminatory impact and intent.
Thank you.
Thank you, Mr. Chair. Wanted to ask about, thank you again for your amazing reporting and work in this area. It's very useful to us as legislators. You're basically our outsourced think tank in so many regards, and we're very grateful for that.
We're happy to do it.
Yeah. In terms of the suggestion, Mr. Kathawala, on rules of procedure for family court, have other states adopted those?
I mean, I'm familiar with California because we have a lot of offices there, and my understanding is, yes, there are uniform rules that govern cases there. Their family court is in a different sort of court, but yes, there are states that clearly have procedural rules governing the family court. The rationale that we've been given, or at least I've been given, is that if OCA enacts procedural rules, that somehow they're intruding on the judicial provenance of the individual judges, referees, and support magistrates, which doesn't make any sense to me. That's the job of OCA, to supervise and administer justice in a fair and equitable way. So I don't understand the resistance. There have been proposals made, rules written, that OCA could certainly come back to and provide comment on if they disagreed with certain of them. But there's just, in my view, no excuse for not implementing them, because I can tell you from personal experience, litigants have no idea what the rules are when they show up. And that's a terribly disarming and further vulnerable situation for them, and causes a lot of anxiety and bad results, I would say.
And Mr. Lewis, have you looked at other states?
I have not looked at other states, but I would like to add that there are some differences, again, between downstate and upstate. And I would say that sometimes the judges may need some flexibility, specifically because if you have, for example, a pro se who is appearing and doesn't understand the procedures of the courtroom, I have found, at least in upstate New York, where I have done a lot of family court work over 45 years, I can tell you that some judges, most judges, will be a little bit more lenient and protective of the pro se party. So while I think we need to have procedures, and we do have procedures, the CPLR applies to family court, I think that we do need to have that flexibility where there are so many pro se parties.
And if I could ask in my remaining 15 seconds, Mr. Weinstein, about the pipeline of family court lawyers. What's New York doing wrong? Is this a nationwide problem? Again, or is a nationwide problem with family courts and the way litigants are treated? And is it a nationwide problem with trying to recruit judges and attorneys for family court?
I appreciate your question. I think there are multiple parts to it, and each part is a little bit different. With respect to jurists, to me, the grave concern is the training that's offered to jurists, and we had some testimony concerning that earlier today with Panel B. I was fortunate enough, very briefly, to be a court attorney for a family court judge, and my training was the same training that jurists received. I was with jurists. And I can tell you with absolute certainty the complete horror I had when one jurist training the others on the definition of imminent risk, which is a very important term in the hearing that enables parents to get their children home. And the judge says that term means absolutely whatever you want it to be, despite the fact that for 20 years we've had the Court of Appeals precedent in Nicholson versus Scapetta. It was the beginning of an outrageous experience. With lawyers, I think there is, in some ways, there's no other way to put it, people seem to think that family court is beneath the other levels. I think in some ways, perhaps in our youth, we want to seek the highest possible office that we want to achieve. But I know I was inspired by Marty Guggenheim when he spoke, I think 10 years ago at a bar association meeting, in which he said, if you want to be a trial lawyer, this is the work you should be doing, because we are the most trial-ready lawyers in the country. And it's true, and it's about getting that message out. It's certainly a national problem, I think, in some ways, because New York is so well organized, at least the city, compared to other jurisdictions, not just in the state, but nationally. I've practiced in Florida as well. The problem is, in New York, despite being more organized, I think nationally there is a problem with recruitment on both levels because of how the courts are viewed. I know of at least one jurist who left the family court for the Court of Claims merely because there was no way for him to ever become an appellate judge in that role.
Thank you. Now we'll turn to Senator
Except for Judge Kaye.
Mayer for 3 minutes.
Well, thank you all, and thank you for pointing out about these limitation to being appointed to a higher bench, which I have seen as a factor. And the other, just a cautionary, nice to see Mr. Lewis, and happy to be part of the task force that you have, that I'm on. But, you know, you're talking about upstate and New York City, and the suburbs of New York City are neither upstate nor New York City, and yet where a whole lot of these problems exist. So I do think it's important to think about it in a sort of more of a three-part way than a down New York City and upstate. So
That may be.
And then the other thing is on the testimony that you provided from the city bar, two things interested me. One is your proposal for uniform procedural rules, which you've had pushback traditionally from OCA, and maybe there's a new sheriff in town, shall we say, and we're hopeful that that is going to be different. But the other part of your recommendation that is troublesome to me, it is proven difficult to come up with a meaningful and sustained way of talking about stakeholder recommendations with OCA and court leaders and assessing the progress of promised change. So, and then you recommend clear public-facing information regarding implementation. So I would just say, thank you for that. That's one of the reasons why we're having this hearing, is because I think there is a frustration of those who are in the court that their voice is not being heard. So to that end, how do litigants get to your level of expertise in the New York City family court system? How do they find you? How do they pay for you? And is there an effort from the city bar to increase the number of pro bono lawyers who are willing to do this work?
I'm a public defender, so my clients come to me at the arraignment phase, which is called intake in the family court when a petition under Article 10 is
Okay.
filed.
I didn't understand that.
So I run a pro bono program at a private law firm, so I am in charge of recruiting people to work on behalf of clients who are poor, and I certainly, further to the comment about family court offering great trial opportunities, one of the things we sell is not only the virtue of doing work for people who need it and can't access a lawyer by paying for themselves, is the professional development opportunities that accompany it. So yes, the city bar is making efforts. The committee I'm on is the Pro Bono and Legal Services Committee, and we spend time discussing how to increase the number of lawyers who volunteer to serve clients in the family courts, among other places.
But just to be clear, the pro bono part of your law firm, basically, the litigants get to you through the city bar, and then they pay nothing for you and your colleagues'
That's
excellent
right. There are a
service.
number of referral organizations that refer clients to us, and then we represent them for free.
Senator Mayor, if I could just add a couple things. In the rural areas especially, I mentioned one county that is desperate.
Right.
There has been a huge attempt to recruit people to become appointed counsel. The judges have worked for it, the bar associations have worked for it, and our bar association, New York State Bar Association, has worked for it. One of the things that we have done is we have presented to the American Bar Association a proposal to try to incentivize young lawyers to come to rural areas, not just
I
in New
see.
York, but throughout the country.
Yeah.
And it's, you can't do it by handing them money, but maybe you can do it by some forgiveness of student loans. And that's something that we would love to have discussion with the legislatures on, because that's hopefully one way to incentivize people to get involved in this.
Thank you.
Next, we'll have Senator Rollison.
Thank you, Mr. Chairman. Obviously, the Bar Association has a long history in advocating not only for the members of the association, but the judicial system, the legal system, the criminal justice system in general.
Since 1877.
And that's a long time. And have done so much work in that space.
Yes.
So what we're hearing today, certainly when it relates to OCA and some of the challenges within the system, and heard from judges, and I've alluded to a little bit here this afternoon on the difference between the family court, the Supreme Court, your county courts, where family court doesn't necessarily feel as resourced, as evident, and we know that. And there are organizations represented here today. There are others, obviously, out in our communities that, and the judges themselves, I mean, the Magistrates Association. Has there been, to date, any partnership on these types of challenges within the family court system, looking at it from a unified advocacy level? In other words, the magistrates, the bar, the people who appear in family court working together, maybe not on every single challenge, because there could be competing challenges, but doing it that way and saying to OCA, it's not just us, it's all of us. Has that been an experience? Has it worked, or is it something you're working at?
I would say that we are working at it, and as was indicated earlier with Judge Zayas in there, we feel confident we're going to be able to work more on it. We feel that, yes, we have worked with the OCA. We will continue to work with the OCA. I think they're open to listening to suggestions. With regard to working with various groups, certainly the Bar Association is open at any time to consult and to research and to give opinions to not only our legislative branch, but also to the OCA, and we have worked closely with them. So hopefully we can, it's not a quick fix. It's something that we are going to have to work at over time, and it's incremental steps, as Ruth Bader Ginsburg always said.
May I add one thing with regard to the committee's report that you have seen on racial justice? Susan Lindenauer, Chair of the Committee on Families and the Law. The committee report on racial justice and the family court was written and endorsed by members of the committee, who include members of the judiciary as well as representatives of a variety of agencies involved in representing parents in child protective proceedings and individual attorneys and people from the private bar. So the voices are heard in that context.
As part of the settlement of various litigations in the state and the city of New York, groups have come together from OCA, from the stakeholders. Oftentimes the problem is OCA is so defensive coming in, the courts are so defensive, thinking that the attack is personal when it's more structural. And it's a non-starter for a conversation when everyone, or at least the state, the courts are coming in with that presumption that it's in bad faith that we're attempting to negotiate and to create change.
I mean, I would underscore what Michael said, which is that the problem is kind of when you try to engage OCA in conversation about how to make things better, it is often perceived, we feel, as advocates, as sort of a criticism, and you're sort of silenced, which is troubling because it doesn't allow us to provide constructive feedback. Just one very basic anecdote. We were told OCA is redoing the website to make it more accessible. We said we would love to participate because we have clients who can provide meaningful feedback. We've never been talked to about the website redesign. It's been going on for at least a year. We don't even know what stage it's in. And so those are the simple requests that we make, and it doesn't go anywhere. And we're hopeful under the new administration, has been alluded to, that there'll be greater transparency. But right, we can only be effective in advocating our client's position if we have somebody who's both listening and engaging us in that conversation. I mean, the good thing about the city bar, like the state bar, is we have judges, we have private sector people, we have public sector people who are members of the committees that ultimately give rise to these reports that we publish. So it's a consensus kind of communication when we issue reports, and hopefully it informs OCA on what we really want in terms of change.
Thank you, and thank you, Senator Ronaldson. Senator Palumbo?
Thank you, Chairman. And like anything else, I'm always, giving my 2 cents that good government is bringing in all the stakeholders and listening to what they have to say. Just 2 quick comments. Mr. Lewis talked about the 18B attorneys, and out in Suffolk County where I am, I'm the 1st Senate District, so I'm the 5 eastern towns from Stony Brook University to Montauk. That's where I am. And I practiced for many years. And the best lawyers in the building were the 18B attorneys. And we lost so many, I think there were 3 in Riverhead on the panel left. And they said, I'm charging $400 an hour. I'm sitting here at 75 for 6 hours. I can't feed my kids. This is not the way to run a practice. So that's a big concern.
Let alone pay your secretary.
Right, and incrementally, as you just mentioned, hopefully we're getting there. We'll see some progress. And Mr. Weinstein, I think that just a funny comment that from practicing, I was an ADA in Suffolk County, was a supervisor, and then went into private practice with someone who did a lot of family court matrimonial work. And I can just think of how many times when you're in there and the petitioner calls, what's your name again? Yeah, go ahead, get up there. Just you really learn how to try a case in family court, no doubt about it. And really my comment generally to all of you, and where I'm looking for some feedback, is the standards and goals issue. I practice primarily now in Supreme. And they beat on you on a contract case to get this thing certified or else. And they really twist arms. And you can't really see that. And I think it's more of a volume issue, but you don't see that in the family court. And I should probably ask panel B these questions because I didn't think of it until now. But you guys all have access to a lot of data. What suggestions would you have to have maybe a more firm standards and goal issue where, as I was saying earlier, maybe you can tap them out to trial. Say, if you guys don't have it resolved by then, too bad. You're going to trial in 2 weeks. Get your act together. What say you?
So I can say this: standards and goals is a bigger problem in family court. There's no question. One of the reasons it's a bigger problem is because we have a dearth of judges and we have a dearth of attorney practitioners. And so what ends up happening is the judge tries to set it for trial, and attorney number 1 says, I can't do it that day. I'm down the hall in another case. And,
Yeah.
and then they come up with another one, and.
That's what I was saying before. And then the AFC is like, I'm on trial that day,
And
Judge.
I'm
We
on
need to go
trial.
another 2 months.
Exactly what you
Yeah.
said before. So that I think is one of the problems. Delays are not just built into the system on purpose. It's because we don't have the personnel on either side of the bench to really keep things moving. And I think that's one of the places we have to look for resources.
I think the calendaring by the courts is atrocious and speaks to Mr. Kathwala's point concerning the need for rules. I mean, the Family Court Act itself refers to these rules, which have never been promulgated. The legislature, wrote that in contemplation. Because of the various types of hearings and the various precedents that they take, so the emergency hearings have to be done within a certain period of time. This is both in the juvenile cases and as well in Article 10 proceedings. The judges routinely don't follow the requirement of the time. And then everything, not just that emergency proceeding, gets pushed down even further. And it becomes a snowball effect. You'll have a judge attempting to hold a combined emergency hearing under the imminent risk standard with a fact-finding proceeding that's a completely different standard. How do you do that? It's unclear because you can't, because there are competing standards, different evidentiary rules. And trying to parse that all out when you essentially have one system per county of the family court is impossible. It's all disjointed.
And I
Thank
would
you.
just say that, if I can, there are a number of family court rules that govern timing, right? Like, for example, in custody cases, the case has to be decided within 90 days from the date it starts. So what happens is the judges never start the hearings. So you have prolonged adjournments to try to settle the case. They know they have to comply with this rule. So it's like, so that I would respectfully suggest that's a case where if timeframes are codified in statute, you can bring lawsuits under them. I've filed a couple of lawsuits on timing requirements, some successful, others not, but at least it provides an oversight mechanism for accountability. And I think the previous panel, there was a woman talking about accountability, and I think in the federal system where I clerked, right, my judge was told by the chief judge, you have 35 cases who are above standards and goals in the federal system. It's not called that, but like, right, they're held accountable, and they know they can't have these cases lingering for years. And I think accountability by OCA is critical.
Thank you.
Thank you, Senator. Thank you very much. We'd love to facilitate conversations between practitioners and OCA. I know the bars do that as well, but anyway, we can be helpful to make sure your opinions and expertise are considered is something we would like to pursue. Thank you very much.
Thank you.
Thank you.
all for your time.
Thank you.
Our next panel is consisting of Jacqueline Franchetti, founder of Kira's Champions,
Nice to see you.
Wayne Baker, executor of the estate of Catherine Kasanoff, Natalie Blundell, representative from We Spoke, and Andre Rainey, New York Chair, National Parents Organization.
Maybe he left.
Oh, we have a fourth person?
I don't see Andre.
Andre?
Oh, there he is.
Oh, okay.
Where is he? Oh, there he is. Okay.
Thank you. Jacqueline, 5 minutes, please. Thank you.
Today, I'm going to talk about
Oh, if you could push the mic closer,
sorry.
thank you so much.
Today I'm going to talk about 25 children. The first, a 2-year-old toddler who was shot and found inside a burning home. A 5-year-old girl who had her throat slashed and her mother's body was found nearby, with her head separated from her body. And a 3-week-old infant who was shot to death while in her mother's arms with a crossbow. These brutal murders did not happen in Gaza, in Israel, nor Ukraine. They weren't killed by Hamas or ISIS. These 3 children and 22 others were murdered by their own parent in New York State due to the failures of New York's family court system. They were going through divorces, child custody cases, or separations. That's 25 funerals, 25 burials, 25 lives needlessly destroyed. As the mother of the first child that I mentioned, the 2-year-old girl who was shot twice in the back by her abusive father and found inside a burning home, I want to ask you these questions. What would you do if the worst thing in the world happened? What would you do if your own child was murdered? And what would you do if you could prevent this from ever happening again? I'm Jacqueline Franchetti. I'm the founder of Kira's Champions, which is founded in memory of my daughter, Kira, who was murdered by her abusive father. And we're dedicated to bringing forth common sense changes to protect children from abusive parents in custody cases. Senators, I thank you for the time today. And I also recall 4 years ago where I was in the overflow room testifying about the horrors of family court system. And here we are 4 years later, and children are still not safe when going through custody cases. That must change. We must pass Kira's law. We must make it the first bill that the New York State Senate passes in January. New York children need action now. Kira loved Elmo and Mickey Mouse, and she deserved to live to her 3rd birthday, her 4th birthday, her 5th birthday, an opportunity she was never granted. Kira's abusive father was not using drugs or addicted to alcohol or anything like that. He was an abuser, and he wanted to hurt me, and he did, using the family court system. I can stand here and tell you I did absolutely everything I was supposed to do. I left an abusive relationship. I got out to protect Kira when I was pregnant with her. But we're not told what happens once we leave and we have a child with our abuser. Because once you enter New York State's family court system, the abuse will get exponentially worse. The very first time that I walked into Nassau County Family Court, and I told the judge that I was being stalked, harassed, threatened, that I was terrified for myself and for Kira, she yelled at me to quote unquote grow up. That was her response. We had Child Protective Services involved in Kira's case. They noted that he had extreme anger and rage issues, an inability to care for her at a young age. And they labeled it no risk and low domestic violence. We had an attorney for the child involved in Kira's case. I begged him repeatedly to get more involved. He refused, even 5 days before Kira was killed. And we had a forensic child custody evaluator. And Senator Mayer, as you mentioned, the bill from Senator Harcum. The field of forensic child custody evaluators, this is the wild, wild west. And there's a tremendous amount of reform that needs to happen in that space. I was part of the Blue Ribbon Commission. There's 11 recommendations. Only 1 has become law. We need 10 more to go. And at our last hearing, the judge said to me, quote unquote, this is not a life or death situation. Days later, Kira was shot and killed. And do you know how New York State's judicial system responded? Do you know what their voice of accountability was over this case? They promoted Kira's judge to Long Island Supreme Court. There's no accountability. Judge Rivera mentioned that we could appeal this. My daughter's dead. How do I appeal this? Since Kira's murder, I've been very active in trying to bring about common sense changes, reforms to New York State Family Court. I put forward a package of 8 bills. Thank you, Senator Hoylman-Siegel, for your opportunity to work together on mandating training for forensic child custody evaluators. It is signed, and actually the training, yes. And the training starts this month. but we have more to go, specifically Kira's Law. And I want to thank all of you on the judiciary, by the way, who did vote for this and pass it out of the Judiciary Committee. But we need to bring this to the Senate floor, and this must pass. Kira's Law does 3 critical things. First of all, it's going to make child safety the top priority in a custody case. What could be more important than the safety of the child? Second of all, it will mandate judge training. Our judges are not properly skilled, nor are they properly trained when it comes to family violence and child abuse. Unfortunately, they are looking at those few pages of a PowerPoint deck. The training is not adequate, and it needs to be addressed, and it will be done in Kira's Law. And finally, Kira's Law will stop common practices that allow abusers to gain custody at staggering rates. In my case, I was told just because he abused me doesn't mean he'll abuse a child. Well, that's ridiculous. You need to look at the full picture of family violence when assessing these situations. We have a package of 8 common sense bills. 6 are around forensic evaluators. Senator Palumbo, Senator Skoufis, you've been integrally involved in developing these, and thank you for that. We need to advance this entire package, but most importantly, Kira's Law to protect children in custody cases now. And while I talked about 25 children, that doesn't take into account the staggering number of children who are beaten, raped, emotionally devastated, and destroyed when they're court-ordered into homes. And that also takes into account the number of women. There's actually a horrible trend, which I know the next gentleman is going to talk about, where women are now committing suicide because their lives are destroyed by family court. We need to change. Another thing I just want to address with Kira's Law.
If you could just wrap up. Thank you so much.
Yes, of course. There are many studies that have been done that talk about how important this is. The National Council of Juvenile and Family Court Judges put out their model code. It is a mirror of Kira's Law, and we need to have this happen. So let me ask you a question. When do we make changes? Clearly, it wasn't with 25 children. It wasn't with 24. Is it when we have a murder count of 50, of 100? When will we enact Kira's Law? When will we make sure that children are safe and protected when going through custody cases? And thank you for your time.
Thank you so much, Ms. Franchetti. Mr. Baker, 5 minutes, please.
Thank you. Yes, this is the tragic story of Catherine Kasanoff, a mother who was caught in the throes of a failed and unethical system. And I'd like to say, listening to everyone speak up to now, the system is broken across socioeconomic strata. It's broken everywhere. Some of you may be aware of her story. All of you should be able to understand the pain and sorrow she experienced. I'm Wayne Baker. I'm the executor of the estate of Catherine Kasanoff. After 4 years, more than 4 years of fighting for custody and to have time with her 3 young daughters, and through this process, when she was under supervision or not allowed to see them, she watched her children suffer, deteriorate, self-harm, and the stress imposed by this unending process. And she couldn't watch it anymore. She couldn't see her girls go that way. So on Memorial Day weekend, Catherine ended her life through medically assisted suicide. She made this decision after the court suspended her visitation with her children indefinitely. That was the order. You see, Catherine could not live without her girls in her life. And the court said she could not live with them. Catherine was a colleague and a friend of mine for more than 30 years. We worked together as federal prosecutors in the Eastern District of New York. Catherine was later employed as counsel in a counsel position to 2 New York state governors, Governor Cuomo and Governor Hochul. Her divorce took place in Westchester County. Over the next 4 years, more than 3,000 documents were filed in the case. It cost her, she had more than $500,000 in her attorney's fees. The divorce, custody, and family law system in Westchester is implemented to utilize as many attorneys, AFCs, forensics, therapists, and experts as possible, and for as long as possible, or until the party's assets are wiped out. The system claims there's not enough judges to handle the caseload. We've heard about that. Obviously, that's a problem that needs to be addressed. But no divorce custody matter should take 4+ years and counting. The relationship between the judges, the attorneys, and the experts are openly based on mutual reciprocity, improper communications, and favored status for the money party. As Ms. Jimenez explained in that first panel, the personal and professional connections between certain attorneys and the experts and the AFCs and the judges, that's what dictates the results. Not the merits, not the facts, and clearly not what is in the best interest of the children. At the outset of her case, one of her 3 daughters reported to the school that the father had kicked her. And that was reported to the school, and then ultimately CPS got involved. When CPS came, they told Catherine, you must get a temporary order of protection against your father on behalf of yourself and the children, or we're going to take the children away. So she did. She did what she was told. She went to family court. She got the order of protection. The next week, the father filed for divorce in State Supreme. The order of protection in the hearing went to the State Supreme, and it was lifted. The temporary order of protection was lifted against the father. You talked about parental alienation. Well, the father and this forensic custody evaluator both alleged that Catherine had alienated the parent, had alienated the father. And this happens, from what I've seen since this matter, regularly when someone alleges any kind of domestic abuse. The answer is always parental alienation, or DARVO, as had been mentioned earlier. Judge LaBelle rubber stamped the evaluator's recommendations. So Catherine immediately evicted from the marital home, and she spent 2 years living with friends, living on couches of friends, temporary housing arrangements, and only allowed to see her children when a supervisor was present. So she looks into this forensic evaluator, Mark Abrams. She found he had numerous misogynist social media postings. Speaking with other women he evaluated, she discovered that Abrams sexually inappropriate actions he suggested, and he sexually harassed these women. He's telling them right off the bat, I'm going to decide your custody. And then he says to one, lay on top of me. I think that'll help you relax. Catherine filed complaints. Abrams was removed from the panel. But why was it that she had to be the one to... These were available facts. There were complaints. Where was the court oversight? And to make matters worse, Judge LaBelle, at his home, had presided over Abrams' marriage not long before. And this was never disclosed when Judge LaBelle adopted Abrams' recommendation over objections. Forensic evaluations are utilized with far too great a frequency. Now, somehow the court gets away with not allowing the party to receive a copy of the report. So it's about you, but you can't have a copy.
If you could wrap up. Thank you.
Thank you. So that is obvious serious due process concerns. Anyway, when we talk about these matters, why, can you answer this? Why would a mother, after 10, 8, and 6 years of parenting her children, suddenly need supervision before she can spend time with them? Is it because the parties are getting divorced, or is it because she alleged domestic violence? Her story and her videos were seen by more than 30 million people on TikTok. Fortunately, that produced such outrage that the father had to resign his partnership at one of the city's most powerful law firms, Greenberg Traurig. Please ensure that some action is taken so that Catherine's experience never happens to another mother. Thank you.
Thank you. Ms. Blundell. 5 minutes, please.
Sure. Thank you for the invitation to speak, Senators. My name is Natalie Blundell, and I represent the grassroots peer-to-peer organization We Spoke. I founded We Spoke in response to persistent reports from domestic abuse victims that the trauma and abuse they were experiencing in New York custody courts was much worse than the experience they had in their relationships. and that the children were consistently being endangered and directly harmed by court practices. What we have learned is that this goes far beyond abuse victims and impacts all primary caregivers in custody courts. Our members are women who have typically compromised their own careers to serve as the primary caregiver of their children. They were never accused of parental unfitness or mental illness prior to their separation, and they seek to co-parent amicably. They consistently report they are being subjected to prolonged litigation until they can no longer afford legal representation and are subject to unequal coercion to sacrifice their parental and due process rights. They report that their children are suffering unconscionable harm by court practices. Senators, we are an all-volunteer network and don't pretend to have, our research is exhaustive. However, we've reviewed our own 2-year-long survey results, data from the NICEF website and Part 36 rules database, plus documents, recordings, and contemporaneous accounts submitted to us by litigants. We also FOIA'd the public administrative records from OCA, but they refused to provide them. The deeper we dig, the more we are shocked to learn. Our findings indicate an environment in both the family and matrimonial courts which incentivizes, enables, and rewards unethical and illegal activity with structural incentives for litigation and court abuse. It is little wonder that women are killing themselves and that men are killing mothers and children and even judges across the nation. It's little wonder that the public's faith in the integrity of our government is in tatters. Families turn to the courts for help, yet we believe for the sake of avoiding the accountability and administrative hassle that comes with trials and appeals, the courts are prolonging litigation and applying pressure to already fractured families to tip them over the edge into collapse and despair. Too many practices are followed and outcomes determined with a reckless disregard for the best interest of children. Meanwhile, in sharp contrast, there's a festive atmosphere in the divorce industry, with attorneys and court appointees joking with each other and flaunting their vacations, parties, campaign events together with judges as families sit crying on galley benches. And why shouldn't they be celebrating? They're driving new cars, dining out, and moving into homes funded with the liquidated assets, homes, retirement savings, college funds of the children and the families trapped in the courts. They're abusing helpless litigants, usurping parental authority, and preying on families, all with zero accountability. So we have a slate of recommendations and requests that we have submitted to you in written form and we posted on our website. First, we ask that you request a Moreland Commission by the Governor and that you conduct your own joint committee investigation under Article 4 of the legislative law, with particular scrutiny on how prolonged litigation and coercive practices are affecting New York children and parents. Second, we've submitted a slate of 11 specific legislative proposals, but we'd like to highlight 4 now. 1, amend and enforce Section 205.14 of the Uniform Rules for Family Court to mandate that judges deliver child custody and visitation determinations within 6 months of the preliminary conference in any contested child custody case, which does not also include an allegation of abuse or have safety concerns. 2, establish an independent body to routinely monitor and report to the court's compliance with New York state law. 3, establish a dedicated family court whistleblower hotline for reports of unethical or illegal conduct by court professionals. And 4, mandate the installation of cameras in all courtrooms with recordings accessible for review by an independent body external to the New York judiciary during routine audits. We believe this legislation will enhance transparency, accountability, and due process in the courtrooms and protect the best interests of the children and families while easing court congestion and promoting a culture of dignity and respect. Thank you.
Thank you, Ms. Blundell. Next is Mr. Rainey, New York Chair at National Parents Organization.
Yes, sir. Good, excuse me, not good morning, good afternoon, elected officials and distinguished board members and the people of the state of New York. Thank you for allowing me this opportunity to speak. My name is Andre Rainey. I'm the former mayor of the great city of Peekskill, New York, current chair of the New York chapter of the National Parents Organization, proud father of 3, soon to be 4 next month, and a lifetime youth advocate. I'm here today to express the need for meaningful reform in family law, a reform that brings equality, justice, and above all else, a focus on the well-being of our children. It is my belief that the state of New York must adopt a shared parenting bill, not in the distant future, not even tomorrow, but now. I stand before you as a father who has weathered the storm of inequality, bias, and systemic failures within our current judicial system. After submitting 55 foiled pages of the domestic violence history of my spouse, of my ex, 82 violations, 7 petitions to enforce the court order, I finally received equal custody of my daughter. During that 2 years of equal custody with my daughter was the greatest experience me and my family's ever had. Unfortunately, without my consent, the mother of my daughter moved out of our county to Beacon, New York from Peekskill, and the judge granted her full access and made me a visiting parent again. So the ball starts all over, even with all of the information that was submitted. Judges claim to be overworked and overwhelmed. They often fall short of considering the well-being of the children. Accountability is missing, and too frequently respect for well-meaning parents is not existent. My battle lasted over 2 years, cost thousands of dollars, and caused insurmountable strain between myself and my child's mother, all in the name of equal, fair custody. The law as it is tends to create rifts rather than mend, cause resentment rather than curb, and to propagate stereotypes rather than evolve with the times. Contrary to what some may believe, responsible, loving parents are not the exception but the rule. And it should not be the labor of Hercules for a father to play an equal role in his children's lives. We look at the states like Kentucky, for example, a strong testament to the power of shared parenting. In the wake of passing their shared parenting bill in 2018, domestic violence cases has dropped by 40% from 2018 to 2022. A shared parenting bill does not equate to opening the back door for perpetrators. It equates to ensuring fairness, justice, and balance for true parents. To those who fear that this bill may provide abusers easier access to their victims, let me be clear, I'm a victim as well. But I still believe shared parenting legislation should always incorporate careful safeguards to protect victims of domestic violence, regardless of what gender they are. We need to focus on setting better norms for our children, demonstrating that a system can function with fairness and that love is gender blind. No child should be taken away from a loving parent due to systemic biases or overwhelmed judges. No parent should bear the brunt of a system lacking in efficiency and accountability. We must consider the gravity of what we are addressing today. At stake are not just parental rights, but the futures of our children. This necessitates that every individual working within our judicial system exemplify the principles of respect, empathy, fair judgment, and not perpetuate a cycle of anger and misunderstandings. Take as an example the case of support magistrate Jean Patsalos of Dutchess County Family Court, well known to have acquired the title of the Yeller. She holds a crucial position with our judicial system. To the support magistrates of the world like Jean Patsalos of Dutchess County Court, who's developed this reputation, we need to clear out the family courts of people like her and use these courts for what they're supposed to be for, resolving issues and ensuring the children have the best possible outcomes. The family court chamber should not be an arena of disharmony, but a forum of resolution. The measures of a judge's success is not solely rooted in the gavel's echo, nor the compiled laws recited, but rather it lies in the outcomes that they co-create with the individual standing before them. An objective periodic assessment of these outcomes, to me, is crucial. What explicit verifiable proof do we possess to indicate their performance to be of benefit or detriment to the families under their jurisdiction? Are black and brown families walking through the hallways of courts emerging with fairness, with justice served no less than their non-black and brown counterparts? Are families of lower socioeconomic status, particularly those who are white, being provided with the diligent attorneys who genuinely advocate for their interests? Is there a comprehensive evaluation system in place to ensure that legal guardians are both adequately prepared and sincerely invested in prioritizing the best interests of every child they represent? Our children deserve nothing less than the best. They deserve officials who approach each case with a sense of balance and understanding. And above all, justice. It's important that we as public servants seek to refine these processes, replacing antagonistic figures with those who can truly champion the needs and rights of both children and parents. This will send a clear message to our citizens, especially our children, that love and parenting are boundaries beyond which prejudice and bias have no place, for our children and our society, and most importantly, for a balanced and fair, prosperous future. Thank you for allowing me the time to speak.
Thank you very much.
Thank you, and I just want to, thank you, for your testimonies, and also for all the witnesses that are patiently waiting. I do thank you for your patience. We will absolutely make sure we hear from every single panel and every single witness, so thank you. So I have no questions at this time, but I'll move on to our first senator, Senator Mayer.
Well, thank you all for all the tremendous sadness of your testimony, which is so important here today. And thank you, Jacqueline, for continuing to push us to make sure we pass this bill, which I'm hopeful we will do. And Catherine Kasanoff was my constituent. I had the honor of meeting with her before her death. And one of the things that she and we spoke was so adamant about was this requirement of an evidentiary hearing, an actual hearing rather than the court's opinion, particularly, within 6 months, which is a completely reasonable period of time. In her case, I'm trying to recall, was there ever an actual evidentiary hearing?
There is, my understanding is there's a court case that mandates that anytime a custody determination is changing, there has to be an evidentiary hearing.
Right.
However, my understanding also is that the court system has put down their own memoranda that pertain to the courts, and in one particular case, the memoranda said you do not have to do that. You can make a determination without a hearing. That was a lawsuit that was brought by the New York City ACLU. They received that one memo, they asked for the others, and OCA appealed it, and that's supposedly on appeal. But the law, there's case law that says you must have a hearing. In her case, there wasn't. So these determinations were made strictly on the recommendation of an AFC, and she never had a chance to have a full hearing after 4 years. And she just couldn't allow this to keep going because she saw how it was hurting her children.
Well, I also want to thank you for being here, because I felt after her death, not knowing the merits of the case, that someone who says they committed suicide because something that happened in our court system should have at least responded in some kind of way. Perhaps they did internally, but the external world, and as someone who was her senator and met with her, I did not feel that occurred. So I appreciate your being here to represent her perspective and to make sure her story is told.
And I thank you for that.
No, and Natalie, thank you for your work and your specific legislative recommendations, which we need to go over. But I think you mentioned having a whistleblower complaint line. Obviously, that poses challenges because every adverse decision could be the subject of a whistleblower complaint. What's your answer to, well, everyone's going to call because everyone is dissatisfied with the result?
Yes, agreed. It's less so for the public. I think there are people that are part of this system that know too that they want to speak up. We heard in session A this morning, from that speaker, that when she did lose her job, she's, whether it's correlated to speaking up. So internally, I believe that we should at least have a dedicated one. There's a national one for courts, but specifically for the family court system. Internal, yes.
Okay. And thank you, Mayor Rainey, and thank you for your continued advocacy on behalf of men who have sought in good faith to retain custody. Do you have joint custody now?
So we had equal custody at one point. Once she started school in September, because her mother moved, we now have what they call joint custody. So the equal custody we had was we split 5 days a week, every other week. So week 1 and week 3, I would have my daughter Sunday, Monday, Tuesday, Friday, Saturday. and it would alternate. Now I have her Wednesdays from 5 to 7 and every other weekend. And I know my time was short, so I won't do it, but I just wanted to share. My 10-year-old son wrote a letter, and he asked me to give to the judge, and I have to consistently make up stories for my other children of why they can't see their sister. But he even wrote in this letter asking the judge, I used to see my sister all the time. Now I see her 4 times a month. Can you make it fair? And it hurts me to see that, you know. And the reason why I don't have my daughter is because she decided to move out of the county. There should have been something in place to protect me from saying, or protect anyone from saying, that this person could take my child away from me simply because they moved. And I'm also a victim of it. My mother moved to Germany when I was 2 years old, when my father fell in love with another woman. And I didn't see my father again until I was 17 years old. So it's not just a matter of addressing the issue, it's about the generational curse that needs to stop. And now I have to explain to my other son and my other daughter that you're not going to be able to see her because, you know, she's busy, her mother's busy, and we're busy too. So, but the truth of the matter is she was allowed to take her out of the county and change the complete custody because she decided to move. And it's just unfair.
She had court approval to move?
She had court approval to move.
Okay, yeah, thank
And
you.
just for the record, there's no domestic violence history on my side at all.
Yes.
Towards her, towards anybody. But from her, several cases. And the judges, even on record, and even all of my transcripts, I asked the judge, how many documents that I submit did you actually read?
Thank you. Thank you very much.
Thank you, Mr. Rennie. Senator Skoufis?
Thank you, Chair. And I want to thank all the panelists for your courage in sharing your testimony. I especially want to thank you, Jacqueline. You know, we, and I've said this before, you know, we in the legislature, we oftentimes, as we discuss constituent issues or bills, we use words like unthinkable and synonyms, I think, pretty freely. But what you've endured is truly unthinkable. And so thank you for being here. Can you answer how much time lapsed between the start of your family court proceeding and when Kira was murdered?
We started in Nassau County Family Court when she was 6 weeks old, and she was murdered at 28 months old. And during that time frame, there was no opportunity for me to bring forward more evidence to prove that he was abusive, dangerous, and the abuse was escalating. And Senator Mayers, you were talking to the colleagues here about having a hearing, an evidentiary hearing early on. One of the things we wanted in Kira's law, which was really because of my custody case with Kira, there was no opportunity for me to come forward and to protect Kira through the duration of the custody case. Our trial would have been in October of 2016. She was murdered in July of 2016. We need to have the opportunity for an emergency hearing, a safety check hearing, to make sure that a child is safe. This is something that was part of the original version of Kira's law. We now have the A version. We had to take that out because of fiscal considerations, because of budget. I would implore upon all of you to work with us to find the money to help us make sure we can protect children in custody cases, because these custody cases, these divorce cases, like I know some of yours, these go for years and years, and there's no opportunity to protect a child, and we need to make sure that happens.
When did you begin raising sort of the equivalent of red flags with the judge that your partner at the time was abusive?
Day one.
Day one.
Day one.
And summarily ignored, would you characterize it as
completely,
such?
not only completely ignored, but then I was the one who was in the wrong. I was dismissed, discounted, and not believed.
One would think that when an allegation like that is raised in court and there's a child at stake here, that I think most sort of normal judges would say, okay, let's hold on before we determine visitation, before we determine any rights. We need to figure this piece out because this piece could put the child in harm's way. But that certainly didn't happen in your case. What was, I touched on this a little bit earlier with a line of questioning. what was the background of the judge? You know, so he was elected, right?
So
What were
Judge
his
Danielle-
qualifications?
Judge
What was he
Danielle
doing?
Peterson was in family court and practiced family law. She is also the daughter of a prominent Republican Party candidate in Nassau County. And one of the things that's incredibly frustrating about judges that are coming onto the bench, when she moved from Nassau County Family Court to Long Island Supreme Court, she ran an election where there were 8 candidates and 8 seats. That's not an election. That's an appointment. And that's happening in far too many counties all around New York State. You know, we shouldn't have Nepo judges. We shouldn't have candidates who shouldn't be there. We should have an election and the ability to find out more about them before they enter and get on the bench.
Thank you.
Thank you. And next we have Senator Palumbo.
Thank you, Chairman, and thank you all for your testimony. I think this is extremely important, as we all obviously, I mean, it goes without saying that. Jacqueline, we've been talking about this for years. You've been quite a champion, and you've brought about effective change, and you're going to bring about even more. So keep up the fight. And without, I don't want to belabor some of these issues that we've discussed somewhat at length, but it almost seems like the takeaway I'm getting is really specific to family court. Training of judges, and this is what I want to hear your comments, is really the most significant factor. Because we have judges all the time, having been a lawyer for 20 some odd years now in the county of Suffolk, where there are political aspects to it. They get cross-endorsed, and they were a town attorney who did what they had to do for the party, and off they go to county court, handling murder cases. You're not going to let that individual, and the administrative judges are at least slick enough to say, well, we're going to give them, you know, maybe some drug cases, maybe some larceny cases. We're not going to give them the sexy, really nasty murder case where there's going to be outstanding lawyers on both sides and it's going to be a brawl. That judge is going to do something that'll probably ultimately overturn a conviction. But that's not the way in family court. Even election law cases, they get steered to certain judges who have that skill set. So even though we have, in your example, someone who was a practitioner so much, as we've heard today, the training aspects are less than what we have to do every 2 years for CLE as lawyers. So it almost seems like that's the takeaway, and I just want to hear your comments. Maybe it should be such a specialized court that they will have an overwhelming amount of oversight, which is much more important to deal with the bad behavior, and we need to have them fully educated so that they don't. So imminent risk isn't something that's completely subjective, as we heard before, that, whatever you feel like, Judge. Today it'll be something, tomorrow it'll be something different. And whoever's in front of me just happens to be the lucky candidate when I get that case that day. That's not a judicial system I'm proud of. So go ahead and comment. I'm sorry, I was talking away.
Thank you, Senator Palumbo, and I absolutely agree with you that New York State judges, family court and Supreme Court, must have domestic violence and child abuse training. And it is not adequate right now. From the judges that I have spoken to, it is not mandated. While it is offered, it is not mandated. So they are not taking this. And it needs to be done by the right people. And if it is mandated right now by OCA, then it's not being conducted properly because we have judges who don't know their wrist from the elbow when it comes to abuse. And that cannot continue. And I can use my case of the number of cases, but I'm certainly going down the line. I think you'd all agree how much they don't understand the dynamics that are at play here.
Sure,
But-
and not so much, I'm sorry to cut you off just because I'm out of time, but not even so much in this most severe, awful situation like yours. Mr. Rainey, you've got that same issue where you have a
Yeah,
judge
I
who
would-
didn't really understand and just made a
I
decision.
would second what she
that
said.
was
I
adverse
would-
to it, so I'm sorry to cut you off.
Yeah, I would also second some of the things she said, cameras, in the courtroom. One of the issues that I had in my experience in Dutchess County was when you leave the courtroom, there's a little wall with a banister of papers in it of transcript companies. And literally 95% of the numbers, it's 14 pages of back and forth, front and back documents. 95% of those numbers don't even exist anymore. You can't. The ropes I had to go through to get the transcripts that I got from my hearings was ridiculous. But it's like, This is supposed to be provided to the people who use this service every day. The taxpayers use this service every day, and we can't rely on it. That's scary to me.
That's a good point.
If I may, when Senator Schofield was talking and asking the two judges that were sitting here about accountability, and they took a little bit of defensive to it, and I think what needs to be done, and this is from a law enforcement background, is when you have an after-incident hearing, when you have a catastrophe, like in Kira's case or in Catherine's, the parties that have interest and have oversight have to sit down and look at it and say, what was the cause? What led to it? What were the contributing factors? Let's look at that. Let's have a sit down and you work through it, and then you can come up with certain remedies, conclusions, and at least then project to all the other judges, listen, when you have, these type of circumstances, you must give these people their custody hearings. It's got to be, an evidentiary hearing.
Thank you. And just a couple of points. One is on cameras in the courtroom. The Senate did pass legislation to that effect. Has not yet passed the Assembly, and we had it in our one-house budget bill as well. So we'll continue to press that. And then on accountability, there are 49 other jurisdictions where I think New York should be looking to see how we can seek that reflection at the very least when outcomes are so tragic and misguided as we've seen and heard from our witnesses. We have to go to the next panel, but you can have the last word.
Oh, the last word. It was just another point about training, just to follow up with Senator Palumbo. It can't be just domestic violence and child abuse training, because domestic violence is always changing. It's always changing. And I was last month. I listened to the UN Special Rapporteur speak, and she's on violence against women, and she is carefully watching the family court system in the U.S. because she feels that is an emerging form of violence against women within the courts. What's happening there. So judges have to be trained also on coercive control, post-separation abuse, DARVO, as we heard from Senator Ramos earlier this morning. So it's complicated, and it feels this is a lot to ask judges. They're doing a lot already. So there's a lot to take in here.
Thank you very much. Again, your insight is very appreciated. Our next panel. Thank you. Amy Mulzer, Senior Attorney, Family Defense Law and Appeals, Brooklyn Defender Services. Nicole Velasquez, Deputy Director of Family Defense Practice, Bronx Defenders. Zainab Akbar, Managing Attorney of Family Defense Practice, Neighborhood Defenders Services of Harlem. Jennifer Feinberg, Litigation Supervisor for Policy and Government Affairs, Center for Family Representation. We're going to do 3 minutes for each panelist.
I'm going to be listening. I have to go catch the jitney. Thank you. I'll be listening.
Ms. Mulzer?
Submitting testimony, written testimony, and so we've sort of made our own order.
Of
if that's
course.
all right. Okay.
You
and
made your own order. No.
We hopefully.
I
get
like.
through-
Yeah, if you could identify yourself
Yes, of
for
course.
media
Of
services
course.
before you
Sure.
each testify. Thank you
Sure.
very much.
And I will do my best to get through what I thought was going to be 5 minutes.
I
in 3
know. I'm
minutes.
sorry. We're just running short on
That's
time.
all right. I completely understand. So my name is Zainab Akbar. I'm the managing attorney of the Family Defense Practice at Neighborhood Defender Service of Harlem. Thank you, chairs and the members of the committee, for this opportunity to testify.
Could you bring the mic closer?
Sure.
And let's start her clock again.
Now that you know who I am. So I'm here with the Bronx Defenders, Brooklyn Defender Services, and the Center for Family Representation. We collectively represent agencies who provide public defense in New York City's family courts. Our organizations have taken the lead of impacted communities and have affirmatively adopted the phrase family policing system to describe what has traditionally been called the child welfare system, a system which includes and whose ultimate escalation is referral to family court. We choose to call it the family policing system to reflect the system's prioritization of surveillance, punishment, and control of low-income Black and brown and other marginalized communities rather than genuine assistance to families. When you walk into New York City Family Court, and you will be struck by the number of Black families and the obvious absence of white litigants. Over 90% of the parents we represent are Black, Latine, and people of the global majority, with a majority identifying as Black. Racism and bias play into the decision-making at every stage of the family policing system, from who is reported, investigated, prosecuted, temporarily separated, found unfit, and ultimately which families are permanently separated through the termination of parental rights. We have been collectively keen observers of the functioning of New York City's family courts for nearly 2 decades, and we can only conclude that the family courts are constructed and managed in a way to perpetuate the same racism and bias that appears in every other stage of the family policing system. As you've heard all day today, the culture of racism in family court is pervasive. And I was going to talk about the Jay Johnson report, but I will move forward a little bit from that. Even after that report was issued, nothing has changed. Family courts rubber stamp the decisions of the family policing agencies instead of functioning as the intended check on those systems. Instead of protecting fundamental constitutional rights to family integrity, the family court resoundingly fails to ensure that parents and families appearing receive even the most basic protections and due process that the law requires. Prioritizing expediency over fairness, humanity, and just outcomes, the family court functions as an arm of the state, of state power, rather than the neutral arbiter of fairness and justice it's supposed to be. And I was also going to just talk about the Franklin Williams Commission, but I'll say that everything that came out of that report conforms with what we experience every single day. And I wanted to share a personal experience that I had of a racial slur being used against me on the record by a very senior judge in Manhattan Family Court. And we can talk about that in the Q&A if you are interested.
No, please do.
Yeah, you want me to share now? Okay. I'm not going to go into the details. I'm not here to necessarily name names, but as one of the only 3 people of color in the trial that was happening, me, my client, and his daughter, to whom his rights they were seeking to terminate, I was objecting, as I should, as my client's lawyer, to questions that were objectionable, and was told to not make another swarthy comment. And my client was not an English speaker, so that was, he was not an English speaker, so I'm not sure how that was translated, and I didn't speak the language that he spoke, but there's only one definition to that word, and that's dark-skinned. And I was the only person, and my client and his daughter were the only people of color in that room, including clerks, attorneys for child, all the court staff. And this is a very senior attorney, and I escalated that experience to judges who are supposed to be in charge of making sure that there's fairness in court and aware of racism in court, and was basically told we can't really do much. And then I escalated it to the IG, and nothing really happened. And if I, as the managing attorney, am being treated like this in court on the record, you can kind of imagine how our clients are treated, right? And our staff and our clients regularly face implicit and explicit racism, sexism, heterosexism, xenophobia, ableism from judge and court staff alike. From their first appearance in court, families are met with suspicion and contempt. Dehumanizing language is nonchalantly used by ACS attorneys, attorneys for children, caseworkers, court attorneys, court officers, and judges to describe our clients and their relationships to their families. Family court players consistently display a complete disregard of our clients' schedules, their obligations, their arduous demands of court-ordered services. And those same players insensitively laugh, joke, roll their eyes, and make light of the proceedings. And those same players then rely on stereotypes, tropes, and narratives deeply rooted in this country's history of racism and classism and other forms of structural oppression. And like in my own experience, there is zero accountability. And I'm going to try to just wrap this up really quickly, but what we also see is that when a parent doesn't conform to idealized values of white middle class society, being polite, being deferential to authority, having insight into their limitations, that results in fewer reunifications, longer time in foster system, more surveillance. But when clients have emotions when their families are separated, or when they question unreasonable directives from the foster agency or ACS or the court, or they raise concerns about the care that their children are getting in the foster system, they're viewed as angry, difficult, non-compliant, lacking insight, and then often considered mentally ill, when they're really just being human and having human experience. And that then results in more punishment from the court and the family policing agency. There's also a problem of the New York statutes requiring judges to make subjective decisions, which then allows implicit bias and racism to play a significant role in outcomes. Black families are separated in 14.8% of indicated investigations, while white families are separated at a much lower 8.9% of indicated investigations. And then courts question our clients, our Black clients' intentions and conflate their love and commitment to their children with their willingness and ability to follow court orders. And as Mr. Weinstein testified before, white parents are often given a benefit of the doubt that Black parents are not. So I just have one last thing to say, which is that instances of outright and flamboyant hate, though they do exist and we're all aware of them in family court, are rare. But the wisdom that I've absorbed from my clients over the years tells me that the system targets, polices, surveils, punishes, and destroys Black families through a grinding momentum of mundane formalities and a culture that we've all become accustomed to over time. All of us who work in the system, including myself, exist on a spectrum of power to harm the largely Black and brown people who are dragged through the system. So addressing racism doesn't mean we have to sort out the bad actors from the good actors. It means taking an unflinching look at our systems and how they perpetuate inequality, and then committing to change no matter how difficult or embarrassing, no matter how large or revolutionary. When you look at Judge Jolly's testimony earlier and some of the other system players' testimony, it's clear that everybody who comes to family court comes with the best of intentions, whether they're prosecutors, defense attorneys, attorneys for children, court attorneys, clerks, or other court staff, but we have to shift our attention away from protecting the purity of our intentions doing this work and towards the painful, difficult, but very necessary work of addressing systemic racism in family court. Thank you.
Thank you very much. The next speaker, 3 minutes, understanding that it's aspirational.
I'll do my best, but I am going to rely largely on what my colleague said here and take out some of my own testimony. But good afternoon. My name is Jennifer Feinberg, and I'm a litigation supervisor for policy and government affairs at the Center for Family Representation. I want to thank you both for holding this hearing today and for allowing us to testify about our experiences practicing in New York City family courts. On a daily basis, we see the family courts fail to deliver the justice, fairness, respect, and support that New York families deserve. As my colleague said, the court really functions as an essential arm of the family policing system, bringing family separation and destruction to low-income Black and Latina families. CFR and all of our offices are the primary defense providers in New York City. We offer interdisciplinary defense, which means that there is a lawyer and a social worker assigned to every single parent that we represent. And they're supported by parent advocates who are parents who've gone through the system themselves and can actually support parents from their experiences. The family court system, as it stands today, was not built to support struggling families. The solution cannot be to grow it, but rather it has to be to invest in solutions that narrow the pathways to the family policing system. In an adversarial legal process, which requires families to affirmatively assert due process rights, in order to be heard, an important way to meaningfully address the concerns is to ensure that parents have access to quality legal and social work advocacy from the moment that a family policing investigation begins through the reunification of their families. The state should fully fund interdisciplinary parent defense offices throughout the state to provide early defense and so that they can meet the caseload standards promulgated by ILS as a way to reduce the pending family court caseloads. Since our offices began representing parents during family policing investigations in 2020, providing legal and social work advocacy to parents during those investigations, we've prevented family court filings in 80% of those cases. And in all the cases handled by CFR specifically, staff avoided placement in the foster system for 92% of children. The success of timely representation is based on our ability to partner with parents as trusted advocates and identify and address each family's particular needs. Timely defense teams can truly partner with parents to identify the specific concerns that parent has and to refer that family to the resources and services that would most assist the family and avoid the need for any further family policing involvement. Additionally, attorneys representing parents need significantly more funding to provide adequate legal representation once cases do reach court. At each of our organizations, experienced attorneys carry caseloads far above the maximum caseload standards issued by ILS. And it's even worse outside of New York City. In addition to safeguarding the due process rights of parents by providing them with counsel who are not overtaxed with excessive caseloads, providing interdisciplinary defense reduces the amount of time children are separated from their parents, which also cuts down on the pending court caseload and reduces court delays, saving the state money. Thank you.
Thank you. Next speaker.
Good afternoon, Chairmans Hoylman, Siegel, and Bridgeport. Thank you so much for letting me testify today. My name is Nicole Velasquez, and I am the Deputy Director of the Bronx Defenders Family Defense Practice. Since 2007, we have mandated legal representation to Bronx parents and caregivers facing family separation and the loss of parental rights in Bronx Family Court. We have a demonstrated track record of promoting justice in the Bronx by keeping families together and lessening the harms of the foster system involvement. Every day, we bear witness to the destruction and trauma that the so-called child welfare system inflicts on New York's most marginalized families and communities. Our experiences in working directly with thousands of families over the years has shown us that family court oversight does not serve as a meaningful check on the harms of the family policing system. Family courts resoundingly fail to ensure that parents receive even the most basic protections and due process that the law requires. Family courts' failure to administer justice is inherent in the court's arraignment system for family regulation cases, which we call intake, as Mr. Weinstein alluded to. Intake is the first critical appearance where the court is asked to determine whether a child will be removed from their parents' care, whether there are relatives available to care for the child, what visitation will be afforded to the parent, and what services are necessary. And yet, this appearance is rushed and truncated. Oftentimes, ACS has already removed a child from their home extrajudiciously and has waited days to file a petition in court. Despite the gravity of what is decided at intake, parents are given just moments to speak with their defense counsel and little ability to challenge family separation or prepare a defense against a system that has been embedded in their lives long before the point at which they are first appearing in court. The process dehumanizes parents and families, shows little regard for family bonds, and treats parents as if they are ancillary to their children's lives. Excuse me, I skipped some, so bear with me. Further, it is not uncommon to receive intake petitions almost simultaneous with the court appearance, with cases scheduled one after the other and only a small window to consult with all of the families who will be heard on a given intake shift. Due to the rushed intake process, parents are unable to fully discuss the allegations, legal challenges, and the fundamental rights that are at stake with their attorneys, let alone their family dynamics, family history, context of the allegations, misrepresentations, and mistakes of fact so often alleged. Instead, parents are too often paired with lawyers who at this point are complete strangers to them, frantically attempting to get as much information from them as possible in order to advise the parent of their rights and best path forward to prevent family separation. The court system's very structure necessitates this triaging, which again denies the dignity and humanity of these families. At a critical juncture when the court is considering whether to separate their family. Further, challenging family separation is the most important part of a family regulation case. Children should not be needlessly separated from their parents and should not spend a day longer in the system than necessary, and the law supports this. New York state law requires emergency hearings challenging family separation to be prioritized. And despite clear constitutional and statutory demands, the family court permits lengthy delays in these hearings by at times beginning the emergency hearings within the statutory frames, but then allowing continuation, completion, and decision on the hearings to be extended for months. Moreover, the family court could, but often fails to act as a check on the practices that undermine the meaningfulness of these 1027 and 1028 emergency hearings. These practices impede the ability of defense counsel and attorneys for the children to prepare and appropriately counsel families for their hearing without added delay. And the family court also erects obstacles that cause delay and undermine parents' and children's constitutional rights. The result of these practices is thousands of children, disproportionately Black, Latina, and low income being unnecessarily separated from their parents for weeks and even months. According to data provided by ACS in response to requests for information, more than 25% of such extended hearings resulted in the return of a child. Within the Bronx Defenders, our data shows that 80% of the hearings we have requested, these 1027 and 1028 hearings, have resulted in the return of a child. Tellingly, what the family court instead prioritizes over these emergency hearings, and importantly, what it does not, positions it as a continuum of state power rather than a check. Driven by court-created standards and goals, case resolution, and achieving permanency for children, which often means adoption or guardianship to a non-parent, is prioritized above all else. Though not mandated by law, New York City family court judges are held to these elusive standards and goals that are not made available to the public, that do not consult the public in creating these standards over fairness and substance, which results in judges being more concerned with expediency rather than reaching the best outcome for our Black, Latina, and low-income families in the courtroom. Fundamentally, the myopic focus on expediency and so-called permanency is a family court structural design that undermines family integrity, the procedural and substantive due process rights of families, and ignores the material deprivations and anti-Black racism that drives families into the family regulation system to begin with. Thank you for the chance to speak today.
And then our final witness, Amy Mulzer.
My name is Amy Mulzer, and I'm a senior attorney in the family defense practice at Brooklyn Defender Services. Thank you for the chance to speak today. I'm also doing some brutal cutting here, so forgive my jumpiness. I want to take us back to a point that was brought up in the first panel today, which is that when we're thinking about fixing the family court, we need to focus on significantly reducing the number of families that ever come into the family court. Given the serious harms and inequities that families experience in family court, we must first focus on directly investing in the marginalized and Black and brown communities that are targeted by the family policing system, narrowing the pathways that bring these families into the system, and investing in early defense representation so that all parents have an attorney when they are facing investigations that have legal consequences. There is a slate of legislation currently before the legislature that seeks to narrow the pathways into the family policing system. We strongly encourage the members of your two committees to support these bills, to sponsor them, and to help us pass them in the next legislative session. First, the Anti-Harassment and Reporting Act requires reporters of suspected child abuse or maltreatment to provide their name and contact information to the SCR, prohibiting the harmful practice of anonymous reporting. In many instances, false anonymous reports are used as a form of harassment or to settle personal grievances. The Informed Consent in Drug Testing Act requires healthcare providers to obtain informed consent before drug testing new parents and newborns. New York healthcare providers test and report practices wherein pregnant people are routinely drug tested without informed consent and reported to the SCR, threaten the health and well-being of Black and Latina people and their newborns, exposing families to the violence of family separation and deterring pregnant people from seeking essential health care. The Family Miranda Act requires workers to advise parents and caretakers of their rights at the start of an investigation. This legislation does not create new rights. It simply ensures that parents are aware of the rights that are already guaranteed by New York state law and the Constitution. In addition to these existing bills, we urge the legislature to consider legislation that would eliminate the legal mandate requiring helping professionals to report families to the SCR. Just as your colleagues in the Assembly demonstrated at their recent hearing focused on this issue, the state's mandated reporting laws do not make children safer. Instead, they work to isolate families in need. Finally, the legislature must hold the court system accountable to do the following to change the practice and culture of the family courts to align with the values of reducing unnecessary harm to families of color. Center the voices, experiences, and perspectives of parents in proceedings about their children. Parents are the people in that courtroom who know the most about the children about whom the proceedings are happening, and they are almost never asked to speak about their children. Their opinions are not considered. Acknowledge that children in Article 10 proceedings belong to a family unit and do not exist in a vacuum detached from their parents, family members, caretakers, and communities. Abolish current standards and goals for family court judges that result in prioritizing disposing of matters rather than prioritizing the unique needs of each family, including the need to reunify families who've been unjustly separated. Require the use of real names and person-first language in the courthouse that is respectful of the lives, humanity, familial relationships, and responsibilities of the people before the court. Enhance and expand interpretation services for additional languages beyond Spanish. And end the daily acts of racism and discrimination by judges and court employees toward Black and brown staff and people before the court. Steps toward this goal should include regularly scheduled surveys and feedback sessions with supervising judges regarding the micro and macroaggressions experienced by Black and brown staff and people before the court. In addition, there should be a centralized reporting mechanism. Again, thank you for allowing BDS to provide oral testimony, and I'm happy to answer any questions.
Thank you all so much. So I guess I'll just start by one circling back to your mention of the Family Miranda Act. So I was just I want to reiterate what the ACS declined our invitation to be here today, which is unfortunate. But I wanted to see if you on the panel are aware of ACS's pilot program, by which they give a card that informs parents of some of their legal rights. And I wanted to get your thoughts if that pilot program is sufficient to inform parents.
We're jumping for the mic.
I was just going to say the fox should not be guarding the hen house. So, I mean, and that's what I'll say, and then I'll pass it to Nicole.
I also will add that in practice, what we're seeing happen is first ACS gets in the door, right? That's how they give the palm card. So the Miranda warning in and of itself already is not structured how we as the defense counsel would want it to be, right? So it's usually not upon the second or third home visit that ACS has already conducted that they are actually giving out these palm cards. So in theory, it's a great practice. In practice, it's not what we're hoping for. It's falling short. And at that point, as we know, when someone of authority comes and asks you questions, the sense that you need to divulge everything because you want to cooperate, because you want to ameliorate a bad situation is going to be the first instinct. And so we're finding that we are still entering into these parents' and families' lives at far too late a stage.
If I could just add, I really want to point out that the most critical moment is the moment that CPS knocks on that door. And the moment that they use coercive and threatening language to get entrance into the door. And handing a person a palm card, even if they're doing it at the end of the first visit or during the first visit in a stack of paper with releases that people have to sign, is not giving people adequate notice. They've already coerced families into letting them in. They've already threatened to call the police and take away their kids in order to gain access to that child and that home. And so that is a violation of the Constitution and of families' Fourth Amendment rights. So the damage has been done. Parents have already spoken to ACS. The palm card does not indicate that parents don't have to talk to ACS. It doesn't alert them that anything that they say can be used against them in court. So it's taking out, just as you know, it's really reflecting the changes and the watering down and the gutting of the Family Miranda Rights Act, and trying to implement something that is less effective and that does not protect parents in order to prevent your bill from being passed and being put into action.
Thank you. I also had another question. I just, I visited family court recently. I heard cases of judges would order some support for families, but there would be mix-ups when it came time to deliver those services. And I was curious if this is something that any of you had seen in your practice in family court. Just quickly, please.
I'm not sure how to answer. I understand the question.
I haven't seen service mix-ups from the judges. I have seen it from ACS. And so it requires us to be vigilant and be definitely paying attention to our specific families that we're serving, to be on top of knowing what actually is their service plan and to hold ACS accountable to that. And I will say, with that, I have not had support from the court necessarily in that check. It has always needed to be my voice in the room to correct that. So that would be appreciated from the court in those instances of also knowing what the individualized plans for the families are that they serve.
And I think related to that, it's just another sort of subtle but very important way in which our clients are deeply dehumanized by the family court process. I can't tell you the number of times that court orders are entered incorrectly, including orders of protection, which if you violate what's on the paper, it's a felony, right? So over and over and over again, orders are issued incorrectly and not corrected, and it has a deep impact on our clients' lives, especially when their compliance with these orders is what they're supposed to do to reunify with their children. And there really isn't a lot of attention to detail or like a sense of urgency around it from the court. And we always have to chase after the court to correct these things. And it happens in criminal court too, when orders of protection are supposed to be subject to subsequent family court order. It takes so much energy when if somebody just took 30 extra seconds to make sure what they were issuing was accurate. It would save time, it would save heartache for our clients, et cetera.
Thank you.
Thank you. Wanted to ask about the bias or disrespectful comments that were made by that judge toward you, Zainab. What was the follow-up? Did you consider going to the Commission on Judicial Conduct to file a complaint?
It was a couple years ago, and since then, the same judge has sent emails with inflammatory language as well. If I remember correctly, I went to the judge who at the time was tasked with enforcing the sort of judicial conduct standards, who said there wasn't anything she could do. And then I made an official complaint with the IG and was interviewed. And I asked the IG to sort of stay their investigation until my client's case was over, because, despite what Judge Jolly said about agencies being very vocal and coming and speaking to judges and to supervising judges when there are complaints, we do that at great risk to our clients and the outcomes that we're trying to seek for them, right? It's a bench trial in all of our cases. It's not a jury trial. So we have to maintain those relationships. And so it's a very difficult choice to confront a judge and say, what you did was actually completely inappropriate. People don't like to be challenged when, especially when they have done something that has had a harmful impact, on the person based on race, regardless of what their intent is. So I asked the IG to hold off on their continued investigation until my client's case was over. And then when it was over, I spoke to them, and I have not heard anything back. And that was, I think, a year ago. And the same judge just a few weeks ago sent an email with some extremely inflammatory language, and has said lots of inflammatory things since. And again, I have seen many judges. I would say there's probably only, I've practiced in Brooklyn, I practice in Manhattan and the Bronx right now. There's probably only 2 judges that I would say don't speak at best condescendingly to our clients. And many judges who scream at our clients, treat them with so much disdain, and really...
It's, I've read it.
Yeah.
But to hear it...
We see it every single day. Every
It's
single
so
day.
shocking and outrageous. I can't tell you that. It makes my blood boil.
Well, I feel the same way. And part of I live it every day. The staff that I work with lives it every day, and I'm shocked to hear how universal that experience is in this hearing, right? There are people who appear in front of family court judges all over the state in different kinds of proceedings, and it's a universal experience. And what's even more shocking to me is that the leadership who appeared today in the hearing, their first response was extreme defensiveness, right? And they walked back, and if that's the leadership, how are the line judges and the supervising judges going to respond if we raise it with them? There's absolutely zero accountability. And there was a lot of language about the signage in the courts. If you see those signs, what they say to me is, litigant, you better behave or you'll be in trouble. And okay, maybe we'll be kind too, but there's no path for accountability for the judges. There's no, and we have to be real. Sometimes it's the supervising judges who are responsible for taking complaints who are themselves causing the biggest problems. And so where do we go then?
Well, I think the Commission on Judicial Conduct may be where you go. It is an outside independent entity that could, in fact, enact disciplinary actions on judges for this kind of conduct. But it's something I would love to follow up on.
Sure.
Because I share your anger, and
And if I could-
I'm really sorrowful to hear about it.
Yeah, thank you. If I could say one last thing, I really appreciate when elected officials come to family court to observe, but know that when you come to observe, it's not the family court that we're practicing in, because they know that you're there. They're going to be acting differently. They even if they don't know you're an elected official, they see someone in the back of the room who's in a suit, who's not usually there, and they're going to be behaving differently. That's just
we need to pull
the truth.
a Ruth Reichel or whoever that disguised food reporter
Right.
was. Yes, Senator Mayer.
I just wanted to say, with respect to your comment about the representatives of OCA that were here today, as defensive as clearly they were, and then had to walk it back, the fact that the chief judge was here, that has, in my experience, never happened before in a legislative hearing about the court. Our relationship as legislators who are frustrated about this issue was never really heard before. So I'm going to give the chief judge and his new leadership the benefit of the doubt, because, and we all know during the hearings, this issue of the experience of our clients, including people of color in family court, was front and center in his hearing. And the fact he was here, I think we should give him the benefit of the doubt, hoping that there is change in that initial instinct of defensiveness. And clearly, you're right. If we go, my point about family court not being open is if anyone appears, they're going to behave differently, because no one ever appears.
Right.
So they need to open the door so that the conduct is the conduct you see,
right,
that others can see.
Well said. Well said, Senator. Yes, and I think the chief judge found this whole hearing, he communicated to me, very informative. So I think it is a moment where we do turn the page, work with OCA, try to address some of these issues at the most granular level. But your testimony today is a very positive step forward for, I know, the OCA administration.
If I may just add one more
Yes.
point to what Ms. Akbar was saying, which is we also heard a lot about the training, right? That instances like Ms. Akbar personally experienced and that our clients experience every day, and that the parents in the first panel outlined was their very real experience. The answer is the end-all be-all cannot be training, right? Also, what training? Who is providing the training? What is the curriculum for the training? That would be great to see for transparency's sake, to remind the judges when they are not following the guidance in the training, and to hold them accountable to the training that they did receive when we are seeing it in real-time play. Because in my experience, what we see is when you can tell when the judges undergo a training, things change for a week, maybe a month, maybe 2 months, at best 6. And then old behaviors start to resurface. And so I think for the public who is appearing before them to know what they should be held accountable to would be really powerful.
And, it goes to the point of, like, how do we attract, better judges, more attorneys? I mean, if you're being disrespected in your own court, that's not going to be an incentive to want to practice there. So we have a lot of work to do to fix that.
We've had a lot of staff leave for precisely that reason. When they exit, they say, I just didn't become a lawyer to be spoken to like that when I'm just doing my job. It's been a repeat experience for us.
Just thank you again for your time and your expertise. We really appreciate you. Thank you. So for our next panel, we will have Dodd Terry, the attorney in charge of the Manhattan Trial Office for the Legal Aid Society Juvenile Rights Practice, Joanna Davis from the Legal Aid Society of Northeastern New York, David Shalik Klein, the founder and executive director of the Family Justice Law Center, and David Lanzner, the co-chair of the New York State Citizen Review Panel for Child Protective Services.
Oh. Yeah, okay. I think it's.
It's our aspiration.
It's aspirational. All right, welcome. Again, we try to summarize your testimony in 3 minutes, if that's possible. And we'll start with Dodd Terry, attorney in charge of the Manhattan Trial Office, the Legal Aid Society Juvenile Rights Practice.
Thank you so much. I appreciate the opportunity to be a witness here to this hearing. I'm a witness of family court for the last 25 years. I come to you as the attorney in charge of the Manhattan Trial Office of the Legal Aid Society's Juvenile Rights Practice. Now, with offices in every borough, the Legal Aid Society Juvenile Rights Practice represents the majority of children that appear in the center of child welfare and juvenile delinquency cases. In addition, the Legal Aid Society Civil Practice and Family Domestic Violence Unit represents survivors of domestic violence, handling orders of protection, custody, visitation, and child and spousal support cases in family court. Now, I want to touch on a few key points. At the outset, it's imperative to recognize the inequities in family court persist because of underfunding, under-resourced, and the overburdened capacity of every entity that operates within this system. While OCA has begun what it's referred to, OCA has begun to address what's been referred to as a second-class system of justice, the time is now to turn this narrative around and recognize the desperate need for the 2024-25 judiciary budget to provide full and adequate funding and critical resources and services for litigants, including fully funding attorneys for children's offices. Attorneys for children continue to experience salary inequities, high caseloads, workload demands that far exceed the national practice standards. The realities led to unprecedented attrition. There must be a sense of urgency. A critical look at the 150 client case cap is something that is necessary. The case cap has to be reduced to a reasonable number, roughly about 60 clients to 55 clients. That's been acknowledged in other courts. Court congestion is a complete extreme problem in family court. It exacerbates the trauma experienced by the children and the families that come in contact in family court. Families are separated for months and years at a time, awaiting a finding or a resolution of their matters, and they can't even enact a 1027 or 1028 hearing that's supposed to make sure that you have an immediate hearing to try to work through or to examine whether there's imminent risk that exists in cases. That situation relates to the underfunding or the overburdened resources in family court. We need more judges and prompt backfilling of judicial vacancies. We need more interpreters. You've heard that already. Additionally, we need adequately staffed courtrooms and improved efficiency. In summary, I know my time is up and I tried to rush through this, but really this conversation today is about underfunding and under-resourced critical and necessary resources for a family court system that compounds congestion, delays in family court proceedings, and disproportionately impacts families of color. It's a matter of racial justice to take steps to ensure fairness, dignity, and equality.
Thank you. Joanna Davis.
Honorable Senators, my name is Joanna Davis, and I'm a managing attorney with the Legal Aid Society of Northeastern New York. I've been practicing in the area of family and matrimonial law for specifically representing only victims and survivors of domestic violence for the last 18 years. I oversee LASNY's program, domestic violence programs, attorneys and paralegals, and I come before you today to discuss several important issues facing New York's family court system, specifically in the Northeastern New York area. So we cover 16 counties in New York State, from Columbia Green counties located just south of Albany all the way up to the Canadian border. The vast majority of our clients in these counties' family court identify as rural victims of domestic violence, or parents facing neglect and abuse proceedings who are also income eligible for free civil legal services and are under 200% of the federal poverty guidelines. With the COVID-19 pandemic, the use of virtual proceedings changed the landscape of access to the courts. With the retraction of the COVID-19 pandemic, so did the return of in-person court appearances for our clients. That also brought back the difficulties our clients are now facing in accessing the courts. The vast majority of our clients are hourly wage employees, lack reliable transportation, have a travel of a minimum 45 minutes to 60 minutes one way to get to court, and are mostly waiting 2 to 3 hours in the courthouse. The vast majority of our clients do not even see the judge at each of their appearances. This has a significant impact on their financial abilities to maintain and support their household, and we ask that the courts really be allowed or mandated to allow for virtual proceedings for all of our clients in which there is no trial or no evidentiary hearing being held. The vast majority of our family law practitioners echo the same concerns about attorneys for children across our entire catchment area. So the biggest concern is that these AFCs are not meeting with their clients and are then substituting judgments that hold positions contrary to the facts of the case. Even when these concerns about these attorneys for children not meeting with their clients are raised to the courts, we're being informed that there's nothing that the family courts can do. And this is a pervasive problem in our area. This has a devastating impact on the trajectory of a child's future and safety. We're asking that there be a mechanism in place for these attorneys to be reported, held accountable, and kept off the panel, as they're not upholding their oath as an attorney and an officer of the court. The ability to access the civil Gideon is one that is necessary and imperative to protect the rights of those who are unable to afford private counsel in matters that include basic human needs. Family court, family law is one of those areas. One of the difficulties we face is the disparity in what qualifies a litigant to access the civil Gideon. So we hold an assigned counsel contract with one of our covered counties, and what is revealed is that not every county throughout New York State uses the same standard income or asset guidelines. We're seeing time and time again individuals making above 600% of the federal poverty guidelines being granted free counsel. The purpose of the civil Gideon is to protect individuals who could not afford an attorney, not to provide one to those who just don't want to pay for one. We're asking that there be a transparent, consistent financial eligibility guideline used throughout the state so that the use of the civil Gideon remains protected. So the cost of court order tests, forensics, evaluations, while we do have a mechanism to request that the county pay for those services, they're largely denied. We're also questioned time and time again, why isn't LASNY paying for these services or these court order tests, and why don't we use our slush fund? I want to be clear that LASNY does not have a slush fund to pay for these court order tests, and we are asking that the state allocate funds to cover the cost of all of these tests for indigent litigants so that we can ensure that access to justice is not determined by the size of one's wallet. Last, trauma-informed training for all court staff, including AFCs, 18B panel attorneys, court attorneys, clerks, judges, court officers. They must be held and they must be prioritized. The vast majority of our clients are traumatized victims. And to compound that trauma with interactions with those in the court proceedings who don't have trauma-informed training or services just adversely affect our clients' impressions of the family court system. I'm just going to echo all of my colleagues' previous statements so that there needs to be more funding for civil legal services. We are vastly underfunded. We don't have enough attorneys on the ground to be providing these services, and so that we ask for additional funding for that. Thank you for the opportunity to bring these concerns from our catchment area to your attention.
Thank you so much. And next we'll hear from Mr. David Shalek-Klein.
Good afternoon. My name is David Shalek-Klein, and I'm the founder and executive director of the Family Justice Law Center. Last year, I launched the Family Justice Law Center to bring civil rights impact litigation on behalf of families that have been harmed. My testimony today focuses on the egregious civil rights violation plaguing families in New York City family courts that occurs daily when courts fail to hold prompt hearings after a family has been separated without prior judicial approval. Hearings that would be completed in less than a day in most courthouses routinely stretch out over many months, diced into many appearances in New York City family courts. Often, after hearing only a few minutes of testimony, judges adjourn cases for weeks out. Once the case is back on, the court takes another few minutes of testimony, and then adjourns the case out for another few weeks. This process repeats again and again and again until the hearing, which consumes only a few hours of actual court time, takes a few months to complete. Judge Rivera stated earlier today that these removal hearings happen on the first day. In New York City, that is simply not the case. The government's decision to forcefully separate a child from a parent without prior judicial authorization is a drastic action of last resort with profound consequences that implicate our most fundamental constitutional and societal values. When the executive branch of the government, in New York City, the Administration for Children's Services, or ACS, takes this extreme step, statutory and constitutional law, and indeed basic democratic principles, require prompt and meaningful judicial review. Immediate court scrutiny is far from a formality. Its purpose is to enable a judge to hear and weigh all the evidence and decide whether the drastic intervention of family separation is necessary. Many of these hearings result in family reunification. New York and federal law recognize these significant stakes and require these hearings to be ordinarily completed in a time that is measured in hours and days, not weeks and months. Against this well-established and incontrovertible backdrop, it is unconscionable and blatantly unconstitutional that New York City family courts have systematically and routinely failed to afford families this key due process protection. Over the years, reports from, among others, the New York State Bar Association, the Williams Judicial Commission, the Annie E. Casey Foundation, the Johnson Report, the Bronx Defenders, and numerous news outlets have detailed the prolonged and protracted nature of family court hearings. Beyond the many reports, though, one need not spend more than a few minutes in a New York City family court to be aware of, befuddled by, and enraged at the clear constitutional violations. In response to many of these reports, the Office of Court Administration, or OCA, has stated its desire to serve and support families, but it has taken no systemic action to fix this long-standing and well-known problem. In the face of families experiencing unnecessary harm, pronouncements of good intention are inadequate, if not followed by ambitious and meaningful action and reform. In early June of this year, the Family Justice Law Center, along with the primary providers of legal services for parents and children facing family separation in New York City family courts, sent a letter to OCA asking for its assistance in fixing the severe civil rights violation. This letter is attached as Exhibit A to my testimony. As the many reports I referenced earlier, our letter was far from the first time OCA has heard about systemic delays in family separation hearings. To its credit, OCA agreed to work with advocates to solve this issue, but to date, nearly 6 months later, OCA has met with our coalition only once and has not even proposed, let alone implemented, one systemic reform. I finished my testimony, however, on an optimistic note, which, Senator, you stated earlier. I am encouraged by and appreciative of Chief Judge Wilson's stated commitment to reform New York family courts. I also thank Judge Kaplan, who is the Deputy Chief Administrative Judge for New York City, and Judge Jolly, who you heard from earlier, for making a commitment to working with the Family Justice Law Center and other advocates to fix the problem. It is essential that this initiative go beyond pronouncements to secure change. The Family Justice Law Center stands ready to work quickly and meaningfully with OCA, and we hope that our advocacy need not go further than this collaboration to ensure that important constitutional protections become a reality for New York City, in New York City family courts. Thank you very much.
Thank you. And next we will hear from Mr. David Lansner.
Yes, thank you. My name is David Lanzner. I've been practicing in the family court since 1971. I was at Neighborhood Legal Services with the Legal Aid Society in private practice and assigned counsel. I represented parents, foster parents, adoptive parents. I represented children. And I also have represented scores of families in civil rights actions against the city of New York for taking children away illegally and recovered millions of dollars for them. Unfortunately, it doesn't seem to have changed ACS's behavior because the money doesn't come out of their budget, it comes out of the general budget. From 1988 to 2000, I served as counsel to the Assembly Committee on Children and Families, and when I left there, the Speaker appointed me to the Citizen Review Panel. We are mandated by state and federal law to provide recommendations, which we've done for 22 years now, and OCFS has never implemented a single one of them, but we've put them into our reports, and we've sent you the reports and hope that you will be able to implement some of them. One thing that I think we all agree on, every parent, every attorney, every administrative judge who was here, is that none of us would ever want our case to be heard in the family court. I think that sums it up perfectly as to how bad this court is, and the routine defense that the administrative judges made just doesn't fly. There have been successful programs. You've heard about how the parent representation programs have gotten children out of foster care faster and kept children from going into foster care. Let's look one step further at what the implication of that is for children. It means that there are children who are in foster care not because they need protection from their parents, but because their parents got the wrong lawyer, and because their children's own attorneys didn't do what should be done to get them out of foster care, and because CPS conducted poor investigations, didn't find the true story, didn't want to provide services. Unfortunately, all of these cases come before the family court judges, and we've heard about everybody saying there should be more money. Well, a lot of the blame should go to the family court judges themselves because of the way they conduct or don't conduct their courtrooms. You go into family court and you see attorneys, men with their ties down and their collars open, and other attorneys look like they've just come back from the beach. It's a total lack of respect, and judges allow that to go on, and that follows with the next step whereby they say, oh, I can't come this day and I can't come this day. I have intake that day to take on more cases I can't handle. Judges should follow the rule in the chief administrative judge's rules that say when a trial starts, the attorney has to be there every day until that trial finishes, regardless of what other cases. Judges should just enforce that. I like to quote our former First Lady, Nancy Reagan, who said, just say no. And the family court judges need to get some of that attitude. As one of my recommendations is that all family court judges be required to spend a full week observing in federal district court and see how judges and attorneys behave in what people call a real court. Unfortunately, most of the judges and most of the attorneys who practice in family court have never been in a real court. And so they accept what goes on in family court as the norm. And they need to get out of that and change this attitude of delay. So I think that institutional providers should be provided. I think that the legislature should also put in a rule that if attorneys are assigned to parents, that it be done on a rotating basis, because there are counties where if the attorney is zealous and asks for hearings and tries to defend a case, the judges won't appoint them to any more cases. So require that it be done on a rotating basis. Re-examine the role of attorneys for children, because attorneys make motions. They talk to their clients regularly. They have their clients with them. They present witnesses. Very few attorneys for children actually do that. Finally, it's not the family court itself, it's Child Protective Services, but outlaw strip searches. Caseworkers should not be going into homes and taking children's clothes off. That's something that the Citizen Review Panel has proposed for years, that the Second Circuit has said is unconstitutional, and yet the city and the state continue to do that. Thank you.
Thank you so much. Thank you to all of you. My first question is actually for you, Mr. Lansner. I know the Citizen Review Panel recommends that the legislature should prohibit interviews of children by CPS at public schools without a court order obtained on notice to parents. Can you share more about why is that, and is it common for CPS to interrogate children at schools?
It's very common for them to do that, and there's an announcement, child number come down to the principal's office, and everybody else knows why it's happening, and so it's a great shame for the child. The child feels pressured. We represented a child in a civil rights action in the United States Supreme Court, where she had been brought down to the office, interrogated for 2 hours by a caseworker, and it was another state, with an armed deputy sheriff, until finally she told them what they wanted to hear, even though it wasn't true. So those interviews should not be conducted in those coercive settings.
And I just have another extra question for you, David Lansner, again. One of the big issues that comes up in family court is the delivery of preventative services. And I know the panel recommended that the executive and legislator should enlarge the delivery and financing system for preventative services outside of OCFS and the public child welfare agencies. So why did you recommend that it should be done outside of OCFS?
Because people don't trust ACS. They know that if you say, what does ACS do? They take children away. So people don't want to go to those services. They don't want to go to ACS to get services. Set it up separately. A great place to put those would be in hospitals. A lot of doctors say that they refer people, or they call the hotline to report abuse or neglect, not because they think the child is in danger, but because they think the family needs services, and that's the way to get it. So get it all away from ACS. There are a couple of great services, child visiting nurse services that are provided by both home visiting by nurses and by social workers to families with new children, has been shown to be incredibly successful in preventing abuse and neglect and keeping children out of foster care. We have urged for years that it be brought up to scale. In Britain, every family, regardless of income, gets a visit from a nurse when they have a newborn child. So we think that. The other is that, of course, as you well know, the income supplements to people were a great success. And there's a long history in child welfare of temporary or experimental programs that work fine, and then they're stopped.
Thank you so much. Mr. Chair?
Thank you, Mr. Chair. The Senate and the Assembly have been funding nurse-family partnership
Yes.
In increasing amounts, and it's something I'm always proud to
Yes, I
champion
think
and support.
That's a failure of the executive to put that
Yeah.
into their budget.
It is. It is. Again, I want to thank all the witnesses. Wanted to ask David Shalat Klein. You won $200,000 from a private philanthropy and started the Family Justice Law Center. I understand it's the first of its kind in the country. What makes it different than another nonprofit that might do this kind of work?
Let me be clear about a couple things.
You did win $200,000,
For
right?
the organization.
Okay, yes,
For the
yes,
organization.
yes, yes.
2 decades ago, not that long ago, the government used to take children from mothers because they were victims of domestic violence on the theory that they allowed themselves to be abused. There was a class action lawsuit that was brought by Mr. Lansner and others to stop that practice, to make it be found unconstitutional that you cannot take a child from a mother because she is a victim of domestic violence. What the Family Justice Law Center is seeking to do is follow a path that has been blazed by other civil rights litigation organizations, from the ACLU to the NAACP LDF, for the Center for Constitutional Rights. In every single civil rights issue in our country, from criminal justice to juvenile justice to housing to disability rights, to women's rights to voting rights, there are organizations that don't just play defense, not just public defenders, which are critically important and the first line of defense, but also go on offense and hold government agencies accountable when they violate the law. And that is precisely what the Family Justice Law Center wants to do for families that are harmed by the system, including executive branch agencies, but also judicial bodies within the system. As someone else testified, I can't remember earlier, the system is made up of a lot of different aspects, and it's important that we address all of them and hold all of them accountable for various violations.
Thank you. Senator Mayer.
First, Mr. Terry, most of your suggestions were fiscal in nature. You know, more money for the more judges, more resources. Aside from the money part, which I get that, are there other specific programmatic changes that you, on behalf of Legal Aid, think should be on the table? Maybe they're in your testimony, you didn't get to read it yet.
We did submit a testimony with some specific recommendations, but as far as your questions are concerned, I really focused more on the resources and the funding issues, because in trying to remain consistent with the testimony that I've heard throughout the day, there's a real challenge that we are facing regarding under-resourced family court. And that is something that's really impacting the ability for families to receive justice in the system. Before we start talking about the programs, we have to start talking about the ability to just try to hear the cases in a timely manner, because we get the opportunity to try to get our young clients out, and that's essentially one of the biggest things that we're looking at.
No, I appreciate that. I think people may not know that generally the Office of Court Administration proposes its own budget to the legislature, and my colleagues can question me if I'm wrong, but my experience over many years is that the legislature has extremely little ability to actually increase the OCA, the judiciary budget. It's a separate budget from the executive budget, and traditionally we have fought on occasion to add money, but and one of the values of this hearing is that OCA is hearing, hopefully, that they have to argue for more resources for family court, because the legislature has limited authority to add to the OCA judiciary budget traditionally.
But the Legal Aid Society is definitely in support of narrowing the front door to family court.
Understood.
And the 3 bills before the legislature that we believe must be passed.
Okay, understood. And the other thing is, I had a question for you, Ms. Davis, on, on the issue of your clients really, and I can totally imagine this, having to lose a day of pay, having to find childcare, all those things, just to go to court and wait for 2 hours to be told to come back in 3 weeks. Have you raised having virtual hearings on those?
Yes, we routinely request. We routinely request the ability to have our clients appear virtually. Our attorneys are willing to go to court, but those requests are routinely denied. We even ask if our clients can just appear by telephone, especially for pretrial conferences where we're not even going before a judge. All of those are being denied, for the most part.
Is that largely by a single judge or the chief administrator? How does that work?
We see it, the bulk of those requests we see from the county that we have the assigned county grant with. But we also see from all of the various 16 counties that we serve. We're being told the pandemic's over. We want to see people. We can't assess their credibility. I'm like, what credibility is there on a further proceeding when you're not going before the court?
Yeah, I think that's something we absolutely need to address. Thank you. Thank you all very much for testimony. Thank you.
Thank you again.
Just a quick announcement, if you are watching in the overflow room, there are some seats that are now available inside the main room, so you're free to flow on right in here. And our next panel.
Our next panel consists of Joan Gerhardt, Director of Public Policy and Advocacy, New York State Coalition Against Domestic Violence; Stacy Schechter, Director of Domestic Violence Law Project for Safe Horizon; Jennifer Friedman, Senior Program Director for Family Law and Policy, Sanctuary for Families; and Rachel Braunstein, the Director of Policy for Her Justice. Joan, Ms. Gerhardt, would you like to go? Aspirational 3 minutes. Okay.
The New York State Coalition Against Domestic Violence is a statewide nonprofit of local domestic violence service providers who are focused on preventing and ending domestic violence. Thank you for having me here today. Frankly, family courts are not complying with current statute. They're not complying with the domestic relations law, which requires them to consider allegations of domestic violence and child abuse in custody and visitation proceedings, and keep children away from parents who jeopardize their safety. Many family court judges minimize or ignore the effects of domestic violence. They take custody away from those who allege domestic violence or child abuse, and they order custody to those who use children as pawns to further abuse their victims. Why are judges doing this? Because many don't believe abuse is actually happening. They believe the allegations are invented by parents for the sole purpose of obtaining full custody. They accuse victims of alienating the child from the offender when they take actions to keep children safe. If a child speaks up against abuse, judges believe they were manipulated to do so. This culture is playing out in courtrooms across the country. Research has shown that female domestic violence survivors who tell the court about their abuse are rarely believed. In fact, they lose custody 28% of the time. Even when a father is criminally convicted, they still lose custody 13% of the time. Now, if fathers claim the mother is alienating the child, fathers win custody 1 out of 2 cases. With odds like that, why wouldn't a father claim alienation? I use the terms mother and father here intentionally, bless you, because the research finds that judges believe men who allege abuse. They just don't believe women. So how can family court function in a way that protects children? First, Kira's Law. We have to pass Kira's Law. This bill implements several of the recommendations identified by the National Council of Juvenile and Family Court Judges, and has already been implemented in many other states. It strengthens New York's existing statute by requiring judges to assess a child's safety before issuing permanent or temporary orders of custody. Questions to be asked include if there's a history of violence, police reports, the use of threats to use a weapon, etc. These are basic questions during a lethality assessment and should be asked by family court judges regularly throughout court proceedings. The bill prohibits the admissibility of alienation allegations in cases involving domestic violence and child abuse, and it requires comprehensive training in domestic violence and child abuse for all family court judges and court personnel. And just a note on the training, yes, there is a current mandate for judges in Supreme who do matrimonial cases, as well as in family court, to get training on domestic violence, not child abuse, just domestic violence, every 2 years. We haven't seen the training. We're not told of the training. We're not asked to participate in developing the training. So the advocates, the experts in domestic violence have no part to play in creating the training. Niskative has prioritized Kira's Law, and we will continue to do so. Of course, there's much more to be done. We must figure out why judges don't have the time in their dockets to fully assess a child's safety. If they can't accomplish this, why do we have family court? Stop the endless rotation of untrained judges into family court. I'm not sure that you've heard that yet today. And in addition to judges, require domestic violence and child abuse training for 18B attorneys and attorneys for children. And we require those attorneys to spend time with their clients before they end up in the courtroom. Make it safer for DV survivors to attend court by creating separate waiting rooms for litigants. Allow DV survivors to attend proceedings virtually, whether from inside the courthouse or from an external safe space, and ensure judges follow consistent protocols and procedures for virtual proceedings. Like most other states in the country, please ensure that all parties and counsel have access to forensic child custody reports, which they don't have in New York. We're the only state that doesn't allow that access. The only state. There was a lot of conversation today about supervised visitation programs. A recent audit found that 20 counties in New York do not have a functioning program. Many other counties' programs are limited. New York must fund a supervised visitation program in every county of the state. And we should adopt statewide protocols for these programs, in addition to safe exchange programs, and establish minimum qualifications for supervisors. We should also create a communications loop for community stakeholders to inform the court if ordered supervised visitation is not happening successfully. New York must do a better job at supporting DV survivors, and we really appreciate your help to getting us there.
Thank you. Next, we will hear from Stacy Schechter. Stacy?
Good afternoon, and thank you, Chair Hallman Siegel and Chair Brisport, for the opportunity to provide testimony before your committees today. My name is Stacy Schechter. I'm the director of the Domestic Violence Law Project at Safe Horizon, which is the nation's largest nonprofit victim services organization. Safe Horizon offers a client-centered, trauma-informed response to 250,000 New Yorkers each year who have experienced violence or abuse, and we acknowledge the many ways that systemic racism impacts the lives of our clients and our staff. Safe Horizon's Domestic Violence Law Project provides direct legal advocacy and representation to indigent victims of domestic violence in New York City's family court, Supreme Court, and integrated domestic violence courts. We assist with orders of protection, child support, custody, visitation, uncontested divorce proceedings as well. We also run a legal helpline that provides information, referrals, assistance to domestic violence survivors. And additionally, Safe Horizon has programs in all of New York City's 5 family courts, staffed by case managers and social workers who assist survivors of DV and family violence with understanding their options and assisting in navigating the family courts. In fact, when the courts were closed during the COVID pause, our DVLP and family court programs, as well as staff from other civil legal programs, assisted survivors with petitioning for emergency orders when the courts were otherwise closed. And our family court programs provide supervised visitation in 4 of New York City's 5 family courts. So therefore, we and our sibling organizations deeply understand what it is and what it is not working in our family courts. Families across New York State, especially survivors of domestic violence and family violence, depend on our family court system to adjudicate these important and often very complex, very personal legal issues. So we wish for our family court system to function in a professional manner and make what are fundamentally life-changing decisions in a judicious and timely manner. However, we know our family courts are not living up to what we would expect from such an essential part of our judicial system. Safe Horizon has submitted full written testimony. I'd just like to briefly highlight a few following challenges. One, the court system needs more funding, not only for the court itself, but for the nonprofit organizations that provide this direct legal assistance, advice, and representation to survivors. We desperately need more funding. To help ensure DV survivors can be successful in seeking orders of protection, custody, visitation, and support, they need attorneys who understand the complexities of DV and who can navigate our system. And it's also helpful for the opposing party, typically the abusive party, to also have qualified legal representation, as this creates a buffer between the parties and generally reduces the likelihood of the abusive partner weaponizing the court system. Judges as well, echoing what others have said today, we need judges who want to be on family court, who have experience in family court practice, who understand the complexities of domestic violence, intimate partner violence. We need better screening around domestic violence and family violence when reviewing applicants for the family court positions. There are vacancies, and we recommend that only applicants with practical experience get appointed. And lastly, I just want to mention the virtual proceedings that have been mentioned by so many others. Safe Horizon DVLP echoes that request that judges be willing to grant virtual proceedings across the board in all proceedings, especially when requested on behalf of survivor of domestic violence. We recommend uniform rules and practices to that end. In our experience, there's inconsistency between boroughs, but sometimes even between judges in the same courthouse, being willing to let our survivors feel safe from a virtual setting when they need to appear, especially for short appearances that don't need to take all day, take them away from work, and place them enclosed environment with their abuser. The ability to attend court virtually is also an economic issue. We should not have to take off all day from work to pay for childcare to come to court and wait all day. This is especially salient for the conferences, and the rest of our testimony can be found in the written report we provided. Thank you.
Thank you, Ms. Schechter. Next, Jennifer Friedman.
Hi, good afternoon. Thank you so much. I am going to dispense with so many niceties and cut right to the chase so to try to keep this on time. I'm Jennifer Friedman. I'm the Senior Program Director for Family Law and Policy at Sanctuary for Families. We are the state's largest comprehensive service provider for survivors of domestic violence, human trafficking, and other forms of gender-based violence. I myself have been a practitioner in the family courts for close to 20 years, and I supervise large staffs in our family justice centers where Sanctuary for Families provides legal services in family law in all 5 of New York City's family justice centers. Last year, a coalition of organizations like mine, including several of my colleagues here, held a big conference that was attended by approximately 700 people and included speakers who are survivors and advocates, as well as members of the judiciary. And we produced a report, our own report, that you can find online and that was attached to our written testimony, which identified barriers to preventing justice for survivors and then a blueprint for change. So the barriers are bias against abuse survivors on the basis of their intersecting identities. And I want to point out that often bias is discussed as either racial bias or immigration status, or bias on the basis of poverty, or gender bias. There was also a Gender Fairness Committee report that came out around the same time as the famous Jay Johnson report, which identified serious issues with regard to ongoing gender bias in the court. Our clients are primarily women of color. They are facing both gender and racial bias. A lack, and other people who testified today discussed this. Our clients, we routinely have to prep them for court with explaining to them how to not fall into a racial or gender stereotype so that the judge will listen to their testimony. It's like routine training for all of our new staff members so that we can make sure that the judges hear their words and not make knee-jerk assumptions about them based on their identities. So this is going back to the barriers. Lack of understanding by the judiciary of trauma, coercive control, and lethality factors. A failure to prioritize the safety needs of survivors and children over the opposing party's demands for custody and visitation. Again, huge pressure and knee-jerk reaction that every single case there should be immediately visitation ordered irrespective of the circumstances. The under-resourced courts, which have been discussed at length. I want to say what's happening, which Joan recently mentioned, is that judges are rotating into the family courts from other assignments on 2-year terms. I myself have a case that I litigated myself that has been before 6 different judges, including 2 separate trials before 2 separate judges. It is actually in court right now. The litigation continues. Insufficient oversight of judges. This was discussed at length regarding accountability. There are not uniform court rules. There are not uniform protocols. There is no appellate process for interim orders. So if a case goes on for 5 years, 6 years, there is no appellate mechanism for interim orders during the course of that litigation. That is a huge problem. Here's Law would change that. So what is the blueprint for change? The court must enhance its training. We've talked about that at length. The court must end the practice of rotating judges through the family court on temporary assignments. The court needs to establish a fatality review process for child and adult fatalities. I'd love to say more, but I won't. Custody and visitation law must be reformed. Judges should conduct safety assessments, prioritizing the safety of children. Courts must stop considering the discredited concept of parental alienation. I want to say, practically every single case I appear on, when a domestic violence survivor says, I am concerned about visitation, I want supervised visitation, or I want pickup and drop off at a precinct, opposing counsel says she's alienating the child. I have had a judge turn to my client and say, ma'am, if I hear anything else like this alienating behavior, I am not afraid to change custody right now. Like, just when she says she wants basic safety mechanisms. Coercive control should be added to the social services law definition of domestic violence, and it should be included as a family offense in the Family Court Act. We applaud the recommendations of the working group on supervised visitation. We support allocation of resources for supervised visitation. As we've been discussing, this is considered the, quote, poor people's court. The fact that that's even used isn't massively insulting, horrifying, that people even still say that. It's just proof of the second-class justice that our clients are getting. So ultimately, these changes are possible. They are not out of reach. We have worked closely with dedicated public servants from the Office of Court Administration. We appreciate that so many of them were here today, and we hope that they will work with us as we go on to change these problems. Thank you.
Thank you. Next, we'll hear from Rachel Bronstein.
Thank you so much, chairs and the Senate, for this incredibly powerful hearing today. My name is Rachel Bronstein. I'm the Director of Policy at Her Justice, which is a legal services organization that for 30 years has stood with women living in poverty in family courts in the area of custody and visitation, child support, and orders of protection. In the interest of time, I'll highlight 4 issues that we believe shed light on how the courts can improve access and equity. One that we've heard a bit about is the delays and backlogs in the family court. To highlight an example, in child support cases, for more than a year and a half after the start of the COVID-19 pandemic and the shutdown of the family courts in New York City, parents could not even file support petitions because they weren't deemed essential. Once filings were allowed without normal court operations, cases were delayed and continue to be delayed to this day. Similar experience with custody and visitation cases as well. What is fascinating is that there's little known about the plan for addressing delays and even, frankly, the scope of the problem itself. The court administration needs to invest more resources so that it can regularly share data around the nature, duration, and outcomes of proceedings, and even issues we heard about earlier, like the levels of representation. We've heard today about the recently published Family Court Caseload Activity Dashboard, which is a start, but as to non-juvenile delinquency cases, non-child welfare cases, the dashboard raises as many questions as it answers. Greater transparency will improve the ability of litigants and lawyers alike to utilize the courts, increase the system's accountability to those who rely on the courts, and provide a clearer path to identifying solutions to the reform that we're all here to discuss. A second issue is that providing a greater menu of options for resolving legal disputes will increase fairness for families and improve system efficiency. Her Justice has deeply studied child support. I raised that issue again, including through a major court observation study a few years ago, and has championed a reform, including a New York State proposal, legislative proposal that's pending, which we thank Senator Hoylman-Siegel for support, which would create an expedited settlement conference process for parents who agree on support. Solutions like these can improve parents' engagement in the legal system, and by triaging cases, given the massive volume we've heard about, will benefit the efficiency of the system overall. And just very briefly, I won't go further into detail, but litigants and lawyers need clear and accessible information. Legal information empowers individuals to make decisions about when and whether to engage in the system. We've heard a lot about that today. And finally, advances in technology will increase access to justice. E-filing, virtual appearances at family court were important advancements in efficiency and access to justice. We echo our colleagues in calling for uniform availability and information to the largely pro se litigants who navigate the courts and how to utilize those. Thank you very much for your attention today.
Thank you so much. So I have a few questions, and I really do appreciate your testimony and your expertise. My first is just responding to, we received some written testimony from law professor Nancy Erickson stating what happens in our overburdened family court predictably leads to faulty decisions. Like in our overburdened criminal courts, the goal is not to have a trial, the goal is to get a settlement, the equivalent of a plea bargain, so that judges will be able to go on to other cases. In a settlement, the weaker party is usually the one who gives up the most, so it is predictable that an abuse victim will end up the loser in a settlement. Does that statement ring true in any of your experiences?
Okay.
There's a lot of that is true.
Yeah, I think it is our experience that judges very much want cases to settle, that our clients are, I don't want to say strong-armed exactly, but are strongly encouraged to settle. That even the entire culture of the family court, which has been discussed at length today, even opposing counsel and attorneys for the children, in general, they just want the case to be disposed of. So if you say, well, actually, my client wants a 5-year order, which can only be arrived at after trial, everyone kind of rolls their eyes and, doesn't want to take court time with you, availing your client of their right to that trial. I do think it's true that I'd like to think that the clients I represent and my office represents and all of our offices represent, that we're not caving because we feel that our client is the weaker party. I'd like to think that we're negotiating strongly and vociferously on behalf of our clients. It would not surprise me if those who don't have strong counsel do cave, and that and by the way, I have had clients, one is coming to mind right now, who when unrepresented against an abusive opposing party have actually given up custody because they're still under. Domestic violence is violence, but it's also coercive control, and the litigation becomes litigation abuse, which becomes its own form of coercive control. And so our clients are often very intimidated during the process and give up all kinds of rights. So if they don't have strong counsel, it's very easy to give those up. Sorry if anyone else wanted to say
We're
anything.
also pushed to settle the case, and in declining to do that because we know we have a winning position, you're punished by having 6 more months to wait for the trial date because the calendar is full. So sometimes clients are punished by just having no outcome and being left in this limbo. Sometimes they want to settle just to be done with this process, and it's a balancing act of advising them whether that's appropriate or not in their particular case.
Yeah.
Can I just add one point? Just because we're talking about settlement, I do want to just lean into something I mentioned, which is that outside of the context of family violence cases or cases where the family is experiencing intimate partner violence, I do think it's important for us to consider innovations in how we're offering resolution of legal issues in family court. We've heard a lot about volume today. We've heard a lot about coming in through the door. And in the context of custody cases and child support cases, where you get 15 minutes, but you've waited all day, and you may not need judicial attention because perhaps there aren't disputed issues. For example, in child support, what if the family can agree on child support without an issue of coercive control plaguing the family? I think we need to think about innovations in what we're offering.
Thank you.
Thank you, Chair. Thank you, everyone, for your testimony. Were any of you surprised when one of our witnesses said that she couldn't imagine that that a litigant would be putting forward the parent alienation theory?
Were we
It was a judge who said that. Yes.
I'm sorry. What did the judge say?
She said that that judges were not accepting the so-called parental alienation theory.
So I'd like to distinguish between parental alienation theory, and it is not admissible at trial. It is junk science. It has been discredited. So I am not seeing, evidence submitted at trial of parental alienation theory with a psychologist. What I am hearing is the word alienation used to basically mean you are blocking the other parent from access to their child. So I think that it's important, to kind of really understand what's happening, which is that when a protective parent says, you know what, I don't feel safe, I think or I'm afraid for the safety of my child, that the opposing party is saying you are alienated, which is basically, there's other words, blocking, gatekeeping, there's a lot of terms that essentially they're saying you're manipulating the children and you're manipulating the system.
Thank you.
And I'm not surprised at all.
Got it. I wanted to acknowledge Chief Wilson's counsel, who has been here the entire length of the hearing, Noah Mamus. So thank you, Noah, for staying with us. And then finally, wanted to ask, thank you for mentioning the the judges who are moved to family court and their lack of experience as a result. Any anecdotes or insight you want to share in connection with that?
I have so many. We have as well. We've had family court cases of custody that were at trial from, with a judge that was from they were from civil court. They were going back to Supreme Court, and we were in a position of settle this case, or you have to drag to Supreme Court and finish it there. It was made clear to us that they did not want to be dealing with our case anymore. And we were in a position to say, well, this is your job to hear this case. We don't care if you have to go down the block. You don't want to be here, that's clear. And the litigant knows that. They can feel that the judge isn't even interested in this topic, much less their particular case. And it's difficult to explain to people that this is just the system. It's not right. They should be there because they want to be on family court. They should be trained in family court issues and have a practical experience.
How frequent is that kind of?
I would say it's very frequent. It's
Very.
been going on for years. When I was a court attorney in
Very.
the Bronx Family Court, we had judges from civil lines that were just filling in.
We had many cases mistried last year at around this time because January is when the judges cycle out. And so they just said, sorry, we're in the middle of a trial, but I got to go to civil court. And our clients were put in a position of either having to testify again. This is a domestic violence survivor who has already testified to the abuse, and they're halfway through their trial. So they either had to start over or accept a settlement, which many of them chose because they did not want to proceed. So that is not supposed to happen. That's against OCA policy, but it did, and we complained about it.
And my last question is that we've heard different suggestions for legislation today. Are you working together as a coalition of advocates to present one package of legislative suggestions?
I can answer that.
You should.
I think, yes, the answer is yes, but in slightly different ways, because although we're here together as 4 separate entities talking about much of the same issues, we have differences of opinion about some of the legislation. So I think it would be hard for us to say we all agree to all of these things. And some of the pieces of legislation are in development, still being tweaked, still being talked about. But I think what we all agree on is what we're actually seeing and observing in family court.
Would you want us as legislators to reconvene you in a different forum to discuss a path forward this legislative session on some of the bills you've mentioned?
I would love that.
Yeah,
I
we
mean,
would
I don't
welcome
want to
that,
speak
yes.
for everyone else, but yes.
Thank you.
Yes, Senator Rollison.
Thank you, Mr. Chair. Obviously, the domestic violence world is intricate. When we talk about coercion, control, and all the things that offenders use against the people that they're abusing. And when that presents itself in a courtroom, whether it is in family court or in criminal court or in Supreme Court, it can be complicated for individuals who don't really understand it. And we talked about training, but we don't know if it's 2-year training, DV training, not really measurable. We don't really know what the training may be, who's taking it. That is also problematic. And do you have any sense about, in cases throughout the family court system, say in a year's time, where there's a DV aspect to it? Is that measured in any way that you know? That a DV allegation was made, a DV allegation was proved, a DV allegation or something in the DV allegation actually affected the decision of the judge?
I can speak to some national research, not
Sure.
specific to New York, but it's estimated about 70 to 75% of cases in family court involve some kind of family violence. So that might not be intimate partner violence, but some family violence.
So since you, before Joan had given some startling statistics on individuals who had been convicted of domestic violence offenses, getting custody and those types of things, which I just find absolutely egregious beyond belief, that we heard from Judge Rivera about an integrated DV court in Albany County, where I I know that the judges are especially trained in domestic violence, and that will actually be good for the individuals that are there. How is that done? I mean, is it, and we didn't really get a chance to ask him, and I didn't, and I probably should have. Who requests that, that integrated DV court? Just like I would assume it's along the lines of a treatment court, where you've got drug courts and other types of things in different jurisdictions.
So the integrated domestic violence courts are specialized courts where if there's a criminal case as well as a family court case, they both come not simultaneous because they have different rights that adhere to the different dockets, but they both are heard before the same court. And those are, as you're suggesting, those are considered the specialized courts, and there's one in each borough in New York City. There's several throughout the state, I believe. Maybe you know exactly how many throughout the state. I don't know.
I don't know how
Yeah.
many, but there's not many upstate.
Yeah, and those are, it used to be actually, when I started practicing a few decades ago, that there were actually specialized just family court parts that weren't the integrated domestic violence courts, but were just a judge who wanted and cared and became, I think, specially trained to preside over more. That does not exist as far as I even know of in the family courts anymore in New York City. I don't know why. I think it was a really an excellent practice and something that should be considered.
And thank you for your testimony. Appreciate it.
Thank you.
Well, thank you all so much for your testimony. I appreciate it. Yes. On our next panel, we will have Mark Funk, the president of the Chief Defenders Association of New York, Joanne Sirotkin, the attorney-at-large at Legal Services Hudson Valley, Kathy Kramer, the CEO of Family Legal Care, and Louise Feld, the senior writing and policy attorney at the Children's Law Center. And if you're fine with the order, we can start with Mark, then Joanne, Kathy, and Louise.
Good afternoon.
And if you can speak into the mic, please.
Good afternoon. I'm Mark Funk. I'm the Monroe County Assigned Counsel Administrator. I'm also actually the immediate past president of the Chief Defenders Association, but the chair of the Family Court Committee for the Chief Defenders. Much of my prepared remarks have been addressed already today, so I want to just hit some highlights. There have been some questions about 18B rates and things like that. First, I do want to say I thank you all for passing the increase in the 18B rates. However, I want to impress upon you the irreparable harm that has been done by the fact that the rates were not raised for 19 years. I've been the assigned counsel administrator in Monroe County, which is the Rochester area, for 7 years. Our family court panel of attorneys willing to take family court cases in that 7 years has gone from 77 to 51. We are a larger community. We have 51 lawyers still willing to take family court cases, but our outlying counties, more rural counties, are having a difficult time finding folks that are coming to me. Do you have folks that you can send to us? So that is the irreparable harm that has happened by 19 years of no increase in assigned counsel rates. Now, my other hat regarding the Chief Defenders Association. My first comment and takeaway from today is the family court system is the most ineffective and racist system imaginable. I don't think New York could have created a worse system if it intentionally tried to make a racist, ineffective system. With regard to child policing system, the last statistics I saw was that we are reuniting parents with children 50% of the time. That's the entire goal of the program, is to reunite, and we're only accomplishing that half the time. We need to do better. I would emphasize, I think what you've heard today is the public defenders that work in family court are committed and passionate about this work. They need the resources to do the job properly. Senator Brisport, you've mentioned a few times today about services. That's where we need to go. We need services for our parents to keep them out of the system, and if they're in the system, to get them out of the system faster. So we implore you to give our attorneys the resources, give our parents the resources, the preventative services to clean up this system. Last thing I want to note is you've heard from like CFR and Bronx and Brooklyn about all the great work being done in New York City with parent advocates and social workers and all that. All of that is completely unheard of in upstate New York. We do not have that, okay? And we need it. You heard the good work that is happening, that kids are getting out of foster care quicker, or not going into foster care in the first place, or they're not even going into family court in the first place because of the work of CFR and Bronx Defenders and Brooklyn. We don't have that, and we need it. So the upstate folks are begging for you to right this ship. Thank you.
Thank you.
Hi, everyone. I'm Joanne Sorotkin. I am from Legal Services of the Hudson Valley, and I want to thank you all for the opportunity to testify and your tenacity today, because you've heard all the testimony so far. I've been tried to cut down what I had to say, since so many of my eloquent colleagues have already said many of my points. But I will share that Legal Services of the Hudson Valley is the largest provider of civil legal services in the Hudson Valley region, and we have an extensive family court practice in Westchester, Putnam, Rockland, Orange, Dutchess, and Ulster and Sullivan counties, which is primarily made up of a robust domestic violence program. However, we also have the model upstate office for multidisciplinary family court representation, family defense unit in Westchester County, which is the first of its kind outside of New York City, which includes social workers, advocates, and lawyers. And I hope you will ask me about how we are diverting cases away from the family court, and we are narrowing the front door with our work. The special advisors, and I just want to add that year to date, we've handled almost 1,000 family court cases, and 75% of our clients in those matters identify as people of color. The special advisors report, as well as the Franklin Williams Judicial Commission report on the New York City family courts, are both highly applicable to the family courts in the Hudson Valley region. And I want to highlight 4 important pieces today, in addition to what everyone has already said, which I echo. There is a lack of language access, a culture that lacks respect and compassion for the litigants and the participants, a lack of oversight, and a greater need for electronic filing and virtual court appearances. But I share what the domestic violence organizations, the civil legal services providers, the family defenders, and all of the defender organizations have said, and their perspective on the work. Very briefly, in addition to the lack of available interpreters in the courthouse, parents who are charged with Article 10 cases do not have the documents translated into their language of origin. They literally cannot read the charging instrument. They cannot read the order that separates them from their children, and they can't read any of the orders that are going on during the case. Now, as an institutional provider, and I'm sure the other institutional providers do the same, we translate those documents at our own expense. But for those people who don't have the benefit of us, which is the majority of litigants in family court, they don't get translated documents. So people are expected to follow custody orders and child support orders, which profoundly affect their cases, and they just can't. The family court's dehumanizing culture has been talked about a lot, but I just want to focus on one point. Bias training is not enough to remediate the problem. There is a lack of understanding, empathy, and compassion to the litigants, particularly the BIPOC litigants, and it is not unusual for attorneys and clients, including domestic violence survivors, to be yelled at by family court judges or treated rudely by court personnel. And this is dehumanizing for everyone involved. So we got to go beyond bias training. We need to have the court focus on the concept of trauma. Our litigants have suffered the trauma of racism, the trauma of poverty, the trauma of family separation, the trauma of domestic violence, and we need everyone who's touching the court system, judges, court personnel, 18B attorneys, institutional providers, AFCs, all need trauma-informed anti-bias training. And it seems clear to many of us who have spent our careers working in the system that this culture of disrespect that exists within the family court is so pervasive because of the stereotypes and assumptions about the people who routinely use the family court, people of color and poor people. And this lack of compassion extends for the litigants to a lack of understanding about domestic violence and poverty. So even where there's a family offense petition that alleges severe domestic violence, judges frequently default to unsupervised visitation and joint legal custody, demonstrating just a lack of understanding of that the survivor may have extreme difficulty co-parenting with the other party in an equitable way. And survivors of domestic violence are routinely penalized in Article 10 cases as well. And being mistreated in family court causes litigants to think that there is no justice there for them. They give up, they compromise when they could get a better outcome in the case. They think that there's no point in continuing to fight. And if we care about the people who are coming before our family court, we need to do better. I'm going to echo what Joanna said. We've got a very diverse group of counties, including people who have to travel hours by public transportation when there's barely any public transportation for a 15-minute court appearance. We really need a default to virtual court appearances in conferences, and we need a NICEF system for electronic filing system for family court. So the greatest cause for concern is really the lack of oversight, which so many people have spoken about so eloquently today. But this lack of oversight creates these dramatically inconsistent practices, courthouse to courthouse and judge to judge.
Sorry,
And
if you could wrap it up soon, please.
Sorry. So it's in my longer testimony, but we have situations where judges refuse to set cases down for trial, even at great prejudice to the litigants. 24 months in an Article 10, no fact-finding. Although our courthouses are presumptively open, as the senator said, in many of our upstate counties, it is exactly the reverse. They are presumptively closed. Some judges don't assign counsel to force vulnerable parties to resolve cases. Judges dismiss domestic violence to such a degree that even where lethality is indicated, the judge is allowing unsupervised visitation. I will just add that there is one judge in our jurisdiction who is not hearing ex parte family offense cases and is not issuing orders of protection, and instead has the summons and complaint petition served on the respondent and brings the parties back to court, making the domestic violence survivor less safe. So just to say, I hope you read my testimony because there's many more examples of this, and I hope you ask me questions. And I guess I'll just say what Joanna said is we really need deeper and more robust training for assigned counsel and for AFCs, and we need oversight so that someone is making sure that all of the litigants are treated with respect and are getting the due process they deserve. Thank you.
Thank you so much. Ms. Kramer?
Yes, thank you all for hanging in there for one of our last panels, and I know there's an important one coming up next. My name is Kathy Kramer, and I'm the CEO of Family Legal Care. You might have known us in the past as LIFT. We're the only organization in New York State dedicated solely to giving parents and caregivers the tools they need to represent themselves in family court on issues such as child support, custody and visitation, parentage, domestic violence, and guardianship. As I'm sure you're aware, 75% of the cases that come to family court are not child welfare or juvenile justice cases, which are, people get an attorney for. So most of the cases that come to family court people come without an attorney. We work with over 25,000 families every year. We work closely with the jurists and staff in family courts. We're all doing our very best with limited resources, understaffing, and tremendous caseloads. One of the things I think we very effectively do is keep people from coming to family court in the first place because we help them go get mediation or other things. But the family court was designed to be a place where you could get justice without an attorney. 80%, as we discussed, of litigants come without a lawyer. But the reality is that it is a complicated course. Legalese, high legal standards, procedures. Legal support is essential. The issues, as you know, are highly personal and emotional, having to do with kids and families' futures. And as we've discussed, the court mostly serves low-income families and people of color, and so reforming the family court is a racial justice and equity issue. We've talked about a number of the recommendations that we put in our longer testimony, but I want to start with one I haven't heard anything about today, which is the courts must prioritize child support. Child support is a poverty prevention tool that can help prevent other issues from ever reaching the family court, including domestic violence and child welfare cases. It's a way of trying to narrow the front door. 40% of all cases in family court involve child support, and yet these cases often take months, even years to resolve. Because child support involves money and there's a formula, people believe that child support is not a complicated legal matter, but that cannot be farther from the truth. As my colleague from Her Justice said, there are some cases where there's no conflict or contention. But in other cases where there is a lot of contention, litigants do not have a right to an attorney in child support unless they're facing imprisonment for non-payment. Pro se litigants are held to the same standard as lawyers and are expected to offer evidence, cross-examine witnesses, and to understand other court procedures like service, which is one of the hardest things anybody has to understand. So child support is not just about money, it's about housing, it's about health care, it's about food on the table. We talked about hiring more jurists and support staff. This has been a chronic problem for decades. COVID made it worse. Very high caseloads for all the jurists, very little support staff. Litigants end up waiting months. We talked about all that. We recently Family Legal Care came back into the courthouse to provide legal information to people who come to the courthouse, who, as we heard from the Judge Jolly, they can't give people legal information. So we do that in the busiest courthouses. There are a lot of new clerks that have been recently hired. The training is not excellent. People don't have experience, and they often give out the wrong information, and then that ends up with further delay. I was really glad to hear about the lack of standardized procedures across the family court, and that they must need to clarify the process, because someone comes in, they don't have access to us or even a clerk, they will never understand what they have to do to present evidence in court or understand the different procedures. And those cases get adjourned or dismissed based on technicalities. The family court needs to really improve its outdated technology. I, too, have heard about this website for years and years and years. We just upgraded our website. We offered to help the court because we've just been through this process of making it very client-friendly. Forms that are on the website need to be updated. One of our clients recently took a form from the website and was told by the jurist, this form is from the last century. She said, I got it off the website. So then we had to have another, adjournment. Another issue that I don't know have been raised today is that the court has limited access to UCMS, and organizations like ours do not have access to this case management system, which really limits our ability to give a clear understanding, for us to gain a clear understanding of the litigant's case history, and it would absolutely help with court efficiency if we knew what had gone on before. Our clients come in with us with shopping bags of papers. We spend half the time with our clients going through their papers. And then the last thing, or two more things. Last thing I want to say, 18B panel, we work closely with them. Many of our litigants, we want to, either need a full representation from an 18B lawyer. They need pay, they need a COLA, all the things that we've talked about today. But many people are so frustrated that they can't find their 18B attorney, so they call us up, and even if they had the attorney, they want us to support them with our much more immediate support. And then the virtual proceedings, I hate to think about them not being offered upstate, but one thing that we find with our clients, they do not have access to, it's the digital divide. So many of our clients will attend their virtual hearing getting public Wi-Fi at the subway station or walking down the street. That is not justice. And so I just hate to hear about our clients who, are 5 minutes late because of a subway problem, and the jurist dismisses the case or adjourns it, and 3 or 4 or 5 months later, they come back. They might have the same problem with teams that they had at the first case. We do not want to see technical difficulties impacting the outcomes of the cases. We love, particularly in child support, that virtual hearings are there, but not everyone can use it as effectively, so the court really has to upgrade their support. Strong families are essential to the welfare of our great state, and we think fixing these challenges, all the challenges we've talked about all day. Thank you so much.
Thank you so much. Thank you. Next.
Good afternoon. My name is Louise Feld, and I'm the Senior Writing and Policy Attorney at the Children's Law Center. CLC is a 26-year-old nonprofit law firm that's represented approximately 130,000 children in New York City family courts and in the New York State Supreme Court IDV parts. And we're so thankful for this opportunity to testify, even at the end of the day. And we are so thankful for your interest in these very important topics that we've been hearing about from so many panelists throughout the course of the day. Now, to be clear, the majority of the children whom CLC represents are low-income children, are children from families of color, and so everything you've heard from the panelists, I will not belabor, except to say that it is our experience, our clients' experience too, regarding the culture in family court and the fact that these young people of color and their families are really being denied access to justice. You've heard a lot about that. Although it bears repeating, I will move on. It's also based on our experience representing these young people that unconscionable delay in the resolution of custody and visitation cases is the biggest court operations issue in this practice area. And my remarks, and I've submitted much lengthier than those that I'm speaking here today, go into detail about this and are focused on custody and visitation because that is the type of case that makes up the majority of our very, very sizable caseload. And we see unconscionable delay in all forms. We see routine adjournments between simple court appearances that are 4 or 5 months long, sometimes longer. We see families waiting a year to get a hearing on a custody or visitation petition and then have that hearing take years to complete because of the court's limited calendar. We see delays because there are no supervised visitation providers. We see delays because we can't get a qualified forensic evaluator to be able to work with a low-income family. We see delays because there are not interpreters available to appear in a case. So on custody and visitation, delay is the enemy, and it is just something that is experienced repeatedly by the litigants who are trying to get some resolution to the crisis in their family. Now, also in my testimony, I've included examples from the words of our clients and their children. So they're not here today. They're not on this panel. But the words of our clients to their attorneys about the impact that this protracted delay has on their emotional well-being. We've spoken to teenagers who tell us about their suicidal ideations. We've had to call ambulances sometimes. We've had to, we have social workers that we work with who have to put plans in place for kids who are expressing some really, really serious self-harm because of what is happening to them, because their family's case is dragging on and they are caught in the middle. There's one example that I have in our testimony about a 7-year-old boy who, in order to describe the impact that his parents' protracted custody litigation was having on him, said, I'm going to say it like this. My family is like my mouth. My mom is the top row of teeth. My dad is the bottom row of teeth. I'm the tongue. And then he bit down hard on his tongue to demonstrate, a 7-year-old, to demonstrate how he was being impacted by his family's protracted custody litigation. Now, the truth is that these delays don't seem to be getting better anytime soon. This was a problem prior to the pandemic. It was exacerbated by the pandemic. And now we have a situation where court is returning to normal operations, or at least operations as they were prior to COVID-19, and the floodgates are opening. The filings in custody and visitation are sky high, and the case numbers are for jurists, for AFCs, for parent representation are just through the roof. So there is no end in sight from our perspective to this massive delay. We have included a number of recommendations, some of which you've heard, and I think from other panelists, and of course the fact that everyone is recommending them, I think gives them a lot of validity. But I do need to, again, reinforce some of the things that we think the state should be doing in order to address this unconscionable delay and to try and protect these children emotionally and physically. One is increased funding for AFC, for AFCs. Mr. Terry, who was on a prior panel, talked about that. Really high caseloads and low wages have become the hallmark of doing AFC work. It has made it impossible to, or nearly impossible, to recruit and retain qualified attorneys who are interested in doing this absolutely critical work. And there really needs to be an increase in funding for AFCs. There also needs to be dedicated funding and an amendment to the social services law to support a statewide supervised visitation initiative. Because there are some counties throughout the state that don't even have a supervised visitation resource. I know you've heard a little bit about it before. There are also the counties like those in New York City where we practice have very, very limited supervised visitation resources, and it's nowhere near enough to meet the demand. And really, if you want to keep children safe, and I know we talk a lot about legislation to keep children safe, but one of the best things that you can do to keep children safe is make sure that there are resources for supervised visitation so that the court can get good information about what's going on prior to, I'm sorry, if I could just, the last.
Yes, please.
To increase funding for adequately credentialed forensic evaluators, and I'm happy, I know Senator Mayer has asked some questions about that. I'm happy to talk about forensic evaluations here or offline, and also just reinforcing increasing the number of family court judges. But because I'm talking specifically about custody and visitation, if I could just also ask that there's a plan to assign some of these newly appointed judges to custody and visitation cases, and not only ensure that they're properly trained, but also that some of them have prior experience with family law, because we did see people on the bench who this was their first introduction and it was presiding over cases. It was their first experience with family law. So I'm sorry for going over my time. I thank you so much for listening at this late hour, and I'm happy to answer any questions and continue conversations after today.
Senator Mayer?
Yes, Mark. Mr. Funk, I'm troubled by what you said about foster care in Rochester. I'm very familiar with the Rochester Public School situation, which is very troublesome. Of the foster care, of cases that come to you where there's a possibility of foster care, how would you characterize what happens to the majority of those children? I mean, you said the support services that were downstate do not exist for you. So what happens as a practical matter?
As a practical matter, CPS files a petition to remove the child. The child is more likely than not removed from their parents and are removed for an extended period of time.
How long is that, generally?
I don't know specifically in Monroe County. I believe the state average is something like 26 months.
Oof. That's over 2 years. Does a hearing occur?
Not, most of the time a hearing is not held. I think I think this is not just Monroe County. I think this is systemic, that a lot of courts make it clear that they do not prefer having 1027, 1028 hearings, that having that hearing may prejudice the litigant moving forward in the case. And particularly with 1027s, which are supposed to be immediate. I mean, in Monroe County, one good thing about our family court system is we actually get the removal petition the day before.
Oh.
So we actually have like
a little bit of time.
A little bit of time instead of, and this just happened since the pandemic. Pre-pandemic, we would get the petition as we're walking into court.
Right.
And so that has been one benefit of the pandemic, I guess you could say. So, but we get it the day before, so we do have a little bit of time to prepare, but 1027s are not advantageous to us or our clients when we're getting the petition as we're walking in the door, which is the usual course
Yeah.
in most family courts in the state.
Well, I hope your testimony addresses the real issue of these children being in foster care for a significant period of time and the impact on them. But I'll follow up further with you about that.
Okay, and
Thank you.
we haven't submitted our written
Okay,
testimony
when
yet,
you
and
do.
we will be.
Okay. And Joanne, just a question for you. Obviously, thank you for what you do with us, but language access, is there not Spanish language access available in every county that you serve, Legal Services in Hudson Valley?
So there's a difference between having an interpreter available
Yes.
in the courthouse versus having documents translated
Yeah, I
into
got
the
the
language.
documents
Right.
part.
So interpretation is a big issue in our multi-county area. Oftentimes, there'll be one interpreter if you've got a combined family court, Supreme Court, there might be one interpreter for both courts on a given day. And so you can almost be guaranteed if you are there with a litigant whose first language is, for example, Spanish, you will wait all morning to get in and see the judge because the court interpreter is stretched in so many different directions.
I think it's been clear for us that we want, at least I've said, interpreter speaking Spanish in easily available in every court in New York. Otherwise, you have your eyes closed to what the demographic breakdown of the counties that we serve. But thank you all. I'm sorry we don't have time for a lot of questions. I want to make sure our last panel
Thank you
gets
very
their
much.
voices heard.
Yes.
Yes.
Thank you very much.
Thank you.
That was our penultimate panel, so
Penultimate.
our ultimate panel is making their way forward. Desiree Wright, policy and parent advocate. Latia Govan, advocate and impacted parent. Davine Roseborough, advocate and impacted parent. And Kristen Hernandez, Esquire, advocate and impacted parent. Thank you.
And thank you for
Thank you.
waiting.
Thank you for waiting.
Thank you so much.
I wanted to ask if there was space to add one more parent to our panel who wants to give testimony here today.
That is a stretch, but they could certainly come up and sit with you.
Thank you. And so I believe we had our panel order beginning with Desiree Wright, but I
That's
think
fine.
we want to switch it up, and
Oh,
I'd like
okay.
to start.
That's fine. Just announce yourself for purposes of our media services.
Absolutely. So my name is Kristen Hernandez. I'm the Director of Policy and Advocacy with JMAC for Families. So I want to foremost thank you all for your time and extend my gratitude to all of the parents who have spoken here today and shared their stories. Right? I think New York families are here today bravely and very generously speaking out about the indescribable traumas that they've experienced at the hands of the family court system, right? And that bravery demands our action. Lawmakers must listen to families as they call for wide-scale divestment of resources from the family court system and investment into community supports that truly treat and prevent harm. New York State can easily reduce the size, scope, and power of the family policing system by passing 3 essential bills this session: the Family Miranda Rights Act, the Anti-Harassment and Reporting Act, and the Informed Consent Act. As a former public defender, I'm also going to repeat a lot of things that folks have said that former and current public defenders have shared, right? But as a former public defender representing parents accused of abuse and or neglect in family courts, I'd hear judges often talk about family courts being rehabilitative. I think we also heard judges today describing family courts as spaces for stability, permanency, and justice. But there's a persistent misalignment between the professed goals of a so-called child protective proceeding and the lived experiences of parents, these parents, under scrutiny of judges who so often treat them as guilty until proven innocent, and therefore undeserving of care, support, and family irrespective of whether or not they have actually caused harm. And we acknowledge that harm does happen in families, right? But the family court system only perpetuates further harm, right? From the start of a court case, parents and caregivers are at an extreme disadvantage. Folks have spoken about this at length here today. They lack information about their rights, what to expect from the court system, or knowledge of what they're entitled to during the initial arraignment appearance, right? Many times, parents and caregivers are meeting their attorneys for the first time in the courtroom as they are assigned, they are meeting their attorneys, leaving little time for parents to get a sense of their rights, let alone preparing for potential imminent risk hearings to decide whether or not their children are coming home with them, right? Insight is a word we often hear in the courthouse I worked in, referring to a parent or caregiver's capacity to articulate a sense of their wrongdoing. And so we've seen judges on the first day of court require that parents demonstrate insight, require that parents talk about culpability before they've ever even had a trial in order for their children to come home. Naming all of these injustices, I want to echo all of the things that other folks have said before me, and I want to stress that funneling more resources into a system whose power largely derives from its ability to separate children from its parents is not the answer, right? We need to come up with new solutions, and while we work towards those solutions, there are things you can all do, right? You could pass critical legislation to reduce the number of families impacted by this system. I want to thank Senator Brisport for something he said earlier today with respect to reducing the number of families that actually walk through the front door of a family court building. And we can do that with bills that I'm hopeful y'all and know that y'all are all aware of. The Informed Consent Act, passing anti-harassment and reporting, passing family Mirandas, and listening to the voices of those impacted by the family court system when they are sitting in front of you demanding change and action. Any change, any reforms, including reforms and training for judges, must include their voices, and they must be given a seat at the table at all times.
Thank you.
Hi. Excuse me, sorry. Hi, everyone. My name is Desiree Wright. I'm an impacted parent. I am also a parent advocate for the Bronx Offenders Family Defense Practice as a member of Plan Coalition and a collaborator with JMAC for Families. I'm going to try my best to stick to the 3-minute rule, but I'm going to be honest with you. As an impacted parent, this is where my voice can be heard, not in those courtrooms, so please bear with me today. I want to say thank you for having me today. Next, I'm so sorry that ACS and OCFS is not here to hear today from the many impacted families impacted by this system. So to them, I'm sorry. I have heard the word justice used more than one time here today. Thank you, Heaven, for highlighting this. But my PTSD will not allow me to say I have received justice in those courtrooms. So when we describe family court, the only word I can use to describe family court is racism, unfairness, and many other words, but justice is not one of them. Broken system, reform, I've heard those words too. You can't keep putting Band-Aids on wounds that don't want to be healed. Family court is not a space of healing or fair system, but a system of harm. Sorry. Now I'll go to my testimony. That was just something I added because I heard all these words today. I speak to you today as a parent who has been directly impacted by this system and has experienced family court. It was 1995 for me, and I was a young person, and I had just become a mother. The hospital where I gave birth called in a case on me because I tested positive for marijuana, a drug legal today. During the labor and delivery for my child, I was only 17 years old. I was still in school, living with my grandmother, and doing everything that I needed to do to care for my baby, for my new baby, who I love deeper than words can convey. But when I showed up in family court for the first time, none of that mattered. The judge did not see me. She did not see Desiree Wright, a young mom doing all she could to make the best life for her new baby. It didn't matter from her demeanor, or from her body language, from the words coming out of her mouth. I knew that when that judge looked at me, all she saw was a mom who smokes weed and does not take care of her kid, a mom who needed the court's oversight. I was always painted in a negative light, no matter how hard I tried to comply with the many mandates the system put on me. For example, I lived in the Bronx, and my son was placed in a foster placement in Brooklyn. Even though I was still in school, I managed to make it to and from Brooklyn multiple times to visit with my son. On the few occasions I was late to a visit or missed a visit, the judge scolded me and suggested that I didn't understand the importance of visiting my own son. But the court never scolded ACS or the foster parent when they consistently failed to bring my son to visits. In fact, the court rarely said anything at all. Because I tested positive for marijuana at birth, ACS and the court mandated me to do a drug treatment program. I don't know if y'all know, but they don't have drug treatment programs for marijuana usage, okay? Exactly. Not even in prison, okay? I just wanted to highlight that part, right? But neither ACS nor the courts cared that there were no drug treatment programs geared towards marijuana use, much less programs geared toward minors. I was a minor, they didn't accept me. Because I was 17, I was turned away from every referral that ACS sent me. There were programs for adults. These were programs for adults. I was a child. Despite this, when I came to court, the narrative was only mom is not engaged in services. Mom is not complying with court orders. No one cared that I was a child myself. No one cared that I was still in school and that while running all over New York City to find a drug treatment program for marijuana use, I was missing out on education. No one cared that an education was far more important for my own well-being and my baby's well-being than a drug program. The court was only concerned with ACS's formulate service plan. And when I did do services that I found on my own, anger management and parenting, that was largely ignored by the court. At a certain point, I just stopped going to court because it was pointless. And let me be clear what I mean. Showing up to court was pointless because it was clear to me that there was no due process, much less justice for me, a young black mom. To go to family court was to endure routine discrimination, humiliation, ignorance, condescension, and hostility. Family court was a place where it was clear that I was a second-class citizen who could forever be denied respect, fairness, and justice. I was tired of hearing that. I was tired of hearing that I was a bad parent and that I was not doing anything for my child. I was tired of walking into a court day after day where the only people being hauled in there were people that looked just like me, black and brown parents, as if my whole entire community was substandard. It was so telling that it was only black and brown parents in family court when we know that white and wealthy parents do the same things that cause black and brown parents to lose their children. You can't tell me that there were no white parents who smoked weed.
Ms.
Yes,
Wright,
I never once saw a white parent in that family court. Overall, my experience with family court made it clear to me that it was not a place where I could get justice. Once the judge read the paperwork that ACS submitted, that was it. That's what the judge believed. That's what shaped the judge's opinions and orders. That the idea that family court is neutral is a fiction. Moreover, my experience showed me that family court was not and would never be a space of support. Family court destabilized my life. It made me homeless at 17 and deprived me of my education. It destabilized my child's life. Family court caused me and my family harm from which my children and I have had to heal. As an adult, I tell my youngest son, who is only 7 now, years old, don't even think the courts are for you. You have to fight for yourself. You must know your rights. You must know the law. You need to involve yourself in everything that involves you. The judges do not see you. They see paperwork. They see what the government says you are. The system is not a system that was built for us or will ever be fair for us. So finally, to end my remarks, how do we move forward? The way we must move forward is to shift power and autonomy back to parents and communities mostly impacted by family court. You must narrow the pathways that push people into the family policing system, of which the court is a part. To do this, you should ensure that not another day goes by where parents in New York State do not know their rights when ACS knocks on that door. You must champion and pass Family Miranda Rights Senate Bill 901. You must ensure what happened to me does not happen to other parents, and pass the Informed Consent Bill 320, which requires that health care providers obtain written and verbal informed consent before drug testing a pregnant person of their newborn. And finally, you must pass the Anti-Harassment and Reporting Act Bill 901, which will do away with anonymous reporting to the SCR. Also, I am
Ms.
asking
Wright,
to,
I'm sorry, we need to let someone else.
this is it. I'm asking to pass some bills, but I want to push back on bills. 86741, expanding mandated reporting to MTA workers should not be something that black and brown people have to deal with policing all over again. And thank you for having me here today.
Thank you. And thank you for mentioning some of my bills too. I appreciate that. I know we had, you actually had an order in mind. Okay, so who's?
3 minutes if you could.
All right. Hi, my name is Latia Govan, and I'm a graduate of JMAC Families Hill Program and a mother of 7 and grandmother of 1, whose life have been disrupted by ACS and the family courts. ACS first came into my life in 2014 when I was pregnant with my 4th child and residing in a shelter with my mother and my 3 children. Based on mental health concerns, they asked for my children to be removed, but the judge said no, and for them to help me and my family. Eventually in my case, the judge disagreed with ACS, I'm sorry, I'm a little nervous, and stated they should help me and my family instead and paroled my children to my mother. Eventually, my case was resolved a few months later with a suspended judgment and supervision. However, after the shelter kicked my children out, and the shelter had kicked my mom and I and my children out. ACS filed to remove my children in 2015. An emergency hearing was held. My attorney, the attorney for my children, and the children's fathers, the maternal grandmothers, and my mom, all were waiting outside the room of that hearing, and they did not allow us to come in to ask for my children. So after this took place, the children's attorney had filed emergency order show cause to have them placed with the fathers. And till then, that case has been adjourned and followed up and closed, and they remained with their fathers to 2017. Then, 2017, I gave birth to my son, and he was removed from me because my children weren't in my care and because they claimed I didn't have housing. I had no open case at the time, but that case was used against me. So I presented myself in court and I represented myself in court and was not successful. In 2019, I had my 6th child. She was removed from my care because my son was in foster care. I represented myself pro se and wasn't successful. In 2021, I gave birth to my 7th child, and she was removed from me, but I filed a 1028 when I had help with Bronx Defenders. My attorney, that hearing was 8 months, and during the hearing, I had to give breast milk to the foster care, and after that, I won the hearing, and then my children that were in foster care were sent to me in my care. In 2022, ACS filed a new petition against me. The reason why is because they stated my son had mental health issues and that I was not able to handle him. But his behavior is because he's been in the system. So now, currently, this case is still open. There's been 18 Bs assigned, and none of them had helped. None of them filed for me. They didn't file a 1028. I just look at this as abusive process, due process violations, and at this time, I'm being told that I cannot have visitation because I refused to sign for my son to have medication, my 5-year-old, and also for him to be in special education. At this point, I feel that there's due process violations, and the judges are not doing their job, and they're supposed to be bound by the Constitution. They have an oath of office. According to Article 6, the supreme law of the land they're supposed to stand and enforce. This is supposed to be enforced. But unfortunately, there's violations that occur, and it causes harm to the family. It's unethical. We know it's unconstitutional, but it takes away civil rights, human rights, and basically, based on the abuse of discretion and conspiracy against rights, it reminds me of deprivation against rights. This, to me, it needs to be a solution for a judicial review and discipline from these officers that are not bounding by their oath, and they're going against their their fiduciary capacity. There needs to be some kind of oversight for the officers of the court, and parents, they need more attorneys that come from a holistic office who will let them know their rights, execute the rights of the clients, and take affirmative action on the client's behalf. We do not need more resources in the family court system. We need to eliminate the harms of the family courts by making sure that parents know and can assert their constitutional rights. This is the reason why I support the JMAX bill as far as Miranda Know Your Rights, because it would eliminate the harm that occurs in these courts.
Thank you.
Thank you.
And then our final testimony.
Well, you know what I mean, right? It's not JMAX bill, but, the Miranda
Yeah,
rights.
we got it.
I mean, it supports the Constitution, the Fourth Amendment, because it's,
Thank you.
Let them know.
Who's next?
My name is.
If you could just move the microphone. Thank you. 3 minutes, please.
I'll try. My name is Davine. I'm an advocate, and I'm a parent who has been impacted by the system. My son was removed from me in 2012. He was placed in foster care where he was molested. My son was sexually molested. The judge let the pedophile off with 5 years probation because he said he agreed to a deal, and a deal is a deal. I wrote a testimony stating that I think even the probation officer they assigned him to stated that he needed jail time. The judge still let him off. The district attorney who was on the case, I asked for her to be reassigned. They never reassigned her because she was not for me. She told me blatantly to my face that the reason why my son was put in that situation because I jeopardized him and put him in the system. Once the molestation case took place with my son, they automatically discharged my son to me to get it out of their hairs. That case stood for 5 years, and it was just granted last October where he got 3 years probation. My question to you guys is, what happens to the other kids out there? You let him go so now he can molest somebody else. And I'm trying to find somebody to appeal because I heard a lot of panels say that there is a process for appeal, but I was never given those options until I heard it today. So when you talk about options that we're given, are we given those options? Because I'm telling you, I was never given the option to appeal this case. And it has not been 3 years yet. So if y'all can give me some type of insight on how I can appeal this and overturn it, I'm willing to listen. Also, I wanted to touch base on some of the things that was stated today. I believe that the system is a pipeline to jail. I believe that the system is the pipeline to jail. I'm a child who came out of the system myself. I've been incarcerated. I've been molested in the system. Unfortunately, I did go to college. I did get a degree. I did graduate. I am an advocate now today. I graduated from St. John University, but none of that had nothing to do with the system. I did that on my own. I did that from outside resources like non-for-profit organizations that helped me build myself. So that had nothing to do with the system. Another thing I wanted to touch on was, and I'm sorry because I'm becoming a little emotional. Another thing you spoke about today was parent advocacy. You guys are pushing for parent advocacy. I have a job right now on hold with Grand Wyndham, and do you know that they will not hire me because of my background with ACS? I have this job on hold to the point where I have somebody from JMAC for Families, a lawyer, and she's helping me expunge this. I'm going through this right now as we speak. They have my job on hold because of my background, and I have to expunge everything from my background before I get an advocacy job. So you guys are saying that you're pushing this advocacy law, but it's still a blockage because of our background. We still can't get it. So what are you really pushing for? Another thing I'd like to address is, oh God. The reporting. I'm pushing for the mandated reporting. For people to tell who they are, give a name. A lot of these reports, I got a package yesterday about as thick as a book. And when you read it, none of it's true, but it's stopping me today from getting a job. It's hindering my future with my kids. I can't financially support my kids. Another thing I wanted to touch on, I advocate for parents. I'm advocating for a parent right now, and I'm going to bring this up because I feel like it's unfair. She's passed all and did everything that you guys asked this parent to do. And because the child is in kinship, the judge and the agency is pushing for the child TPR. Termination of parental rights, and I think that it's unfair. They're not listening to mom. They're not listening to the lawyer, and this is a case that I'm fighting for and I'm advocating for, and I'm telling them the first thing is reunification with mom, not with the grandmom. Grandma is secondary. Mom comes first. So that's another problem that we're having in the system where a lot of the panel spoke about friendships with lawyers and judges. That was a problem within my son's case. I watched the district attorney laugh and giggle with Justin, the one who abused my son, lawyer. And I had to step out myself and say, do you find this funny? I think that my son's case was let go and it was thrown off because the person who molested my son, his family was of political standards. So the father sat on the NAACP. The mother was a part of the father was also a part of the national NAACP. He was a member of the NAACP. The mom sat on the committee for the Mount Vernon School. All of those things played the factor in the determination of whether he'd get time or not. And I don't think that they should have because of the relationships that the parents had with the community. It hurt my son. And my son have to go through mental health evaluations, and we're still going through this today, the trauma. My son will not talk to officers. He do not want to go to judges. Another thing I wanted to say is about the Zoom sessions that you guys are talking about. I asked for Zoom sessions when it came to my son. They say that they let the case go and he got the sentence that he got because they would have had to put my son on the stand at trial. And I thought that it was more traumatizing, especially from what he'd been through. So I asked for a Zoom session. They turned him down. So you guys are saying that you're implementing these Zoom sessions. They're not being implemented, especially in the case with my son, because we asked for one in order for this to go to trial, and it was totally thrown out. Like, no, we're not. The judge said it point blank, we're not. Another thing I heard you guys speak about was us obtaining the records. I'm still asking for the minutes of what that judge said so that I can have a physical copy. They will not give it to me. I then went through Vanessa Clark, the head district attorney of the Bronx. She was supposed to reply to me. I've spoken to her assistant, who said that if you look at the charges is so horrific that they don't even know how he got off with 3 years probation, but nobody will answer my plea or tell me what to do. Another thing I wanted to touch on that y'all spoke about today, I'm hearing a lot about money. I wanted to bring that up too. I heard one of the state senates bring up a situation. Well, I heard today about the 18B lawyers being funded. I don't think that we need that. I believe that they say that in 2003, there was an ATB fund that was established with $800 million. I think that can go to, that sounds crazy to me. I think that could go to families in need. I think that should not be going to an 18B lawyer. What about the families that need services? That money needs to be put into the community. I also heard one of the senators say that they're having a lot of problems because when you do get these 18B lawyers, some of them say, well, I can get, and these were the numbers he used because I wrote it as he was saying it, I can get $440 an hour compared to $70 an hour. But when I did the comparison as he was saying it, $70 times 8 hours a day, that gives you $560 a day. $560 times 5 days a week, that gives you $2,800 in a week. You do that times 4, that gives you $11,200. I don't understand how you can't support your family off of that. So you're asking for $440 an hour, your 70 is not good enough? Because I think $11,200 to support a family a month is good enough for me because we don't even get that. And nor do the system provide it to us. So you're going to tell me you'd rather give it to an 18B lawyer than put it in our community? I
think I want to know really quickly, right? Like when we're sitting here and we're hearing the stories of parents, and I do want to correct the record, I'm not an impacted parent, right? But these are families who have been deeply harmed by the systems that we've been talking about the entirety of today. And I think it's very important, right, when we recognize and see and hear people's stories of the ways in which they have been so deeply impacted by these systems, right? That these stories don't stay here, that the pain and the harm and the very real trauma that they are discussing and they are talking about that they've experienced does not end here and does not end in a conversation. That ends in tangible action, so that we can address some of the issues related to judicial indiscretion, related to resources in communities. And I know I want to name, right, we recognize that across the state, a lot of families are represented by 18B attorneys, and I think Davina is speaking very specifically to an experience with attorneys in New York City. And so we also want to uplift, right, having more holistic defense models, having more funding towards comprehensive legal teams for all parents so that they not only have advocates in the courtroom that are working with them tirelessly, but advocates who are also making sure to connect them with resources outside of the courtroom so that they can have all of the things that they need to thrive safely and have safe families and communities.
Another thing I wanted to address was that the second panel, which was, I think they was representing the ACS, they spoke very highly about this website that y'all designing for them, the OCS website. And I wanted to say, y'all spoke about translation, like transitioning. My thing is that even if you design that website, you still need somebody to verbally explain it because the language, the legal terminology is not understood by the parents. So I don't care how many parents you direct to that website, they're not going to understand it. So I think that that's a problem that we're having as well. Y'all are implementing things that we still don't understand. Another thing I wanted to speak about was one of you guys asked about the CLE. And if there was a CLE that provides doctors, lawyers, dentists with the training that provides them with the fundamentals of what cases to call and what cases they should not call and how to, differentiate what to do and what not to do. And ACS, the ones who sat up here on the panel, they couldn't give you an answer, but I can. JMAC for Family offers those CLE courses. She does them through Penn State. She offers them to doctors, lawyers, and they get credit for it. So that's another thing I wanted to bring up. To me, this whole day sounds like, and I don't want to be like nasty about it, but I felt like our kids are like slaves. I felt like we were slaves being auctioned. Everything was about $1, not helping us. And y'all talked about giving all this funding to 18B lawyers. Where's our kids? I think we must narrow the pathway. We must narrow the pathways that push people into the family court system. There are several bills that the state can pass this session to do this. First, we must pass the anti-harassment reporting bill to prevent people from using CPS as a way to harass, because the same people who report is the same people who sit in here like us. We also must pass the Family Miranda Act to ensure that all families are informed of their rights, because I was never informed of my rights. Even when it came to me having an advocate for my son's case, I wasn't informed that I can have an advocate until I physically passed out in the courtroom. Family Miranda to ensure families are informed of their rights, including the rights to an attorney at the start of the CPS investigation. The harm that the system has caused to my family cannot be undone. We can prevent it I want us to try to prevent it from it happening to more families. I don't want another child to end up raped in the system or neglected, and you guys just throw it to the side like it's nothing. I witnessed a judge tell me, I'm going to give you 3 years probation because a deal is a deal. That deal didn't help my son, it hurt my son. And now in 3 years, he comes back out to the street. Does he do that to another kid? I don't have nothing else to say.
Thank you. Thank you all. This is incredibly important for us to hear, and I agree with you. It's incumbent on us to hear these stories and to take action, and not to leave it in this hearing room, but to actually have concrete next steps. You provided us with a lot of information, personal experience, which is very powerful for us as lawmakers to take to our colleagues. We had many colleagues here asking questions, and of course court officials, including the chief judge. So please understand that you were heard loudly and clearly today. I know I speak for Senator Brisport and Senator Mayer when I say that. So from the bottom of my heart, thank you very much.
Yeah, thank you, and I'm so appreciative that for one of your patience to hold all that all day and still be able to share it with us, because what you've really revealed in this hearing is that those of us in government have immense power to help or to harm, and it's very clear the passion that you bring to this, that we have some good things we can do in next year's legislative session to bring more help to the people that need it. So I really appreciate y'all taking the time to share this all with us, and it was necessary. You were absolutely heard, and this will also help us too as we're pushing for beneficial legislation in the coming months.
Some of
Thank you.
Can I say one thing?
I think unfortunately, we're going to have to wrap up unless Senator Mayer wanted me.
I did just want to say how important it is, not only that you spoke up and you waited this long to hold this all and tell this all and cry with us as mothers and grandmothers, at least for myself. But that this is broadcast. This wasn't just in this room. This is recorded, this is viewed by not just senators, assembly members, the other part, the governor's office, the courts, the people you are talking about who made decisions that impacted your lives. So this doesn't end here today. This is an opportunity to make sure that your voices are heard and that we take steps, as Senator Brisport said. We have power, we have to exercise power and be as impactful as we can. So we hear you, and I just would add to those who weren't heard today, you can certainly submit written testimony to our panel, right, chairs?
We ask that you don't hear us, you enforce what we
Well,
say.
I hear you. We
Do something, just don't hear us.
No.
Because we're hurting parents that got kids who hurt too.
Understood. I understand you. When I say we as lawmakers, we have certain powers. Those are the powers we got to exercise. And we get it. We heard you on that. And we know what our power is.
Well, again, thank you very much. We are closing our session. Thank you to staff, Stephen Koch in particular, for helping us organize this, and Senator Brisport's team, Senator Hoylman Siegel's team, and Senate Conference Services for broadcasting this and for making it possible today. Thank you very much.
Thank you.
Next step is action.
Absolutely.